Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The sweet peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when sweet peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Right with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate. Take it to trial, where the truth gets loud and the laughs run wild. Sweet peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you write a line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet Pea's nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
What's up? What's up? What's up? Good morning. Happy Monday. Oh, I'm like, okay, y'all can blame my tardiness on gossip, rumor, innuendo. I was listening to her Kathy's video on our other case in Utah, and I'm like, okay, wait a minute. I'm almost at the end. I'm almost at the end. So if y'all haven't heard it, I'm gonna put the link in the chat. He is absolutely fun. Yeah. So I was listening to that, and you know, because I'm so over Kouri. Like, I'm so over this. I'm so glad we had closing statements. That's what I can tell you. I hope everybody had an awesome weekend. Welcome. We are at closing arguments. I didn't know. I'm glad. Good morning, Merelda. Hey, Christine. Good morning, Lynn. Hey, Pretty. Hey, Susie. Hey, Serena. Good morning, Lady SD. What's going on? Hey, Jason. Good morning, everyone. Good morning to you. Or afternoon. It might be afternoon some places. Who knows? So, did y'all answer the survey as y'all came in? I hope y'all did, because I want to know where we at with this before we even hear anything about this closing arguments. Oh, man. Let me see here. Okay, 90. Okay. Some people say the state didn't prove it. Some say the state didn't prove it. Dun, 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 dun. Okay. Y'all know I turn everything into a dang on song. Don't pay me no attention. Okay, so we got, I think she guilty. I think she's so guilty that it's sickening. But that's just me. Like, it's so guilty. Like, I'm trying to figure out why are we here? What are we here for? What is this about? So we will have some kind of TiVo time, maybe. It looked like they've been doing it for about maybe about 20 minutes. But that's fine. I don't mind having a little TiVo time because he doing just jury instructions right now. Good morning, Drunky. My eyes, are they gonna hypnotize you, Jason? Look into my eyes. Look into my eyes. Look, I'm gonna hypnotize you through the computer. Like, yes, I do. Even though I don't stand up as much as I should stand up, but I be trying to stand up. Oh, y'all got to see my shirt. Look. Wait a minute. I may have to lower it a little bit. Let me see. Can y'all see my shirt? Look. It says, I'm just here to establish an alibi. That's why I'm here, y'all. Nothing more, nothing less. See? If she was here, she would have an alibi. That's what my shirt says, at least. I don't know what that means. Maybe I got an alibi. I'm just here. Whatever is clever. Yeah, and I like you can, you know the controllers and pretty. I bought me one of the little step machines to go up under it. Girl, I got on that thing. I said, "Oh, I'm so out of shape. I can't do 5 minutes on it. I cannot do 5 minutes on the step machine. That's what I could tell you. I keep trying. I said I'm gonna build up my stamina. It's such a mess. I guess if I do a little bit of this each day, maybe I'll get to that point. But I was like, oh, so while we in the cases, I can be up here like. It ain't happen. Would you say, like, just keep going? That's what I said. I may not can't do a whole 5 minutes, but I'm gonna keep going, getting on there. And I guess 1 minute each day, one more each day. That's all I'm asking for. One more each day. One more each day. And maybe I'll be good. I can get up to a full 10 minutes. But shit, I was trying to do it during our little breaks last week when I first got them. Like I'm all sweaty and stuff. Like, what the fuck? Like, wow, really? I wouldn't even think that thing could do all of that, but it do. Okay. Well, I ain't gonna talk us to death. I know y'all want to get in this courtroom and see what these closing arguments gonna be like today. I will put up another poll in regards to our how long we think it's gonna take before we have a verdict. What I want to do? I was trying to see if I had something. Okay, guys, let's go ahead and get in here and see what we got going on today with our girl Kouri. I honestly think that the defense didn't call any witnesses or anything because I think they think with the last detective, they thought that they had made some solid points in regards to detective. You don't know how Eric Richins got the Fetty Wap. You don't know who administered the Fetty Wap. You cannot tell us how Eric Richins received it. I think because they asked those couple questions and the detective was like, well, no, I don't know. He didn't say Kouri did it. He said he didn't know. So there's that. So we shall see. But I think that's why they thought that they had a. I think that's part of the reason. And then I think because they think they discredit Carmen so much. And remember, when you think about things, nobody testified that they actually had hand-to-hand contact with Kouri with any of these rugs. So who knows how he got the Fetty Wap? Then they got, they didn't get the Red Devils in like they wanted to get in. And they was like acting like they had this expert. So I'm like, oh, they're going to have an expert. They're going to have somebody come testify. Nobody. I'm really surprised they did not have the brother come testify, because I just knew the brother would have to come testify to explain, hey, I don't know what y'all talking about with this walk the dog letter. Never received it. She couldn't walk this dog because I was already walked. She walked me a long time ago. So I don't know why y'all think that she had to write me a letter talking about walk the dog. That was for one of her books, but they didn't bring him on the stand. So let's get in here, see what we got today. Welcome, and let's get to it.
Okay.
Ain't nothing to it, but
counsel for the state are present. Counsel for the defendant are present, along with Ms. Richins. We're set this morning for a closing argument. Mr. Bloodworth, is the state ready to proceed?
Yes, Your Honor.
Ms. Lewis?
We are.
Okay. Anything before we invite the jury in? Mr. Bloodworth?
No, sir.
Ms. Lewis?
No, Your Honor.
All right. Okay. Cody, we're ready for the jury.
she got on her Martha Stewart shirt. All the damn flowers.
Oh, all right. Very good. Well, so it goes. While I have this moment, if one member from each of your respective teams would plan to meet with Brittany after closings are complete, just confirm that we have consensus regarding the exhibits that we're sending back into the jury room.
Yes, Your Honor. Can we address physical evidence as well? I don't think we're requesting to send any physical evidence back, but I'm not sure.
For example, the glassine bags of the gummies, etc.
Correct.
Okay. I wasn't planning to send those back, Ms. Lewis.
That's fine.
Okay. Very good.
Your Honor, is the court sending a computer back for the kind of audio video files? Got it.
We have a air gap computer that will not attach to the internet or connect to the internet, that they'll be able to use to view files off a thumb drive.
Right, Your Honor.
Have a seat, please. Ladies and gentlemen, welcome back. We will begin this morning with jury instructions. Then we'll take a restroom break, and then we'll proceed with closing arguments. You have a copy of the jury instructions on your chair. You're welcome to read along, but you're not required to. You'll be able to bring those back with you into the jury room to review during your deliberations. And we can fast forward to instruction number 13. The preceding pages before instruction 13 are just a written copy of the jury instructions the court gave prior to opening statements. Closing roadmap. Members of the jury, you now have all the evidence. 3 things remain to be done. First, I'll give you additional instructions that you will follow in deciding this case. Second, the lawyers will give their closing arguments. Prosecutor will go first, then the defense. Because the prosecution has the burden of proof, the prosecutor may give a rebuttal. Finally, you will go to the jury room to discuss and decide the case. You have 2 main duties as jurors. The first is to decide from the evidence what the facts are. Deciding what the facts are is your job, not mine. You are the exclusive judges of all questions of fact. The second duty is to take the law I give you in the instructions, apply it to the facts, and decide if the prosecution has proved the defendant guilty beyond a reasonable doubt. You are bound by your oath to follow the instructions that I give you, even if you personally disagree with them. This includes the instructions I gave you before trial, any instructions I may have given you during the trial, and these instructions. All the instructions are important, and you should consider them as a whole. The order in which the instructions are given does not mean that some instructions are more important than others. Whether any particular instruction applies may depend upon what you decide are the true facts of the case. If an instruction applies only to facts or circumstances that you find do not exist, you may disregard that instruction. Please perform your duties fairly. Do not let any bias, sympathy, or prejudice that you may feel toward one side or the other influence your decision in any way. You must also not let yourselves be influenced by public opinion. Regarding closing arguments, when the lawyers give their closing arguments, please keep in mind that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. During the trial, I've made certain rulings. I made those rulings based on the law and not because I favor one side or the other. However, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. As the judge, I am neutral. If I have said or done anything that makes you think I favor one side or the other, that was not my intention. Please do not interpret anything I've done as indicating that I have any particular view of the evidence or the decision you should reach. You must base your decision only on the evidence that you saw and heard here in court. Evidence includes what the witnesses said while they were testifying under oath and any exhibits admitted into evidence. Nothing else is evidence. The lawyer's statements and arguments are not evidence. Their objections are not evidence. My legal rulings and comments are not evidence. In reaching a verdict, consider all the evidence as I have defined it here and nothing else. You may also draw all reasonable inferences from that evidence. Regarding items not admitted into evidence, transcripts, police reports, or other written audio or visual materials may have been referenced during the trial but not admitted as exhibits. It's common during deliberations for jurors to ask to review these materials or to have transcripts of what witnesses said during trial. These materials, other than what may have been admitted as exhibits, may not be requested as part of your deliberations. Regarding witness credibility, in deciding this case, you'll need to decide how believable each witness was. Please use your judgment and common sense. Let me suggest a few things to think about as you weigh each witness's testimony. How good was the witness's opportunity to see, hear, or otherwise observe what the witness testified about? Does the witness have something to gain or lose from this case? Does the witness have any connection to the people involved in this case? Does the witness have any reason to lie or slant the testimony? Was the witness's testimony consistent over time? If not, is there a good reason for the inconsistency? If the witness was inconsistent, was it about something important or unimportant? How believable was the witness's testimony in light of other evidence presented at trial? How believable was the witness's testimony in light of human experience? Was there anything about the way the witness testified that made the testimony more or less believable? In deciding whether or not to believe a witness, you may also consider anything else you think is important. You do not have to believe everything that a witness said. You may believe part and disbelieve the rest. On the other hand, if you're convinced that a witness lied, you may disbelieve anything the witness said. In other words, you may believe all, part, or none of a witness's testimony. You may believe many witnesses against one, or one witness against many. In deciding whether a witness testified truthfully, please remember that no one's memory is perfect. Anyone can make an honest mistake. Honest people may remember the same event differently. Evidence has been presented that a witness was previously convicted of a crime. This evidence was brought to your attention only to help you evaluate the credibility of that witness. Do not use it for any other purpose. It is not evidence of anything else. An informant is someone who provides evidence against someone else for a personal reason or advantage. The testimony of an informant alone, if believed by the jury, may be of sufficient weight to sustain a verdict of guilt, even though not corroborated or supported by other evidence. You must examine and weigh an informant's testimony with greater care than the testimony of an ordinary witness. You must determine whether the informant's testimony has been affected by self-interest, by an agreement they have with the government, by their own interest in the outcome of the case, or by prejudice against the defendant. You should not convict a defendant based on the unsupported testimony of an informant unless you believe the unsupported testimony beyond a reasonable doubt. A person may testify under a grant of immunity, that is, an agreement with the government. Their testimony alone, if believed by the jury, may be of sufficient weight to sustain a verdict of guilt, even though it's not corroborated or supported by other evidence. You should consider testimony given under a grant of immunity with greater care and caution than the testimony of an ordinary witness. You should consider whether testimony under a grant of immunity has been affected by the witness's own interest, the government's agreement, the witness's interest in the outcome of the case, or by prejudice against the defendant. On the other hand, you should also consider that an immunized witness can be prosecuted for perjury for making a false statement. After considering these things, you may give testimony given under a grant of immunity such weight as you feel it deserves. You should not convict a defendant based on the unsupported testimony of an immunized witness unless you believe the unsupported testimony beyond a reasonable doubt. Remember, the fact that the defendant is charged with a crime is not evidence of guilt. The law presumes that the defendant is not guilty of the crime charged. This presumption persists unless the prosecution's evidence convinces you beyond a reasonable doubt that the defendant is guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If the evidence leaves you firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. On the other hand, if there is a real possibility that she is not guilty, you must give the defendant the benefit of the doubt and return a verdict of not guilty. The defendant has entered a plea of not guilty and denies committing the alleged crimes. Every crime has component parts called elements. The prosecution must prove each element beyond a reasonable doubt. Until then, you must presume the defendant is not guilty. The defendant does not have to prove anything. She does not have to testify, call witnesses, or present evidence. Regarding direct and circumstantial evidence, facts may be proved by direct or circumstantial evidence. The law does not treat one type of evidence as better than the other. Direct evidence can prove a fact by itself. It usually comes from a witness who perceived firsthand the fact in question. For example, if a witness testified that he looked outside, saw it was raining, that would be direct evidence that it had rained. Circumstantial evidence is indirect evidence. It usually comes from a witness who perceived a set of related events, but not the fact in question. However, based on that testimony, someone could conclude that the fact in question had occurred. For example, if a witness testified that she looked outside and saw that the ground was wet and people were closing their umbrellas, that would be circumstantial evidence that it had rained. Before you can find the defendant guilty of any charge, there must be enough evidence, direct, circumstantial, or some of both, to convince you of the defendant's guilt beyond a reasonable doubt. It is up to you to decide. You have heard evidence that before or after the alleged acts charged in this case, the defendant may have done the following: made false statements connected to the financial affairs of her business, engaged in an extramarital affair, or made false claims about whether she was the sole author of a book. This evidence was not admitted to prove a character trait of the defendant or to show that she acted in a manner consistent with that trait. You may consider this evidence, if at all, for the limited purposes of determining motive, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Keep in mind that the defendant is on trial for the crimes charged in this case, and for those crimes only. You may not convict the defendant simply because you believe she may have committed some other acts at another time. Regarding fact versus expert witnesses, there are two types of witnesses: fact witnesses and expert witnesses. Usually, a fact witness can testify only about facts that he or she can see, hear, touch, taste, or smell. An expert witness has scientific, technical, or other special knowledge that allows the witness to give an opinion. An expert's knowledge can come from training, education, experience, or skill. Experts can testify about facts, and they can give their opinions in their area of expertise. You may have to weigh one expert's opinion against another's. In weighing the opinions of experts, you may look at their qualifications, the reasoning process the experts used, and the overall credibility of their testimony. You may also look at things like bias, consistency, and reputation. Please use your common sense in evaluating all witnesses, including expert witnesses. You do not have to accept an expert's opinion. You may accept it all, reject it all, or accept part and reject part. Give it whatever weight you think it deserves. You have heard the testimony of law enforcement officers. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is up to you to give any witness's testimony whatever weight you think it deserves. Regarding the defendant not testifying, a person accused of a crime may choose whether or not to testify. In this case, the defendant chose not to testify. Do not hold that choice against the defendant. Do not try to guess why the defendant chose not to testify. Do not consider it in your deliberations. Decide the case only on the basis of the evidence. The defendant does not have to prove that she is not guilty. The prosecution must prove the defendant's guilt beyond a reasonable doubt. Regarding conduct and mental state, a person cannot be found guilty of a criminal offense unless that person's conduct is prohibited by law and, at the time the conduct occurred, the defendant demonstrated a particular mental state specified by law. Conduct can mean both an act or the failure to act when the law requires a person to act. An act is a voluntary movement of the body, and it can include speech. As to the mental state requirement, the prosecution must prove that at the time the defendant acted, she did so with a particular mental state. For each offense, the law defines what kind of mental state the defendant had to have, if any. For some crimes, the defendant must have acted intentionally or knowingly. For other crimes, it's enough that the defendant acted recklessly or with criminal negligence or with some other specified mental state. Later, I'll instruct you on the specific conduct and mental state that the prosecution must prove before the defendant can be found guilty of the crimes charged. The law requires that the prosecutor prove beyond a reasonable doubt that the defendant acted with a particular mental state. Ordinarily, there is no way that a defendant's mental state can be proved directly because no one can tell what another person is thinking. A defendant's mental state can be proved indirectly from the surrounding facts and circumstances. This includes things like what the defendant said, what the defendant did, and any other evidence that shows what was in the defendant's mind. Some definitions. On or about includes any day that is near the day alleged in the information. For pecuniary gain means for the acquisition of money or something of monetary value. Attempt means the actor engages in conduct that constitutes a substantial step toward the commission of the crime and intends to commit the crime, or when causing a particular result is an element of the crime, acts with an awareness that her conduct is reasonably certain to cause the result. Conduct constitutes a substantial step toward the commission of the crime when it strongly corroborates the actor's required mental state to commit the crime. Utter means any intentional act that puts a writing into circulation and implies, by word or action, that the writing is genuine. Unless these instructions give a definition, you should give all words their usual and ordinary meanings. Elements of count 1, criminal homicide, aggravated murder. Kouri Richins is charged in count 1 with committing aggravated murder between on or about March 3rd and March 4th, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements. Kouri Richins intentionally or knowingly caused the death of Eric Richins under one or more of the following circumstances: for pecuniary gain or by means of the administration of any substance administered in a lethal amount, dosage, or quantity. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 3 beyond a reasonable doubt. You must also unanimously agree which circumstance or circumstances the prosecution has proven. You will mark your decisions on the verdict form. Elements of count 2, attempted criminal homicide, attempted aggravated murder. Kouri Richins is charged in count 2 with committing attempted aggravated murder on or about February 14, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements. Kouri Richins attempted to intentionally or knowingly cause the death of Eric Richins under one or more of the following circumstances: for pecuniary gain or by means of the administration of any substance administered in a lethal amount, dosage, or quantity. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. To find the defendant guilty of attempted aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt. You must also unanimously agree which circumstance or circumstances the prosecution has proven. You will mark your decisions on the verdict form. Definitions of mental state related to counts 1 and 2. For the purposes of counts 1 and 2, a person acts intentionally or with intent when her conscious objective is to cause a certain result. A person acts knowingly or with knowledge when the person is aware that her conduct is reasonably certain to cause a particular result. Elements of count 3, insurance fraud. Kouri Richins is charged in count 3 with committing insurance fraud between on or about January 29 and August 31 of 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with intent to deceive or defraud, intentionally, knowingly, or recklessly devised a scheme or artifice to obtain anything of value by means of false or fraudulent pretenses, representations, promises, or material omissions, and the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Elements of count 4, insurance fraud. Kouri Richins is charged in count 4 with committing insurance fraud on or about June 14, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with intent to deceive or defraud, presented or caused to be presented any oral or written statement or representation as part of or in support of a claim for payment or other benefit pursuant to an insurance policy, certificate, or contract. Knowing that the statement or representation contained false, incomplete, or fraudulent information concerning any fact or thing material to the claim, and the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Elements of count 5, forgery. Kouri Richins is charged in count 5 with committing forgery on or about January 29, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with purpose to defraud anyone without the authority to do so, did make, execute, or utter a writing so that the writing or the making, execution, or utterance purports to be the act of another person. After you carefully consider all the evidence in this case, if you're convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Definitions of mental state for counts 3, 4, and 5. For purposes of counts 3, 4, and 5, a person acts intentionally or with intent when her conscious objective is to engage in certain conduct. A person acts knowingly or with knowledge when the person is aware of the nature of her conduct, or is aware of the particular circumstances surrounding her conduct, or is aware that her conduct is reasonably certain to cause a particular result. A person acts recklessly when she is aware of a substantial and unjustifiable risk that certain circumstances exist relating to her conduct, but she consciously disregards the risk and acts anyway, or her conduct will cause a particular result, but she consciously disregards the risk and acts anyway. The nature and extent of the risk must be of such a magnitude that disregarding it is a gross deviation from what an ordinary person would do in that situation. Conduct means either an act or an omission. Separate consideration of multiple crimes. The defendant has been charged with more than one crime. It is your duty to consider each charge separately. For each crime charged, consider all the evidence related to that charge. Decide whether the prosecution has presented proof beyond a reasonable doubt that the defendant is guilty of that particular crime. Your verdict on one charge does not determine your verdict on any other charge. Regarding jury unanimity. Because this is a criminal case, every single juror must agree with the verdict before the defendant can be found guilty or not guilty. That is, you must be unanimous in your verdict for each count charged. To help you in reaching unanimous agreement, I recommend that you not commit yourselves to a particular verdict before discussing all the evidence. In addition, you may not use methods of chance, such as drawing straws or flipping a coin. Rather, in the jury room, please consider the evidence and speak your minds with each other. Listen carefully and respectfully to each other's views and keep an open mind about what others have to say. If there is a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own. A unanimous verdict must reflect the individual, careful, and conscientious judgment of each juror as to whether the defendant is guilty or not guilty. In making your decision, do not consider what punishment could result from a verdict of guilty. Your duty is to decide if the defendant is guilty beyond a reasonable doubt. Punishment is not relevant to whether the defendant is guilty or not guilty. Let's pause there for now. That went a little quicker than I anticipated. Mr. Bloodworth, would you like to proceed?
Yes, Your Honor, we may proceed and then maybe take an intermission.
Understood.
We lost.
No problem. We sure did. Mr. Bloodworth, would you like me to publish the slide deck now?
Yes, Your Honor, please.
There you are. Please proceed.
Thank you. Kouri Richins feels aggrieved and is thus an intensely ambitious person. She feels aggrieved because growing up, her father was an alcoholic who traded parenting for prison, and her mother a gambler who traded parenting for a casino. Kouri Richins thus worked for her aunt, cleaning the homes of rich people in Park City. She was not beneath those homeowners, but she felt that she was. This fueled in her an intense desire to appear privileged, affluent, and successful. She met Eric Richins. He was a successful business owner. He had money. They had a son, married, and had 2 more sons. Kouri Richins was on her way. But she was unhappy. She wanted to leave Eric Richins, but did not want to leave his money. Their prenuptial agreement meant that if she left him, she would also leave most of his money. So Kouri Richins took $250,000 in equity out of Eric Richins' home without him knowing it, so that she could start her own business and earn enough money to leave Eric Richins. Kouri Richins is intensely ambitious. First with Eric's money and then other people's money, Kouri Richins carefully curated the facade of a privileged, affluent, successful business owner. Behind the facade, however, Kouri Richins was incompetent. She took tremendous risks. She borrowed money by any means necessary at exorbitant rates. She gambled other people's money and lost. Her business was imploding. All the while, Kouri Richins was more interested in spending time with Josh Grossman than Eric. She dreamed of living in the Midway Mansion with Josh, running it as an event center, farming and raising kids, Eric's kids. But she did not have the money to leave Eric or the money to salvage her business. Kouri Richins is an intensely ambitious person. She is a risk taker. There was a way forward. Eric had to die. As Judge Mrazek just instructed, there are 5 counts. And each count has a series of elements. The state has to prove each count and each element of each count beyond a reasonable doubt. That is our burden. In this closing, we will go count by count, and then within each count, element by element, to show to you how the state has met its burden of proving aggravated murder, attempted aggravated murder, 2 counts of fraud, and forgery. That, again, is the reasonable doubt instruction that Judge Mrazek just read, and you will have back with you in the jury room. Judge Mrazek also read this instruction on what evidence is, and it's usually testimony and exhibits. To reiterate, what the attorneys say is not evidence. And as I asked you in opening, please focus on the evidence. Throughout this presentation, I generally use this format for slides. And so everybody understands where we are, the count, and then the element within the count is at the top in the red banner. We then quote some witness testimony and we cite it because it's the evidence that matters. So that you'll have the exhibits back with you when you deliberate. And you can reference them. Usually it's a transcript, page, line, number of the testimony. We also publish exhibits. And usually we'll have an exhibit number down here. If there's an exhibit, whatever, 2-5, so you can reference it. Let's begin with the aggravated murder count. The evidence will prove that Kouri Richins was the person who committed the aggravated murder. The evidence will prove that she intentionally or knowingly caused the death of Eric Richins, here by means of administering to him the illicit street drugs that she purchased from Carmen Lauber. She intended to kill him with the illicit street drugs. It doesn't matter what illicit street drugs. We'll get into it more. It doesn't matter if it was the propofol, if it was the fentanyl that actually killed him, if it was oxy or some other illicit street drugs. She bought illicit street drugs to kill Eric Richins. That's what matters. That's murder. These two elements are just murder, right? If we hide this, that's a murder charge. Here we have an aggravated murder charge, and the state will prove two separate and distinct aggravators. The first is for pecuniary gain. This is a why aggravator. Why did Kouri Richins kill Eric? For money. The second aggravator is a how aggravator. How did she do it? Here, by the administration of any substance, here it happens to be fentanyl, but it could be any substance administered in a lethal amount. Either one of those aggravators are what transforms this case from a murder case to an aggravated murder case. So, first element, was it Kouri Richins? Yes. The state has proved that Kouri Richins had the means, here the fentanyl, the illicit street drugs, the motive, here money, and a fresh start at life, and the opportunity to kill Eric Richins. She was the only other adult in the home at the time. Nobody else killed Eric Richins. Now, intentionally or knowingly caused the death of Eric Richins by administering the illicit street drugs. The state will prove with all kinds of evidence, testimony, exhibits, patterns of her behavior, and what each of us know about humans, that she intended to cause Eric's death. She intended it probably as early as December the 7th, 2021, when she booked a trip for her and Josh Grossman to the Caribbean for April. People don't book that trip. Kouri Richins did not book that trip thinking Eric Richins would be alive in April. She booked it knowing he would not. In December, before Eric died, before Kouri Richins murdered Eric, she told her friend, Becky Lloyd, in many ways, it would be better if he were dead. That proves she intended to cause his death. This was the New York Life policy that covered the C&E buy-sell agreement. And on January the 1st, 2022, Kouri Richins changed the life insurance beneficiary on Cody's policy from Eric to her. The evidence proves that Kouri Richins didn't understand that was Cody's policy. And when she figured it out, she went ahead and changed it back because she planned to murder Eric. She did not plan to murder Cody, but she planned to murder. Kouri Richins asked two people, Hayden Jeffs and Carmen Lauber, for the Michael Jackson drug. Kouri Richins was a suburban mother real estate agent. She does not know a lot about the illicit street drug world, but she knows Michael Jackson died from taking drugs. She doesn't know how to order a street drug, but she knows she wants the Michael Jackson stuff. She knows she wants it because it is lethal, it is fatal, it kills. And she wanted lethal, fatal death. Kouri Richins is intensely ambitious. She wanted the perfect life, or at least the appearance of the perfect life. And for her, that meant Josh Grossman. But first, Eric had to go away.
So with these transactions, when Carmen hit you up, what did she tell you?
She just told me that she had a friend that wanted,
Did she ask for blue specifically or fentanyl specifically, or did she ask for oxygen? What did she ask for?
I think she might have asked me for blue. I can't remember.
But you sold her M30s, right?
Yeah, I told her what she knew what she was buying.
Okay, so it wasn't like she's asking for oxys or something like that, and she got the M30s.
Right, no.
Okay, so she knew that there was fentanyl in those pills.
Absolutely.
At Kouri Richins' request, Carmen Lauber purchased illicit street drugs from Robert Crozier. It's those illicit street drugs that killed Eric Richins. It's those illicit street drugs that Kouri used to murder Eric Richins. And while there may be some question as to whether she specifically ordered fentanyl or she knew she was getting fentanyl, the evidence proves she at least knew it. She wanted fatal, lethal, illicit street drugs. And all the testimony from Carmen Lauber, Robert Crozier, digital forensics, we'll get into it, all confirm that Kouri Richins ordered and received illicit street drugs, and that those street drugs contained fentanyl. Illicit street drugs is all that matters. But you heard the testimony that despite confusion in what people were ordering, people were getting fentanyl. The fake M30s looked like the real, the fake M30s looked like the real M30s. Everything on the street in early 2022 had fentanyl. That's how we know that it was this purchase that ended up killing Eric. It's the fentanyl. We can trace the fentanyl. Next slide. The digital forensics corroborate Carmen Lauber's testimony that 5 days before Kouri Richins murdered Eric Richins, Carmen Lauber purchased for Kouri Richins fentanyl from Robert Crozier at the Maverick in Draper. The call detail records show an extraordinary amount of overlapping communication between Carmen Lauber, Kouri Richins, Carmen Lauber, Robert Crozier during that time. We, of course, don't have the communications. Carmen Lauber deleted them because they were evidence of a drug deal. Kouri Richins deleted them because they were evidence of a drug deal and a murder. Robert Crozier said he had lost his phone. But that's an extraordinary number of communications. We know that Kouri Richins, the evidence proves that Kouri Richins used a Moscow Mule and a shot to administer the fentanyl to Eric. She writes it in her orange notebook where she journals what happened the night she murdered Eric. It's a self-serving journal. We'll discuss that down the road. But she wrote Moscow Mule and a lemon drop shot. And that is consistent with all the toxicology. Again, in the notes that investigators recovered from the kitchen cabinet in Kouri Richins' home, she wrote Moscow Mules. Lemon water, vodka, and rum. She left out the main ingredient, which of course is the ginger beer. But there was ginger beer. We know that from the Cock and Bull that OME investigator Cam Sessions found in the trash can in the kitchen. It's interesting that Kouri Richins wrote vodka in parentheses rum. The evidence may show that the Moscow Mule she made that night was ginger beer and fentanyl. The lemon drop shot may be lemon and fentanyl. Notice that here she writes drink in bed. We'll come back to that in a minute. The Cock and Bull, as I mentioned, corroborates at least the Moscow Mule. And then we know the cause of death from the death certificate was fentanyl. The fentanyl and the illicit street drugs that Kouri Richins got from Carmen Lauber, who got from Robert Crozier. We know that Eric ingested the fentanyl from the Moscow Mule, the lemon drop shop, or both. Medical examiner Dr. Pamela Ulmer, toxicologist Brianna Peterson, chief medical examiner Dr. Eric Christensen, all testified that the 20,000 nanograms per milliliter of fentanyl, an extraordinary amount, in his stomach indicates oral ingestion. Indeed, Dr. Christensen not only testified to it, he told Kouri Richins that in their phone call that she recorded. Ms. Peterson's testimony, as well as Dr. Christensen, also proves that the fentanyl was illicit. Again, illicit coming from the street, illegal street drug, illicit fentanyl. And it was their testimony, right, was that there was not only fentanyl in the toxicology, but there was norfentanyl, which was a marker of an illicit fentanyl. There's also acetyl fentanyl as well. But it's the norfentanyl that is a marker of illicit fentanyl, which completely tracks with how Kouri Richins got the illicit street drugs. We also know that Kouri Richins intended to kill Eric Richins because the toxicology contained quetiapine.
Your Honor, we may have lost the audio.
Let's reset. My apologies.
Is an antipsychotic medication.
Last one, what is quetiapine? Quetiapine?
Quetiapine is an antipsychotic medication. It's called Seroquel.
Okay.
It's a prescription mental health medication that's prescribed for different things.
I gotcha.
The quetiapine in the toxicology for Eric Richins shows that Kouri Richins was involved because she was prescribed quetiapine. Now, this conversation that she recorded with Dr. Christensen is also very insightful. She pretends to not know what quetiapine is. It's her prescription. Of course she knows what it is. She pretends to not know what it is to cover up her involvement in putting the quetiapine inside Eric's body. She feigns the ignorance. She covers up her conduct in murdering Eric Richins in several ways throughout, beginning the night she murdered him, all the way through the walk the dog letter. In the orange notebook, she writes, she jumped out of bed, ran, turned on the lights, grabbed her phone, and called 911. The evidence proves that is not true. The evidence proves that when she returned to their bedroom, Kouri Richins says she was in Ashton's room. There's no evidence of that. But she returned from somewhere to their bedroom, unlocked her phone, put it on speaker. There's no call detail records showing a call at that time. But she may have called on Wi-Fi, somebody. That would not appear in the call detail records. It would appear on her phone if her phone had not been deleted.
Objection, Your Honor. These are facts that are
Overruled.
not.
Please have a seat.
She then unlocked her phone again at 3:08, 3:10, 3:15, 3:19, 3:19. And then 15 minutes later, she called 911. That is not immediately called 911. Perhaps she was staging the scene during these 15 minutes. We're going to discuss the 911 call in a minute. This is a receiver activation. At 3:22:12, when we're in the 911 call, she's on receiver on her phone. The 911 call operator asks her, "Are you on speakerphone?" She says yes. No. She's on receiver. Before we play this, sorry, we're going to listen to the first part, actually most of the 911 call again. I ask that as you listen to it, you'll hear the first minute. The first minute is not the sound of a wife becoming a widow. To echo her friend Chelsea Barney, the first minute is the sound of a wife becoming a Black widow. Listen to how Kouri Richins on the 911 call immediately presents, very soon after the call begins, presents her alibi narrative. Listen to how she tells the 911 dispatcher where she was when Eric died. She is distancing herself. Rather than, he's not breathing, he has no pulse, I have to figure out what to do, I need help. She's saying, hey, look, I was not there, I was in my son's room. That's her alibi. She's distancing herself from the time and the place that she murdered Eric. The 911 call operator asks her to perform CPR. Notice how she distances herself from that. No, I don't know how. No, he's too heavy. No, I can't move him. She is not immediately trying to revive him. We're going to run a clock from the time that the dispatcher asks her if she can start CPR to the time she purportedly starts it. It's 6 minutes. Listen, please, to the portion of the 911 call where the operator instructs Kouri Richins how to remove Eric from the bed. Listen how the dispatcher says, move to the side of the bed. Kouri Richins says she does. Remove the pillows, pull the arm, pull the leg, lift up the sheet, pull him off. If Kouri Richins is following the instructions of the 911 dispatcher, Eric Richins' body is on the floor on the side of the bed, not the foot of the bed where it was found. Listen also to her choice of language. She has dehumanized Eric Richins. When she is talking about removing Eric from the bed and she is protesting and she is saying she cannot, she is not saying, I can't move him. She is saying, I can't move it. Eric is no longer a him to him. She murdered Eric. Eric is an it. Finally, listen to when she says she is performing CPR and the phone is on speaker. The phone's not on speaker. Determine whether she's performing CPR. Okay, Scott.
I'm not breathing. He's cold.
Okay, what's the address?
282 Willow Court.
282 Willow Court. Okay, what's a good phone number in case we get disconnected?
435 671 4987.
Okay, it's gonna be in Francis. Okay, tell me exactly what happened.
I don't know. I was sleeping with my kids.
Okay, I can't understand you. I need you to take a deep breath. What's going on?
I don't know. I was sleeping in with my kids. I just came in the bed in our bed, and I turned over, and he's just cold. He's just cold.
Who's cold?
My husband, I turned the light off.
And he's not breathing? He's not breathing? I need you to confirm it for me. Is he not breathing?
No.
Okay, can you do CPR?
No, I don't know how.
You don't know, I'm gonna tell you how to. Are you willing to do CPR?
Yeah.
Okay. If there's a defibrillator available, send someone to get it now and tell me when you have it.
No, there's
You have one available? Okay. I'm sending the paramedics to help you now. Stay on the line and I'll tell you exactly what to do next, okay? Okay, are you right by your husband right now?
Yeah, he's so pale. His mouth is
Okay.
open.
Okay, listen carefully. Are you able to lay him on the floor or the ground? On the floor, on the ground?
I'm just thinking, I can't touch him. I can't.
You can do it. You can do it. You need to calm down,
He's
okay?
just yellow.
We need to help
Yellow
him.
and white.
I can guide you through CPR. Take a deep breath for me. I'm here with you.
He doesn't have a pulse.
He doesn't have a pulse.
No. There's no pulse.
Okay, I'm here with you. I'm here with you. We need to get him help. If you need to put me on speaker, put me on speaker. I'm gonna guide you through CPR, okay?
Okay.
Tell me when you've done that.
Okay, I'm ready.
You ready? Okay, he's on the floor.
He's on the bed.
Okay, are you able by any chance to move him on the floor?
There's spots on it. I don't know what's happening.
Okay. I'm here with you. You're not able to move him to the floor?
Go out. Don't come in here. Oh my God, my sister.
You're not able to move him to the floor? Just listen carefully. We just need to get him on the floor. Don't worry about hurting them.
No, he's just too heavy.
Is he still on the bed?
Yes.
Okay, if there's a sheet or a blanket under them, can you loosen it from the mattress?
Yes.
Okay, stand at the side of the bed closest to them and remove anything under the head.
Okay.
Okay? I need you to pull the sheets towards you and slide them off the bed. Don't worry about him falling. We just need to help him now.
Okay.
Tell me when he's on the floor.
I can't move it. It's just dead weight. Like it.
You're not. If he has sheets under, pull them to the floor. Don't worry about hurting him.
Yeah, can you please send somebody?
Okay, I have the ambulance that's on the way. Okay, there's another way to do this, okay? Grab their feet. Grab his feet. Slide them towards you until they're just off the bed. How old is your husband?
39.
39?
Yeah.
Okay. Okay, were you able to put his feet off the bed?
And pulling.
Okay, now grab the arm closest to you and pull the rest of the way off the bed. Again, don't worry about the fall. We just need to help them now. I have the ambulance on the way. I just need you to do this, okay, so we can get the help for him.
Okay.
Once they arrive, they'll take over. We just need to start CPR now. You are doing great, okay? I just need you to get him on the floor.
Okay, from the floor.
You got him on the floor?
Yeah.
Okay, listen carefully, okay? Make sure that there's nothing under his head. Is he laying flat on his back?
Yeah.
Okay, just listen carefully and I'll tell you how to do chest compressions, okay? Place the heel of your hand on the breastbone. This is in the center of the chest, right between the nipples.
Okay.
Put your other hand on top of that hand.
Okay.
Okay? Start pumping the chest hard and fast, at least twice per second and 2 inches deep.
Okay.
Okay, start counting out loud so I can count with you, okay? We're gonna count 1, 2, 3, 4, okay? Let me know when you're ready.
1,
1, 2, 3, 4. One, 2, 3, 4. Count out loud so I can hear you. I'm counting with you. 1, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1. If it's easier for you, am I on speaker?
yes.
Okay. 1, 2, 3, 4. Do you know if the front door is open?
No, it's locked.
I need you to go. Is there anybody else within the home or is it just you?
It's all my kids.
Okay. Are one of them old enough to go unlock the door?
Yeah, it's unlocked.
It's unlocked now?
Yeah, he's here. He's there.
Okay.
The protesting that was part of the 6-minute delay in Kouri Richins performing CPR. I can't move it. It is just dead weight. Contrast that 911 call with her self-serving text message to her best friend, Chelsea Barney. I tried so fucking hard to save him, his lifeless body on my bedroom floor. I pumped so damn hard, so hard, screaming at him to come back to life, that I needed him. None of that happened. She's covering up her involvement in murdering Eric Richins. Recall the alibi narrative at the beginning of the 911 call. Her letting the 911 operator and everyone know that she was not with Eric when he died. I was somewhere else. I was distant in place and time. When she calls her father-in-law, Eric's dad, Gene Richins, what does she say right at the outset? I was sleeping with Ashley and I came into the room. Gene, I wasn't there. Wasn't me. When Eric's sister Katie arrives, he wasn't breathing. I went to bed. I was in Ashton's room. He was having nightmares. I wasn't there. It was not me. Her alibi. Her cover-up. This is the written form that sheriff's deputies gave Kouri Richins early morning of March 4th to write out what happened. It says, describe in detail what you saw, know, or heard of the incident. Where does she start? Eric and I put the kids to bed around 9 p.m. We had a drink. In Kouri Richins' mind, that's when the incident started. It was the drink, and she knew it because she put the fentanyl in the drink. She didn't start with, I walked into the bedroom at 3 a.m. My husband was not breathing and cold. Describe the incident. The incident for her begins around 9:15 when she has the drink, because she knows that is in fact when the incident began. And then more of her self-serving alibi narrative. It wasn't me, I wasn't there, before she gets into really what matters. Intentionally or knowingly caused the death of Eric Richins. We know it was intentional because she planned the immediate reaction. When she spoke with Eric's sister, Katie, very shortly after medical examiners rolled Eric Richins' body out of his home for the last time, she told Katie that she was going to plan the Midway, she was going to follow through with the purchase of the Midway mansion. She was going to sell the home that she was living in. And she had a plan for running Eric's business, C&E. The morning of Eric's death. She had those plans in place because she knew she was going to murder Eric. She had already thought about not only murdering him, but what I'm doing immediately after murdering him. Her plan with the Midway mansion is consistent with her dream of living there with Josh Grossman, running it as an event center, farming and raising Eric's kids. Her plan to sell the home she lived in proves that she had no idea that home was in a trust. And she couldn't sell it. Her plan on running Eric Richins' half of C&E shows that she did not understand the buy-sell agreement, the life insurance coverage on the buy-sell agreement, or that that life insurance coverage went to the trust, not her. The morning Eric died, she had a plan on how she was spending Eric's money and didn't realize it was trust money. We know that Kouri Richins intended to kill Eric. The evidence proves that she intended to kill Eric, in part based on her conversation with Josh Grossman shortly after killing Eric. Kouri Richins asked Josh if he had ever killed anybody. Killed was her word. Not have you ever lost a loved one. How do you agree? Not have you ever walked in and found a dead body unexpectedly. Not how do you respond to a tragic and horrible accident. It is how you have you killed. And then she asked how it made him feel. She asked that because she was working through her own feelings on killing and wanted Josh to help her work through those feelings. And never mind that that's a highly selfish question. She's worried about working through her feelings on killing. Never mind Josh Grossman's feelings on having had to have killed in service of his country. It was her feelings that mattered. Walk the dog letter. There's a lot to unpack in this. But right now, let's unpack the fact that Kouri Richins says Eric gets pain pills and fentanyl from Mexico. She goes on to talk and says, Eric finally told me and asked if Carmen could get him some pain pills and fentanyl from Mexico. Some refers back to pain pills in Mexico from fentanyl. Sorry, pain pills and fentanyl from Mexico. Kouri Richins knows 4 months after she's been arrested for Eric Richins' murder, a year and a half after she murdered him, she knows that she bought fentanyl and she has to explain it. And how does she explain it? A year and a half after murdering Eric Richins, she blames it on Eric. Oh, I bought it for Eric. That's the sum of the evidence. Her self-serving statement asking her brother to testify falsely that she brought it from Eric, for Eric. Year and a half after she murdered. Kouri Richins did not tell the 911 dispatcher, hey, I just bought some fentanyl for Eric. She didn't tell the paramedics, he might be dying from the fentanyl I just bought for him. He didn't tell the deputies that responded. He didn't tell Detective Woody. He didn't tell Dr. Ulmer. Didn't tell Christensen. Didn't tell her friends. Didn't tell her family. All the off-ramps she had the opportunity to take to say, hey, I bought the fentanyl for Eric. She doesn't, because it did not happen. She did not concoct this story until a year and a half after she killed him. And it is a story. It's a fake story that she wants her brother to testify to. There are, of course, other inaccuracies. Kouri Richins in the Orange Notebook writes self-servingly, when the EMT walked up to me and said he didn't make it, we did all we could, I lost it, I immediately ran to the bathroom. This is the video of when the EMT walked up to her.
Basically, she said we went to bed at 9:30. She slept with the kids because then she goes to bed when she was in bed. So around 3 o'clock, moved in her bed.
We'll stop it there. We could play it for several more minutes. She doesn't immediately or otherwise run to the bathroom and throw up. When people make up stories, they are inconsistent in the retelling. Here in the orange notebook, Kouri Richins says they make the Moscow Mule and the lemon drop shot in the kitchen, and then they go to bed and brush their teeth. Here, they drink it in the bedroom, not the kitchen. Kouri Richins tells her attorney, it's on the right, she tells her attorney that Eric was on the phone when she went into Ashton's bedroom. But Eric Richins' phone activity tells a different story. Kouri Richins repeatedly said that she went into Ashton's bedroom 9:30, 9:45. Eric was off the phone before 9. In the orange notebook, Kouri Richins says that Eric was awake when she went into Ashton's room. And that rambling phone call with Bryce Knutson that Chelsea Barney recorded, she suggests that he was asleep because she says when she returned to the bedroom about 3 a.m., Eric was in the exact same position as he was when he fell asleep. That means she was there when he fell asleep, not in Ashton's room. Her story is inconsistent in the details. That proves that much of it is fake. We've read text messages throughout this presentation. We'll continue to publish some more for you to read. None of those text messages were recovered from Kouri Richins' phone. They were recovered from Eric's phone, Chelsea Barney's phone, Josh Grossman's phone, but not Kouri Richins' phone, because they were deleted. That is part of her cover-up. When comparing the contents of the phone with few to no text messages, with the contents of the call detail records, with thousands of text messages, that's how we know they were deleted. When Detective Woody executed the first of the search warrants on April the 13th, 2022, and she informed Kouri Richins that toxicology showed that Eric died of fentanyl poisoning, Detective Woody seized her phone. On her phone that she got to replace the seized phone, on the phone that Kouri Richins got to replace the seized phone, these are the searches. What was Kouri Richins worried about? She was worried about the police recovering all her deleted text messages. Why? They're inculpatory. They would further prove that Kouri Richins bought drugs from Carmen Lauber to then murder Eric Richins. Her phone searches reveal what she was thinking. She's worried about being investigated. She's worried about having to take a lie detector test. She's worried about my office. She's worried about her seized electronics. Prison is on her mind. So is money. She's interested in the life insurance. We don't know precisely when these searches were conducted. It's just not in the digital data. We have the data we have. But we do know that she hasn't been paid out yet on life insurance. And she started getting paid out in June of 2022. And this phone she got in April of 2022. So the inference is that these searches occurred between April and June of 2022. This one's the most insightful. If someone is poisoned, what does it go down on the death certificate as? She didn't search if someone accidentally ODs. She doesn't search if somebody is dead for unknown reasons. She searches if somebody is poisoned, because that is what happened. Now we have to prove that Kouri Richins intended to murder Eric Richins, which means we have to prove that Eric Richins did not commit suicide. Kouri herself says he didn't, no mental health concerns. But the other evidence proves it as well. Eric had every reason to live. The first three of which are Carter, Ashton, and Weston. He was a phenomenal father. He protected his boys. He put his money in trust mostly for the benefit of them, to protect them. He was a protector. He's not leaving his boys. He was also planning for the future. He was a successful business person, and he and Cody had future business plans. He had future plans with his sister. They were planning family vacation to Disneyland. He was planning on buying a cabin in the Uintas with his father for the family. Every shred of evidence in this case proves that Eric did not commit suicide. This wasn't an accidental overdose. Eric Richins did not use drugs. He did not use illicit drugs. Set aside THC gummies. Kouri Richins said no, never to Deputy Wynn and Paramedic Offred. These are people that it would have made sense to tell he used illicit drugs to in the moment as Paramedic Offred's trying to save Eric's life. But no, she was honest. Nope, never. Same thing with Dr. Ulmer as they're reviewing the toxicology and trying to explain the fentanyl, right? Dr. Ulmer's like, well, there's this fentanyl, really can't explain it. Did he do illicit drugs? No, never. Grossman, she's honest with anybody. She's honest with Grossman. No, Eric did not use drugs. Her best friend, another person she's honest with. Nope. Life insurance company? No. Chief medical examiner? No. And every bit of evidence that came into this case, everyone who testified and knew Eric well, his friends, his family, no, Eric didn't use illicit drugs, not even prescription drugs. Your Honor, this might be a good place to take a break.
Let's do it. Folks, one moment, just a friendly reminder. Don't talk about the case. Don't allow anybody to talk to you about it. Do not do anything with your devices during this break related to this case at all. We'll return at 10:20. Please rise for the jury.
So of course we have some TiVo time, so I will pull us past this.
Thank you.
I guess before I pull us past this, I do have one question. I put a 1 in the chat if you think he's doing great so far when we talk about Mr. Bloodworth laying this all out. Put a 2 if you think that he may be just losing people. So 1 if you think that he's doing good so far. 2 if you think he's losing the jury. I'm just interested to see what people are saying because I guess because he doesn't have any kind of like, I don't know, he kind of like, I know he got to get the information out, but his voice does not ever change to me. So it just seems so dry. I do love that they have the charts and stuff, but other than that, I'm like, okay, it just sounds, I want you to, I don't know, I guess I'll be looking for some excitement. I want you to raise your voice, slam the book on the table. I don't know. Something to get my attention. Lynn say he doing good. He not losing the jury just yet. Sensei too, he losing them. I mean, what is that called? Is it called monotone when your voice just like I want you to say, she wasn't even crying. I mean, of course we can hear it. Oh my gosh. And she sounds so, the more and more I listen to anything that Kouri does, it is so irritating. It's just like so irritating. Like, hey, my husband, I came in here, he was cold. Monotone, okay, yeah. But the only thing that I'm kind of getting out of it is that, you know, I love how they had the PowerPoints. I really like pictures. I am really like a visual person. And also a listener. Okay, Charmaine, we'll be here. And so that part I kind of get. But yeah, just listening to her it just irks me. Like for some reason, it kind of just pisses me off. Oh, I can't move him. Oh, the door is unlocked. I'm like, she wasn't even never, you know, when the operator asked her if she had him on speakerphone, she ain't never have it on speakerphone. She wasn't even doing nothing. Is the door unlocked? No. 5 seconds later, yes. Like no heavy breathing, no nothing. Like, how are you going to be giving somebody active pumps, you know, breathing for somebody or doing CPR on somebody and you not out of breath, you not excited, you just not nothing. Like her voice is monotone too. And she should be excited. But oh no, not her. Yeah, I want him to get exciting. Like I want him to say something. And my girl Lewis, she got up and she thought she was about to be objected, and he told her to have several seats. Sit down, ma'am. You know, and that's the hardest thing. Like, you know, and when we talk about opening statements and closing arguments for somebody to be getting up there and objecting, he told her just sit on down. I'm not even about to hear what you got to say about this. Just sit down. Have a whole bunch of seats, ma'am, and a good day. But let's go back in here. I just wanted to see what people's thoughts were.
about the two aggravators. The why aggravator, money motive, and the how aggravator, administering any substance.
Please have a seat. Mr. Bloodworth, you can make sure that mic is still on, and please proceed. Very good.
Thank you, Your Honor. Recall at the outset of closing when we were looking at the aggravated murder charge. I mentioned the first two elements are murder, and then we get into the two aggravators. So the closing up until now has been the murder charge. That is straight murder. But the state, of course, has charged aggravated murder. So now we'll talk about the two aggravators. The why aggravator, money motive, and the how aggravator, administering any substance in a lethal amount. You'll recall Brooke Carrington's testimony. And when she began her forensic accounting analysis, this drew her attention. The number of overdraft and non-sufficient funds transactions beginning in April. That jumped from 1 in September to 37 in October, beginning in October. That jumped from 1 in September to 37 in October to 77 in December. And Brooke Carrington's analysis was the beginning of the downward financial death spiral. Then Ms. Carrington analyzed the overall debt, and it showed a growing debt picture nearing $8 million in debt when Kouri Richins closed on the Midway Mansion. All the while, she's not paying it off. She's barely sending her creditors any money. And it's never an increasing amount of money, it's flat. The payday loans particularly showed distress to Ms. Carrington. This isn't a traditional mortgage. This isn't even hard money lending. This is, give me money today, I'll give you money when you get paid at an extraordinary, exorbitant interest rate. And when Brooke Carrington saw this, she sees the line here go flat. Payday lenders would no longer lend to Kouri Richins. She was barely paying them off, or barely paying towards them. Kouri Richins lost money flipping homes. You heard Brooke Carrington testify about the extraordinary growth and unsustainable level of growth for even sophisticated business people. Kouri Richins is not a sophisticated business person. She didn't even understand fundamental accounting, fundamental tax reporting. Brooke Carrington plotted out the profitability analysis of each of Kouri Richins' home flips. Kouri Richins, when she bought a home, when you total up the home she bought and the loans she took out, she started her projects $2 million in the hole. When she was finished her projects, of money that Brooke could trace to expenses, she could only trace about half of it to expenses because Kouri Richins did not conduct normal accounting. Kouri Richins lost $469,000 on her home flips. But recall that Brooke Harrington testifies there's this other pot out there of $400,000 that I know she lost. I just can't trace it to a particular project. When you add those up, it's nearly $900,000 loss in flipping homes alone. Recall that Brooke Harrington said that does not count the foreclosures. While deliberating, you'll have this, and on the second page, you'll see all the foreclosures. She lost millions more in foreclosures. To include foreclosures on Chelsea Barney's home and the Midway Mansion. Kouri Richins would borrow money by any means necessary. 6 times she submitted inaccurate bank statements to lenders to get money. Those bank statements reflected her business account and balances in C&E's business account. This evidence proves the level of financial desperation that Kouri Richins was in late 2021 and early 2022. The next level of financial desperation is taking $45,000 of your best friend's hard-earned cash tips from waitressing, telling her that you are going to apply that as a down payment to a mortgage on her house where she lives with her partner and her children. And then diverting part of it to pay off Fund 5 merchant, a payday lender. And spending the remainder of it, as Brooke Harrington testified, on expenses to rehabilitate homes and servicing existing debt. Then telling your friend, your best friend, since middle school, that you applied the money to the loan, here's the deed, sign the deed, and then not filing it. You will see, if you review that Brooke Harrington's schedule that had all the property transactions, you'll see that not only did Kouri Richins not file the deed, she took out another loan on the house. That's the loan that was foreclosed on, that resulted in Chelsea Barney, her partner, and their children getting evicted and losing their life savings. That is the next level of financial desperation that Kouri Richins was in January 2022. There's the tax liabilities. In the grand scheme of the amount of debt, 150 grand in tax liabilities is de minimis, but they were on her mind. There's an interesting little nugget here. She underreported her expenses in flipping homes to her tax accountant, which resulted in her paying more taxes than she would have. One would think a sophisticated business person would think to limit their tax liability. That's not what interested Kouri Richins. What interested her was the appearance success in business, the appearance of affluence. And by underreporting her expenses, it looks like she made more money than she did, and she appeared more successful than she was. Because she cared not about being successful, she cared about her facade. She cared about appearing successful. You'll recall that C&E distributed $36,000 to pay some of this $150,000 tax liability, which Kouri Richins then diverted to close on a home. And her tax liability was on her mind 2 days before murdering Eric Richins. She spent over an hour and a half on the phone with the IRS. It was on her mind because if the IRS moved on her tax liabilities, Eric would find out. She had to fix it with the IRS before Eric found out. You're familiar. Kouri Richins needed cash immediately when she murdered Eric. Eric's long-term earning potential, immaterial. She wanted to close on the Midway Mansion. She had no money to refurbish it, to flip it right away, to run it as an event center. But she was going to close on it. She needed money now. Doesn't matter if Eric's going to earn a ton of money down the road. That does not help her now with the Midway Mansion. It does not help her now with servicing her existing debt. She needs money now because she's closing on the Midway Mansion on March the 4th. And when she closes on the Midway Mansion, it's worth $2.9 million. She's borrowing $3.2 million. None of it's her money. She's reaching into other people's pockets to get that money. Not only does she want money to purchase the Midway Mansion, she wants $87,000 for herself. She takes out $87,000 at closing. And how does she spend it? Servicing existing debt and expenses for rehabs. She ultimately closed on the Midway Mansion the day after she murdered Eric. There's an interesting thought here. Did she close on the Midway Mansion in spite of murdering Eric? Or did she close on it because she murdered Eric? She hedged. She was supposed to close on the 4th. She didn't want to close until she knew Eric Richins was dead, because she knew she would have his money. She knew she could do something with the mansion. And that's why when everybody else signed on the 4th, or in advance of the 4th, she signed on the 5th. It's unconscionable that she closed in spite of his death. It's unconscionable that she closed because of his death. This is probably Kouri Richins' true plan for the Midway Mansion. And if Eric had not put most of his assets into trust, could have happened. Recall Brooke Harrington's testimony that after closing on the Midway Mansion, Kouri Richins' liabilities were right about $8 million, and she was in the hole $1.6 million. Her net worth was negative $1.6 million when she murdered Eric. That her business was in financial distress, her financial enterprise was collapsing, had been collapsing, and but for a significant infusion of cash and capital would continue to collapse. That significant infusion of cash and capital was supposed to be Eric Richins' money. You have a fortunate perspective during this case in that you get to observe the defendant. You get to observe Kouri Richins. And you observe her affect with some, when some witnesses testify, and you observe her affect change when other witnesses testify. You observed that when we played the 911 call during trial, her affect was flat, no emotion. You also observed that when Brooke Harrington testified about the financial distress of her business, she was exercised because that testimony pierced her facade. It pierced her facade of being a successful, privileged, and affluent person. It was a narcissistic injury. She was bothered because the world saw that she is indeed not a success and not affluent. The bulk of Eric Richins' estate was in insurance coverage. Some of it got paid out to the trust, some of it got paid out to Kouri Richins. Kouri Richins knew this, knew that much of his estate was insurance coverage. And different than taking money from Eric's home equity, different than taking money from Eric's bank account, to take Eric's insurance money, Eric has to die. Now for the aggravator of administration of any substance in a lethal amount. The substance here happened to have been fentanyl, could have been any part of the illicit street drug that she bought, happened to be fentanyl that she administered in a Moscow Mule and a shot or a shot. But we know that's how she administered it because it was in his belly. We know it was a lethal amount. The death certificate, fentanyl killed him. That's the substance, lethal amount. Can be as small as 3 nanograms per milliliter. And in this case, he had 15. 5 times what can be a lethal amount. That, by the way, is not an accident. That amount of fentanyl shows that Kouri Richins wanted Eric not only dead, but good and dead. Now, count 2, the aggravated murder. The elements are the same as count 1. The only difference is attempt. Attempt requires, as the court instructed, a substantial step. There's plenty of substantial steps from ordering the drugs to making the Moscow Mule Here, the aggravated murder count proves the attempted aggravated murder count and vice versa. The commonalities between Kouri Richins' conduct are not coincidental. In each instance, she purchased drugs from Carmen Lauber a few days out. In each instance, she spoke with the IRS a few days out. Taxes were on her mind. Eric would find out if the IRS was after them. In each case, she had an immediate financial stressor. We just discussed closing on the Midway Mansion. If you look at Brooke Carrington's materials, she had a note due on Chelsea Barney's house shortly before February the 14th. She had an immediate financial stressor in each instance. In each instance, she administered the substance in a way that Eric would ingest it. On Valentine's Day, it was a sandwich. When she murdered him, it was a drink. Notice that she learned from her mistake. One can season a sandwich with fentanyl. Eric can eat it, tell something's wrong, set the fentanyl-laced sandwich aside. You throw a lemon drop shot back. By the time Eric would notice, the shot was in. It was in his body. Moscow Mule, just to be good and sure. In each case, she leaves Eric alone. She distances herself from the dirty deed. She leaves the bedroom when she murders him. She leaves the county when she attempts to murder him. That's part of her alibi. Not only can she not be present, she has to be distant. So that when she calls 911, she says, I wasn't even there. I was in Utah County. And in each case, she has a delayed response, right? It's the delayed response in calling 911 when she murders him. And it's her delayed response in returning home when she failed to murder him. The element of, again, is it Kouri Richins? Yes. She is the person with the means, the motive, and the opportunity. Nobody else. The means, illicit street drugs in the sandwich. The motive, money, fresh start at life. The opportunity, she left the sandwich in Eric's truck. Intentionally or knowingly caused the death of Eric Richins, right? It's attempt, so attempted to cause the death of Eric Richins. The same reasons. She told Becky Lloyd it would be better if he were dead. She wanted the Michael Jackson stuff, the lethal stuff, the fatal stuff, the stuff that kills. She wanted Eric Richins' life insurance. You only get life insurance when Eric's dead. The commonalities persist. Kouri Richins ordered fentanyl from Carmen Lauber, or ordered something from Carmen Lauber, the Michael Jackson stuff, the fatal stuff. Carmen says, I told her I could get her fentanyl. She said, okay, get the fentanyl. But she ordered illicit street drugs from Carmen Lauber, who got them from Robert Crozier at the Maverick in Draper. Again, the volume of calls during the drug purchase between both Kouri Richins and Carmen Lauber and Robert Crozier and Carmen Lauber. And recall, we don't have the content of the texts because they were deleted from Kouri Richins' phone. deleted from Carmen Lauber's phone, and Crozier lost his phone. The IRS was on her mind. She called him twice, 3 days before attempting to murder Eric Richins. We know she placed the call to the Mirror Lake Diner to order a potentially fatal sandwich. We know that Kouri ordered it. Kouri picked it up in person. It was swiped. Don't know if you can tell that's Kouri Richins' signature, but notice it's one stroke. There's no pen lift. We'll talk more about that in a minute. Kouri Richins then distanced herself. She left the sandwich for Eric, and she drove an hour away to meet up with Josh Grossman on Valentine's Day. There's another commonality between the attempted murder and the murder, of course. They're big days. Losing your husband on Valentine's Day, that garners extra sympathy, extra attention. Losing your husband the same day you're supposed to close on the biggest purchase of your life, that garners extra attention. The type of attention that Kouri Richins relishes in. You heard Kouri Richins testify how Eric was a cowboy when it came to injury or illness. He worked through it all. He cowboyed up. Cowboys don't go to the hospital unless they're near death. They don't even think about going to the hospital unless they're near death. And at 11:33, Eric's thinking about going to the hospital. And then all the activity, the physical activity on his phone ceases for 87 minutes in the middle of a busy workday. Shortly after activity resumes in Eric's phone, he calls his best friend and business partner Kouri Wright. Recall Kouri said he could hear the fear in Eric's voice, a fear he'd only heard twice before, both times associated with death. A fear he heard when Eric told him his mother had passed away, and a fear he heard when someone who struck Eric's truck in an automobile accident, and Eric thought that person might have passed away. He then spoke with his hunting buddy and close friend, Josh Kays. You know and learn a lot about somebody when you hunt together and travel together. And Josh Kays said Eric sounded somber and serious. Josh asked Eric perhaps the two most pertinent questions. If he was going to the hospital, and what was he going to do about it? Let's turn to alley staking, singular, not plural. Clearly close with Kouri. Friends since middle school. You observed the banter when Ms. Staking was testifying, the banter between her and Kouri Richins. It was friendly. She's still friendly with her. And Allie Staking testified about how a week or two after Valentine's Day, when Kouri Richins attempted to murder Eric, When I questioned her, she said, well, Eric jokingly, kind of jokingly, maybe jokingly said that Kouri Richins tried to poison me. Perhaps joking. But Kouri Richins' reaction is what was important here. Kouri said no, she got defensive. That is not what happened. It was like an allergic reaction or something. It wasn't at all dramatic. She is covering up for poisoning him. Then when defense counsel questioned Ms. Staking kind of backed off the jokiness of Eric's comment and attributed the jokiness to everyone else. Ali Staking said, defense counsel questioned, what did he tell you? That he believed Kouri had tried to poison him. Maybe it was one of those joking things like, I'm sending a message to Kouri Richins. I know what you tried to do. I'm joking about it, but I'm going to let you know. Maybe he was serious. Either way, comes back to Kouri Richins trying to poison him on Valentine's Day. Kouri Richins repeatedly tries to cover up that she tried to murder Eric on Valentine's Day. She says she was home with him. She tells her best friend, Chelsea Barney, I was home with him. She was not. She was with Josh Grossman. She did not come home until after 6:30 p.m. She was saying he never broke out in hives or used an EpiPen. That means he broke out in hives and used an EpiPen. When she spoke with her mother on August the 22nd, when she says she didn't put a love note and the sandwich in the front seat of his truck, she put a love note and the sandwich in the front seat of his truck. She is trying to distance herself. She is trying to cover up. She is trying to deflect. When Eric said he was thinking about heading to the hospital, what did she say? Take a nap, call me when you're up. She's saying that thinking he will take a nap and not wake up. When he does, Eric texts Kouri. He's asking if she's home because he had just said, I'm going to hospital. Then he had stopped communicating, or he said, I'm thinking about going to the hospital, and then stopped communicating for nearly 2 hours. He's figuring she was coming home to assist him, but she wasn't. She's in Provo waiting for a cabinet installer guy. Maybe. She says then she's going to head home in 20 minutes. Nearly 2 hours later, question mark, where are you? You were heading home 20 minutes ago. She responds, what? Thanks for answering. Did you call? You didn't call. She thinks he's heading home. She's not. She's trying to figure out what to do. She's trying to figure out what to do because Eric survived. She had not planned on that. She is delaying to make her plan. And then at 6:34, Eric texts, we're headed in there. Food is on the front seat of his truck. The same place she left the poisoned sandwich with the love note. Eric Richins is telling her, I know what you did. That is the attempted aggravated murder. That's the attempted murder. Now, of course, we have the two aggravators. They're the same. Same as with the aggravated murder. The money motive, same. Similar financial distress, same. There's also the first start at life motive, right? That hasn't changed a bit. Josh Grossman, it's Josh Grossman on Valentine's Day, and he's Josh Grossman on March the 4th. Money motive the same, fresh start at life motive the same. Now the second aggravator, administration of any substance in a lethal amount. Recall Dr. Eric Christensen's testimony that hives, EpiPen, all consistent with an opiate-like or an opiate allergic-like response, a pseudo-allergic response. Hives, EpiPen, along with zero activity, shows that Kouri Richins attempted to administer the illicit street drugs that she bought 3 days earlier from Carmen Lauber in a lethal amount. She just failed. Next guy. Okay, the insurance fraud. There are two insurance frauds. Let me distinguish them, please, for you. The first one is a scheme charge, a fraud scheme. The second one is a fraud claim charge. Count 3, the scheme charge relates to the $100,000 true stage policy. We're going to put it up in a minute. The fraud claim charge relates to the $250,000 true stage policy. The forgery, which we will get to, is a forgery related to count 3, the scheme charge. Let me unpack them now. Okay. Different than the aggravated murder and attempted aggravated murder, I'll address all elements of the insurance fraud scheme kind of at once because they all jump out of this single page. And the scheme is quite simple. Kouri Richins wanted to murder Eric Richins, thus took out an insurance policy on his life to get money for murdering Eric Richins. Then she murdered Eric Richins, and then she submitted a claim to get the money. That is the scheme. And we know it was Kouri Richins because everything on this application for this $100,000 true stage insurance policy returns to Kouri Richins. Kouri Richins received the application because she was a member of PED-FED. The application was addressed to her at her work address, so she would have been the one to receive it. If there was any questions about it, any further follow-up mailings about it, they would go to her and not to Eric. This applicant information is all her, but the partner information is all her as well. Her work address, no email address where they could contact Eric. We'll get to the social security number in a minute. The primary phone, that's not Eric's phone. You'll see that Eric's phone is 801-792-9317. And when you look at this closely during deliberations, you'll see that was originally a 7 that she later marked up to read like an 8. She initially wrote his correct phone number, then did not want anyone from True States to call him, so she changed the 7 to an 8. So that Eric would never know that this policy existed. After Kouri Richins took $250,000 out of Eric's home equity, he put all of his insurance that he knew about into the trust. If Eric had filled this out, the beneficiary would have been the trust, not Kouri Richins. Then we'll get to the signature. That's the fraud count 5 as well. It plays into this. We'll talk to it during count 3. But it's also the freestanding charge in count 5. Let's go to the next page. The social security number was blacked out for privacy reasons on the application we just reviewed. But you'll recall Ann Coates testifying that the last 6 digits were transposed. We all know our own social security numbers. We often get a little bit confused on our spouses. Eric did not sign the application. Matt Throckmorton, the handwriting expert. Eric did not sign it. It was probably a simulated forgery. We'll call his testimony that Eric Richins has pen lifts in his signature. The forged one didn't have any pen lifts. You'll see Kouri Richins' signature throughout this case. No pen lifts. Then Kouri Richins filed a claim for this $100,000 True Stage policy. It's actually the same claim for both policies. And she said she really does not know where her husband, Eric, got the fentanyl from. Of course she knows. She ordered it from Carmen Lauber. That is the fraud scheme. Plan to kill Eric, fill out life insurance so I can get money for killing Eric, kill Eric, and then claim the money. Now for the insurance fraud claim count 4. This is the True Stage $250,000 policy. This is the claimant's statement filled out. Kouri Richins beneficiary, Kouri Richins email, Kouri Richins address. Everything about this claim says Kouri Richins is submitting this claim. And then, like before, the fraud here, the falseness of it is she says she doesn't know where the fentanyl came from, when in fact she ordered illicit street drugs from Carmen Lauber. And indeed, later in the Walk the Dog letter, admits to asking Carmen for fentanyl. Finally, count 5, the forgery charge. We've discussed most of the forgery when we discussed count 3. But there's this without the authority to do so element. It's not a forgery if Eric gave Kouri Richins permission. The state has to prove that Kouri Richins did not sign Eric's name with permission, with authority. All of the evidence in this case proves that Kouri Richins does not ask for permission, she takes. She took with the home equity loan. She took other people's money. She's a taker, not an asker. Finally, like I mentioned earlier, Eric Richins, the evidence proves, would have put the trust as the beneficiary, not Kouri Richins. If he had given permission, it would have been permission to make the trust the beneficiary. That's the forgery charge. Let's please now turn to Kouri's motive for a fresh start at life. You heard the instructions. The state does not have to prove any motive except for the pecuniary gain motive because it's an aggravator. But motive explains why Kouri murdered Eric Richins, why she attempted to murder him. Motive explains a lot here. These texts at this point are familiar. The day after Kouri Richins speaks with Becky Lloyd and tells Becky Lloyd Eric she would be better if Eric were dead, she texts Josh Grossman that she's in love with him, a man not her husband. If I was divorced right now and asked you to marry me, would you? That's the day after the attempted murder. If he could just go away and you could just be here, life would be so perfect. We're familiar with this text. We've read it already today. I ask you to read it again. This time, replace the word divorce with the word murder. This graphic shows a juxtaposition between Josh and Eric that is insightful to what Kouri thinks about each of them. In each instance, she is texting, well, she is kind of simultaneously texting. These are laid out chronologically. She is simultaneously texting with both Josh and Eric about closing on the Midway mansion. And she's so excited she is so excited texting with Josh. I can't believe it. I want to celebrate with you. Love you, love you, love you. Thank you for always being my support, shoulder, and rock. I need you all the time. Some things I could never do without your encouragement. You have no idea how much I appreciate you. Eric tries to reach out. You want a shot? Can't. Sorry, busy. Then right back to Josh Grossman. To me, you're worth millions a year. I'm honored to be your best friend, your lover, your go-to. Life is going to be different, I promise. You're one hell of a patient person. I hate your hard days. I wish I could be there to turn them around for you. Can I try Friday? Give me a few days. Hang in there until then, please. By Friday, of course, Eric Richins was dead. Kouri had murdered him. She's right, life's going to be different. She promised him. It was. Then, 16 days after Kouri Richins murdered Eric, are we there yet? And then 1 month later, Kouri's ready for Eric. Sorry, Kouri's ready for Josh to be her husband. Josh Grossman loved Kouri Richins. He believed that she loved him. Not sure that's true. You saw him testify. He was gutted. He's a grown-ass man gutted. You also observed Kouri Richins' affect when he testified. Flat. The evidence proves that Kouri Richins murdered, attempted to murder Eric Richins, and that she committed 2 counts of insurance fraud and forgery. The evidence does not support any other rational explanation. The state, since its opening statement, has stressed the requirement to consider the evidence that has been admitted and not what the attorneys say. What the attorneys say, insinuate, speculate is not evidence. Please let me show you why the state has stressed this. In the defense's opening statement, counsel said that the evidence will show that Kouri Richins had a 1/2 interest in the Willow Court home. There is no evidence of that, and indeed contrary evidence. Defense counsel said that the evidence would show that Eric was always checking Kouri's phone. There's no evidence of that. Defense counsel said that the evidence will show Eric and Kouri Richins went to marriage counseling. There's no evidence of that. Defense counsel said that the evidence will show in the few weeks before Eric died, his closest friend thought that he and Kouri Richins were the happiest together that the friend had ever seen. There's no evidence of that. Defense counsel said that the night Eric died, he and Kouri Richins had their drinks and set their cups in the sink. There's no evidence. Defense counsel said that the evidence will show that the cups were sitting in the sink and the nanny put them in the dishwasher the next morning and they still had fluid in them. There's no evidence of that. Defense counsel said that Eric talked to a friend named Scott Wagner at 10 p.m. the night he died. There's no evidence of that, and indeed contrary evidence. Defense counsel said that the evidence would show Eric unlocked Kouri Richins' phone at 10:30 p.m. the night he died, and this is the last thing that he did. There's no evidence of that. Defense counsel said that the evidence would show investigators interviewed Kouri over and over and over again about what happened the night that Eric died. There's no evidence of that. Defense counsel said that the evidence would show that law enforcement secretly recorded Kouri Richins' phone conversations for over a year after Eric died. There's no evidence of that, and indeed contrary evidence. Defense counsel said that you will hear Kouri Richins telling her family that she purchased pain pills for Eric at his request. You did not hear that, although she did write it in the walk the dog letter 4 months after she was arrested. In listening to defense counsel's closing argument, please only consider the evidence that has been admitted.
Ms. Lewis.
Your Honor, could we address something outside the presence of the jury before
Of
we
course.
start?
Folks, let's give you an opportunity to stretch your legs, use the restroom. Please rise for the jury. Have a seat.
Your Honor, at this point, we'd like to make a motion for mistrial and make a proffer on it. First of all, at multiple points in the prosecution's closing, he made efforts to dehumanize the defendant. In fact, calling her a black widow, comparing her to a deadly spider, calling her a narcissist when there's been no evidence introduced to support that, no expert testimony, nothing of the nature. Furthermore, it's completely improper for the prosecution to comment on her demeanor while she sat at counsel table. That's a comment on her failure to testify. Asking the jury to take into consideration facial expressions, which in his opinion may or may not have happened. I don't know what he's basing that on, but it's improper, and it's our suggestion that is a comment on her failure to testify by revealing what her response to testimony was, is calling upon her to testify in this case. Furthermore, in the closing, there was wild speculation on what was in Kouri Richins' mind, completely made up by Mr. Bloodworth with no evidence whatsoever to support it. Also, Mr. Bloodworth wrongly told the jury that giving any illicit street drugs to Mr. Richins was sufficient to support aggravated murder. That, in fact, is not true. The only drug that would support aggravated murder would be fentanyl. What he said to the contrary is not consistent with the court's instructions, and we would ask that that be corrected with a curative instruction. That they should follow the court's instructions on what it takes. It would not be sufficient if she bought some other type of drug that did not cause his death. That's just not the law. Let's see, just a moment. I think that's it, Your Honor.
Mr. Bloodworth. Forgive me. I need a little bit more detail as I go through these.
Yeah.
Which of these do you want a curative instruction regarding? In which of these are you moving for a mistrial on?
Moving for mistrial on all of it, Your Honor. The curative instruction, I think, is required by the wrongful information that giving him any illicit street drug is sufficient to support aggravated murder. That's just not true. And that's super important, because if they do believe that, there is evidence to make a finding that there was oxycodone. And there was no oxycodone found in his body. So that can't support a conviction. So that's what I think requires the curative instruction. The rest of it, I don't know any way you can cure it, Your Honor.
The Utah Court of Appeals disagrees with you regarding the prosecutor's comments. A long line of cases talk about the potential prejudicial effect of an improper comment by a prosecutor only being able to be measured after the defense gives its closing and the state gives its rebuttal, and we consider any curative instructions. what's your alternative position there? I could, for example, instruct the jury that Mr. Bloodworth's observations of Ms. Richins' demeanor are not evidence, and they are to rely on their observations of Ms. Richins, if any, only.
I just don't even think that her demeanor is proper to rely upon because she didn't
Certainly can
testify.
be. I mean, she burst out in laughter during the showing of the decedent's body. I don't think it would be appropriate for me to tell the jury you can't possibly consider that.
I'm sorry, but I have no idea what you're talking about. I totally trust you, but I have no recollection of any laughter when his body was
No,
shown.
it was a hypothetical, Ms. Nestor.
Oh,
to
thank
probe
goodness.
the bounds of your categorical statement that the jury can never consider the defendant's demeanor.
I'm sorry. I thought you were saying she did that, and I was just horrified.
Please stay focused.
But I am focused. I just misheard you. I mean, is what you're asking me is, do we want a curative instruction now? Do we want to wait until later? Is that what the court is asking?
Right.
Court's indulgence for just a moment. Okay, I think we do want it now, if we can get one now.
Let's hash that out for a second. What I proposed was an instruction that the jury may rely on their own observations, if any, of Ms. Richins' demeanor in trial, but they cannot rely on counsel's statements regarding what Ms. Richins' demeanor was. I want to be clear, there were no comments regarding her silence.
Well, I mean, it's our position that when you comment on how she looked while she remained silent at counsel table, that is a comment on her silence in our estimation. But I agree that he didn't say anything specifically about silence. That instruction would be preferable to no instruction, I think.
Okay. And then the Black Widow comment was connected to comments that were made by Chelsea Barney, correct?
I mean, they came out of his mouth in closing.
And he specifically referenced Chelsea Barney's testimony. Is it your position that Chelsea Barney never used that phrase or words?
I don't recall her saying that, but it's been a long trial and I would not want to make that I 1000% am sure, but I certainly don't recall that.
It was in the recorded phone call with Bryce Knutson.
And then everybody is speculating as to defendant's state of mind. It's one of the factual issues that the jury will have to determine according to circumstantial evidence, because as we instruct them, there's no direct evidence of what's in her mind. Why was anything that Mr. Bloodworth said regarding the inferences that can be drawn regarding her state of mind inappropriate?
Because they were made up out of whole cloth with no evidence to back it up.
You're going to have to be more specific.
So he went to great lengths to fantasize about what she was thinking about when there's been no evidence to that. He could have certainly said, look, she could have been thinking this, she could have been thinking that. He didn't. He gave them what was in her mind, which is just based on things he made up in his own head, not based on evidence.
Aren't they all based on his view of the evidence that came into trial? Was there any references to evidence that did not come in?
Well, first of all, calling her a narcissist, I mean, that didn't come in. There was no testimony that she's ever been diagnosed to have a narcissistic personality disorder. There's no evidence at all about her mental condition. And then when he talked about her putting the reasoning why she picked certain days to get more attention, nothing about that has ever come in to play, ever. I mean, that's just one of many. He went through lots of scenarios about what she was thinking as if it was a fact, and it wasn't. So, I mean, I think he can encourage the jury to use circumstantial evidence to try to reach their own conclusions, but he can't say this was in her mind when he doesn't know.
Okay. Anything else?
I think that's it, Your Honor.
Mr. Bloodworth, go ahead. Sir.
Your Honor, were there any particular points that defense counsel raised that remain unresolved in the court's mind?
Any objection to the proposed instruction regarding the jury must rely on their own observations, if any, of defendant's demeanor, but cannot consider counsel's statements regarding her demeanor?
No objection.
Okay. And then the statement regarding giving any kind of illicit street drug is sufficient to show the murder count. Talk to me about that. I did catch that comment. They're not making that one up. Now, there was more, and in the total course of the state's initial opening, I think you made it clear that you were encouraging the jury to make specific findings beyond a reasonable doubt regarding each required element.
Mm-hmm.
There was that initial comment, though. I don't think an instruction regarding having trouble crafting a curative instruction that doesn't just give a theory of the case. What's your view of this?
Your Honor, I don't think anything needs to be cured. The state does not have to prove that the defendant intended to murder Eric Richins with fentanyl.
True.
The state only needs to prove that the defendant intended to murder him with the illicit street drugs that she purchased from Carmen Lauber.
And that they contained fentanyl. Yeah.
Well, on the second element or the aggravator? Because there's a distinction there.
I think on both. She has to actually knowingly or intentionally cause the death for count one. So if she buys something that she thinks is OxyContin.
Correct.
And intends the giving of the OxyContin to kill him. And it turns out that what she got was blue M30s that had fentanyl and it killed him. The difference between aggravated murder and murder is irrelevant. She has committed an aggravated murder. What the distinction I think that I acknowledge is that she doesn't have to intend to kill him with fentanyl. She has to intend to kill him with poison. Even if she thought she was getting one and got the other.
Correct.
As long as it worked,
Correct.
She committed the crime.
Correct. I think that's what I said throughout.
I think that is the weight of the argument overall that you made.
If there's a particular sentence I said that is different than that, then I agree we should cure it. But I don't think I said anything different than that.
On this one, Ms. Nestor, I think the better course, rather than for the court to insert itself at this point, is to allow the rest of closing to play out, and we can readdress this issue at the end.
Okay.
I expect that this issue will get teased out in detail through Ms. Lewis's closing and the state's rebuttal. Give me a moment to collect my thoughts regarding the others. All right, thank you. Court will be in recess until, oh, I'm sorry, go ahead.
I'm sorry, Your Honor, can I just maybe say one thing?
Yes, please.
The state did not refer to the defendant as a narcissist. The state said that that was a narcissistic injury.
Right, I got it. Okay, I'll be back. 11:40, please. We'll be in recess. All right.
They say mistrial. You talk about the way she looked, what she looking like, what she acting like over there. Wow, how funny. It was like they over there taking notes on everything that they think that the prosecutor is doing wrong. So thank you so much, Drunky. Thank you so much, Susie, for the super chats. Truly, truly appreciate it. You know, I wouldn't want to be anywhere else but here watching it with you guys too. Like, this is crazy. Crazy. Like, they got to do everything they can to possibly derail this trial at this point in time, I guess. I don't know, like, when they ask for a mistrial, like,
Counsel, this is what I
one of these
propose.
cases, this is one of them cases that even if they ask for a mistrial and they get a mistrial, like, the state is going to come back and try her again. So do you think, I mean, like, I just don't see them giving it up, or is it just kind of like, we want the state to spend some more money, but they're going to come back and do it all over again. So I don't even understand why we get to these points. But yeah, like, okay. But her facial expressions, I'm telling you, like, all I can think about is the Rude Boys, boy, is written all over your face. You don't have to say a word. Good grief. Like, if she don't fix her damn face, like, when the judge was like, I was just like Nezra, even while he was like, stay focused. I was like, oh my gosh, she was laughing when they showed the decedent body. I was like, oh my gosh, we're gonna have to go back and find that part. He told Nestor, no, just stay focused. Okay, look, just stay focused. She's like, I am. Yeah, everybody getting a little irritated, a little on edge in this trial. I see at this point in time, Nestor said, look, I'm over here dealing with this Charlie Kirk situation I had to deal with Friday. I didn't get to go through the jury instructions. Now I'm back over here with this one today. She a hard-working lady, baby. I'll be here having all the cases mixed up. About Ms. Lewis, after Ms. Lewis arguments, yeah. Yeah, and I mean, I guess because she is, I mean, they shouldn't be making any inferences. The jury should see those things on their own. I do not think it's okay for the prosecution to be trying to say, hey, she hasn't said a word. She hasn't done this. Because that's like implying like she has to say something. She doesn't have to say anything. So I want them to be okay with that and not be putting that out into the air, you know, for the jury to be looking at, because that's making inferences, I guess, in regards to her having to testify. But she doesn't have to testify. She doesn't have to say not one thing. Y'all better prove it. That's all she know. Prove it. All right. Well, I'm going to take us back in here so we can go back and listen. Here we go, guys.
Let me give you a ruling regarding defendant's motion for mistrial. Then I'd propose I give the jury the curative instruction related to evidence of defendant's demeanor. Then I'd propose we take a lunch break, Ms. Lewis, so we're not interrupting your closing.
I agree with that.
Okay. Any objection, Mr. Bloodworth?
No objection, Your Honor.
All right. The issue before the court is a motion for mistrial and request for curative instruction in the alternative made by defendant on the record this morning. The motion for mistrial is based upon several comments made by Mr. Bloodworth in the state's initial opening that, in defendant's view, are so improper as to require a mistrial. The court will address defendant's arguments one at a time. First, the defendant argues that Mr. Bloodworth's reference to Chelsea Barney using the phrase Black Widow during a recorded telephone conversation that was played for the jury, though Chelsea Barney's comment was not admitted for its truth, improperly compares defendant to some kind of terrible insect. The court listened to the comment in real time during the state's opening. That is not a fair characterization. Rather, that was a rhetorical flourish by Mr. Bloodworth comparing comments by one witness or the defendant herself to her becoming a widow to Chelsea Barney, referring to her being referred to or considered as a black widow. It's not a reference to an insect. Rather, it's a reference to, in the court's view of Chelsea Barney's comment, a spouse that kills another spouse. There's nothing so improper or improper at all about that comparison, which has a factual foundation in Chelsea Barney's statements that were played for the jury as to support a request for mistrial or require any other relief. Moreover, the defendant requested mistrial based upon, in defendant's view, Mr. Bloodworth characterizing Ms. Richins as a narcissist. Defendant argues that that is unsupported and improper expert testimony from counsel that has no basis in the evidence. The actual phrase used by Mr. Bloodworth was narcissistic injury in relation to Ms. Richins' hearing from Brooke Carrington when she testified that in the state's view, defendants' appearances of wealth and success were not accurate. That is permissible line of advocacy during closing argument. It is not testifying in any way by Mr. Bloodworth. It is not otherwise prejudicial or unfairly prejudicial. With respect to Mr. Bloodworth's argument related to defendant's demeanor, the court determines that in an abundance of caution, it is appropriate to instruct the jury that they may consider their observations of defendant's demeanor in the courtroom, if any, but they may not consider counsel's statements regarding counsel's observations of defendant's demeanor, as counsel's statements and counsel's observations are not evidence. Moreover, the court notes that Mr. Bloodworth did not comment on Ms. Richins' silence or in other way otherwise implicate her protected right to choose not to testify. Mr. Bloodworth's statements regarding what the state believes it has proven regarding defendant's state of mind at various points in time is permissible advocacy based upon evidence in the record, and defendant's counsel will have ample opportunity to try to persuade the jury to draw different inferences from that same evidence regarding defendant's state of mind. There's no basis for a mistrial there. And regarding any misstatement by Mr. Bloodworth in his initial comments regarding count one that may have created confusion as to whether the state needed to show that regardless of her intent to purchase, secure, or otherwise administer fentanyl, all the state needs to show is that Kouri Richins intended to purchase, secure, and administer poison, and that it happened to contain fentanyl. That was, on the one hand, borne out in detail through the rest of the state's initial closing, and the court expects will be borne out in detail through defendant's closing and the state's rebuttal. The court determines that no curative instruction is necessary on that point at this time. Mr. Bloodworth, any clarification?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. All right. Are we ready for the jury, Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay. Can we bring the jury in, please?
Your Honor, I'm sorry to interrupt. My screen is still active, but I don't want anything to accidentally pop up during defense's closing. Thank you.
There you go. Bless you. Ms. Lewis is 12:45 agreeable.
That's fine.
Okay. Folks, this time just stay standing. This will be a quick turnaround. Okay, thank you for your patience. A quick instruction and then a scheduling note. First, a quick instruction. You may consider your observations of defendant's demeanor during trial, but you may not consider counsel's statements regarding counsel's observations of defendant's demeanor because counsel's statements are not evidence. We're going to break now for lunch so that we do not interrupt defendant's counsel's closing argument for the lunch break. We will take a recess until 12:45. During the break, as always, please do not discuss the case. Please do not allow anyone to discuss it with you. Please do not do any research whatsoever about the case. We'll be in recess until 12:45. Thank you. Anything further, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis? We'll be in recess until 12:45. Thank you.
No, she is not crying. No crying today. She ain't never cried. She ain't never cried. That's what I can tell you. You know, I think that last instruction that he gave to the jury, that just made that stand out more to me. And if they were not watching Kouri's demeanor, I think that they will be watching this, all those facial expressions and stuff. I hope her attorneys are letting her know that it's probably going to really stick out like a sore thumb, especially if the jury can see exactly what she's, her facial expressions, because it kind of like, it stands out to me. And now it's going to really stand out to the jury. Like, well, what do they mean? What did the prosecution team say about her demeanor? What, you know, like, yeah. So I think that's gonna make it stand out more. I don't know if sometimes if you even want them instructions because it kind of like sticks out. So we know that 5 counts are going to the jury. We have 1 aggravated redrum, you know, that she intentionally unalived her husband, Kouri Richins, by giving him that Fetty Wap and a drink in March of 2022. We also have the attempted redrum us going back, saying that she allegedly previously tried to poison him. Then we have the third one, which is that insurance fraud that they talked about. They saying that she filed because she signed the form, that she filed it fraudulently. But like I said, I signed a lot of stuff. I mean, but I'm not Kouri because I'm not planning to unalive him, but I signed a lot of stuff and he don't know about it. That's what I will say. So I do think that, you know, I guess with the totality of the evidence that now that he's unalive and that they're looking at everything, but that insurance card that she's talking about that you get from a credit union, I'm pretty sure all of us have probably have seen one come in the mail and you just signed it and sent it back in. And that was for the $100,000 that she did receive. And then she has the other one for the insurance fraud count too, for the actual claim, because they're saying for the $250,000 life insurance policy, you know, Eric just forgot that was still going to Kouri, or he would have changed that and put it in the trust fund's name, the trust name, like he did everything else. Because remember, he had that one, the 250 out way prior. Okay, and then we just got the forgery in regards to, you know, her signing or something. So there we have that. So those are our charges that's coming back. I see some people saying Wednesday for the jury to come back. I know they told them to keep them all like separate counts. So I guess they can find her guilty of signing documents, right, for insurance related to Eric's death, but they can find her not guilty of the redrum. Okay, Susie. Oh, that's okay, Charmaine. Yeah, yeah, this trial right here, boy, oh boy. Um, so I don't know. I don't know how long they're gonna be out. I'm thinking probably if they get through everything, because it looked like closing arguments is gonna take the full day, from what I can tell. You say with the hush puppies? Oh, when she gave Eric some hush puppies? Yeah, I think the jury gonna come back fairly quick. I don't know if it's much that they need. I mean, especially if they're gonna convict. You say you don't know. I'll find out for you, Susie. I think I heard something about the hush puppies. You say you heard it here and there. Yeah, I did hear something about the hush puppies, but I think she kind of doomed herself. I definitely think that if Kouri wouldn't have wrote them letters, if Kouri would have not did the journaling, did all that extra stuff, that it kind of would have been word versus word for a lot of this stuff. But a lot of these things are in her own handwriting that people can actually see. Let me see. So let's just for instance, and I didn't know she was doing all that IRS stuff. I don't know what that's about. Let me get the letter up. She did too much self-snitching. And I don't know what they were talking about in regards to the book. I don't know what the book, I guess, are they saying they claiming fraud because she didn't write the book and she had a ghostwriter? Is that what that was all about? I didn't get, I don't know. I see why you brought it up, but do they consider that fraud? Because a person doesn't write the book and somebody else does? Yeah, I never knew that. Let me see. I want to get I'm gonna get our trial prep up so we can look at the because I think that I was with her into this letter. Oh, we did that live. I'm like, I know we went over the walk the dog letter and that stuff, and I couldn't remember how we did it. We did it live. Let me get it up here. Where we decided that we wanted to walk the dog. Okay, that's the motions. Those are the last motions that we went over. The goofy email. She's so goofy. Just while we on break. We got about 30 minutes for break. Just so y'all know. Move. Let me take this off the stage. Stop. And you ready for this? You ready for this, SD? What day you plan? What day is the party? What day you think we gonna hit it? I'm gonna be waking everybody up. Okay, so I will listen to these. I mean, this is how she messed up herself. Nobody else messed her up but her, for the most part. She did more damage than anybody could have did. You say you had a party on Saturday? I guess I do know who does this. Kouri does this. And so as I was going through this case, and I'm like, what the
Before we left.
Y'all let me know. Is it just me, or is this some weird stuff after your husband passes away? This is something that you do
On your list that you spoke to.
Redacted.
About the beginning of February last year, my kids had a soccer tournament in Mesquite. The day before we left, February 2nd, 2022, I tested positive for COVID. I have attached the picture of my test from on my counter in the kitchen from when I first found out. Photo 1. I had sent it to my mom and
Redacted.
to let them know because I
Thank you so much, I was like, when I looked at the thing at the top, thank you so much. Now, you know, if you received a membership from shout, you know what you need to do. Shout it out. You done changed your picture, your profile picture. I'm like, what is, I had to figure out, go in the chat and see. Thank you so much. I hope you feeling better. You say you've been watching on your TV. That's good. You have to let me know on Discord how your rehab and stuff going on Discord. Thank you so much. Yeah, this is the email that she sent to the police officer, you know, trying to make sure that he understood exactly what's going on. She needed to clarify some stuff with him. Clarify, Kouri. Here we go, guys. Thank you so much.
was just around both of them. Eric was the coach of the soccer team, and I'm the annoying mom on the sideline that never stops yelling. We didn't miss games or tournaments. We're a huge soccer family. When we found out I had COVID, I didn't want to miss the soccer tournament, nor did I want my kids to get sick. So I stayed at Casablanca. I didn't want to risk getting my boys ill during the tournament and then not play well. I brought a box of home tests with me to test every day so I could either join the boys staying at my father-in-law's or at least be with them during the game. Casablanca is about 5 minutes from the soccer field. Actually, there is a picture of the room number I stayed in. I had taken a picture for my mom and Eric. I would take pictures of my test to Eric to say, still positive. You can check Eric's phone for this. I stood on the sidelines wearing a mask and not interacting with anyone. Happy to get other soccer parents to attest to this. Eric had gotten COVID after we got home from Mesquite. You asked,
Redacted,
about any exotic vacations I have taken since Eric's passing. I went on 2 trips last year. One, my kids tried out at soccer camp in SLC to qualify to play in Spain in June, and both my kids made it. So yes, I took them to Spain in October 2022. I have attached their invitation letters. Also, Eric and I went to Mexico every year, sometimes twice. We traveled a lot. We have taken the boys to Mexico a few times. We like to go in January. However, January of 2022, we could not go because Eric had his hunting trip to Mexico trip of 2 weeks planned, and it was too much that month. This is not new for us to go to Mexico or for us to go out of the country or on a vacation with our kids. I took my kids and my mom came with us in August of 2022. As I hope you understand, the months prior to this, since Eric's death, have been hard to deal with. No, I have never been to Key West or the Keys in Florida. However, my nanny went with her family in June 2022, so maybe you have something mixed up. Eric's affair was the same year I moved out. The trust was created as well as him looking into a divorce. I never actually moved out. I moved my clothes out one weekend to make Eric understand I'm not kidding about leaving him if he doesn't end things with
redacted.
I did this on a Thursday or Friday while he was out of town. I was home Monday. I never stayed another night at that other house. Eric and I figured things out like most couples do.
Redacted.
Was her name. He changed her name in his phone so I wouldn't know about it. And honestly, we worked things out. And after that, I never went through his phone again to see if he changed it back. But you have his phone and can check. Eric and I went to
Redacted.
counseling in Camas, 801.
Redacted.
We only went about 4 times. Maybe it wasn't for us.
Redacted.
And
Redacted.
are the same person, as I'm assuming you know that. Ha ha ha. I'm also assuming
Redacted.
told Woody her husband got a call from him and gave him all this information. LOL. Yet he didn't ever go and talk to detectives. Ironic how these things work. Mental health. Yes, I got postpartum after my second child in 2014. Yes, I took medication for it. No, Eric and I did not have financial problems ever. Yes, Eric made more money than me. Do you make more money than your wives? Have I ever been financially reliant on Eric in the last 5 years? Absolutely not. Eric did not want me working because 1, his first wife cheated on him with a guy at work. 2,
Redacted.
3, Eric wanted us to live in the typical conservative life where the man takes care of his family and the wife is a homemaker. Wife, mom, and that's it. That is not my personality and not the way I was raised. I'm very independent. Even when I stayed home with my kids the first few years, I was in grad school for years because I wanted to be more and do more than be a homemaker. And when I did and started my business, it took some adjusting, but Eric and I were fine with it. We hired my nanny and everything worked out. My nanny,
Redacted.
801,
Redacted.
moved out because she was engaged and she and her fiance were moving in together. That was always supposed to be temporary. She's worked full-time for Eric and I for years prior to his death. If anyone can tell you about our marriage, it's her. She lived with us. Feel free to call her.
Redacted.
Has already submitted her phone records to you to prove that your toll is incorrect.
Redacted.
We'll also be submitting hers over to you guys today or tomorrow. I am working on getting mine. However, Eric's business partner is not being cooperative, but you can call
Redacted.
and ask for them, and he would probably give them to you. 801.
Redacted.
I know what time I went to bed that night. There was no hole in my story. Hopefully by obtaining 4 phone record documentation, you guys can see this too. Happy to clarify or provide anything else you may need. I just want this over. I just want our lives back and move on and grieve and mourn my husband without looking over my shoulder constantly for you guys or the idiotic private investigator or the Richins family. Whatever I can do to help close this out, just ask. I'll give you whatever you want to know. Please check with the lab on those gummies. P.S. Chad, I heard you also know our good friends.
Redacted.
Their son and my son play on the same soccer team. When Eric passed,
Redacted.
took over coaching. You guys should even chat with them if you feel necessary. Kouri Richins.
Thanks for the clarification, Kouri. I don't know that it matters either, but I appreciate the communication. Best, Chad.
So even when he came back, he responded to her. Yeah, even though when he came back and responded to her, he was like quick, short, and to the point. Like, I don't even know if any of this stuff matters, but whatever. Thank you for sharing. Like, you trying to tell me about what, in regards to what my situation is, and do my wife make more money than do I make more money than my wife? And you know, trying to compare my relationship with your relationship. Well, no. Pump your brakes. I'm like, nope. Not happening. So let's see. So we talked about that. And y'all know we had our little goofy book. And that's the sister's testimony. Let me get the walk the dog up here. Y'all know I always walking that dog, baby. Where the letter at? This all goofy. I thought I had it up here. Wait a minute. I probably was. Oh, the prosecution team got the first 3 pages in there. Y'all heard what the Oh, that's me talking. Only because my voice kind of like when I hear my voice, it kind of, I don't know. Like, yeah. Okay. Spare me on that one. But let me get the walk the dog letter up so we can. I'm going to tell y'all when I figured out she was guilty. Hold on. You'll listen to some tunes while I get it up here. I'm pretty sure I read it when we did our trial, our prep game, but I want to get this together. I want to pull it back up so we can look at it again. In the meantime, let's listen to some tunes. I know Film sent it to me before the walk the dog letter, the entire letter. I'm just trying to find the link that he sent it to me on so I can show you guys so we can go through it again. I tell you.
Yeah, lights on, shadow wake. What's the move tonight? Sweet pea in the room, yeah, you know the vibe, right? Quick, sharp mind cutting through the noise. Got the whole room laughing when she drops her voice. Eyes on the screen and she reads the whole room. From drugs to facts, she's ahead of the boom. Not just talk, yeah, she bringing receipts. When Sweet Pea speaks, everybody hits repeat. She don't just show up, she sets the tone. One laugh from her in the chat's blown. Smart, funny feelings, yeah, that's the code. Main character energy fully in mode. Sweet pea, say it louder when she enters the scene. Sweet pea, got the jokes, got the facts, got the mean. When she talks, everybody leans in. Sweet pea, yeah, you know she always wins. One line of queen, yeah, she never miss. Turn a quiet room into a viral clip. Brains and humor in a perfect blend. When Sweet Pea starts talking, that's the trend. Say it again, who runs the chat? Sweet Pea, yeah, that's that. Sweet pea, yeah, you know she always wins. Late night glow from 1,000 screens. Everybody watching, nobody seeing the same thing. One line drops, tension in the air. Half truth, half theory. Somebody already there. We don't just scroll, we decode. Read between what they said and what they showed. Quiet minds with loud ideas. You feel it shift when the chat appears. Not here for drama, not here for the show. We're here for the patterns that nobody else knows. We're the signal in the noise. Low voices, sharp choices. Every thought hits like a flare in the dark. We're the signal in the noise. No scripts, just voices. When the chat moves, yeah, it leaves a mark. what they tried to hide in the gaps. No spotlight, but the room feels tight. Truth doesn't shout, it arrives quiet. Different minds, same frequency, not followers, we're a community. They think it's random, they think it's luck, but patterns don't lie when you look long enough. Say it's soft, say it's slow. Who really runs the flow? Not the screen, not the host, it's the chat. Yeah, you know, you know.
Okay. Okay, so this the one I got is redacted, so cool. Thank you so much, fam. I'm like, I know he sent it to me. I couldn't figure out where it was at for nothing to save my life. Okay, so this, when I seen this letter, this is when I made her guilty. And you'll notice that the letter just came in fairly recent. So let's see what the walk the dog is talking about. I don't think they brought all the pages in here, but we'll go through them.
It's after dark, where the filters fall, where we talk about the things you don't say at all. Sweet peas in a chair saying, tell it how it is. We unpack real life, not just courtroom biz. It's opinions, confessions, messy and true. Real talk, real laughs, and a grown-up view. Not gossip, not drama, it's truth with style. You can plead the fifth, but we'll still see you smile. We don't tiptoe around the hard conversation. Oh, oh, oh. We break it down with truth and speculation. Hey, therapy, law, comedy, insight. That's what trial talk sounds like at night. Take it to trial after dark, where the real ones speak and the truth hits hard. No scripts, no filters, no playing polite. We say what we think after day turns to night. Turn up the talk, let opinions ignite. Take it to trial. Dark tonight. Film freaks got receipts in the hidden scenes. TYK breaks it down like a therapy machine. Rachel keeps the facts sharp, logical, tight. Pretty brown girls got the clapbacks on sight. Fowler keeps the peace, well she tries at least. Morelia drops gems when the topics get deep. And Jason walks in with that wise guy grin, and the chat yells, here comes the chaos again. Not late night drama, late night perspective. Big brain debates that get introspective. It's real, it's bold, it's thought and fire, and it hits different when the lights get quieter. Take it to trial after dark, where the real ones speak and the truth hits hard. No scripts, no filters, no playing polite. We say what we think after day turns to night. Turn up the talk, let opinions ignite. Take it to trial after dark tonight. Oh, 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 oh.
Okay, let's walk this dog. The dog that walked that I was like, she guilty. Let me make sure I got the court stream back up so I can see when they get back in court. Okay, so this is what Kouri wrote while she was in her jail cell. You see it right here, say walk the dog. Says walk the dog, but take vague notes so you remember. So, and this is the letter that she was writing to her mom. No, her mom did not receive it, but she was trying to get it to her mom. They just caught it before then. And just so you know, her attorney, for whatever reason, after this walk the dog letter was kind of out there, her attorney withdrew for differences that they couldn't reconcile. So it says, Sky is saying, even if the gummies have Fetty Wap in them, wait a minute, I might need to blow this up. Fit with, let me see. Let me see. I'm trying to see if it's gonna let me see there. I can't even see. And the prosecutor will say, I tried to put the Fetty Wap in the gummies, so Eric would have them. Stupid, I know, but that's what she's thinking. We will still test them though. However, she wants to link Eric getting rugs and pills from Mexico. You see what that says? And still, she wants to link Eric getting rugs and pills from Mexico. So is she saying that Sky wants it? So we need some kind of connection. Gosh, Sky could have lost her license. I see why she withdrew from this case, because of stuff like this. Like, she basically saying, her lawyer is saying, hey, we need to make a connection, so you connect the dots for me. Her private investigator is doing some research on the ranch/cartel place where Eric would stay at. Here is what I'm thinking, but you have to talk to Ronnie. Ronnie is her brother. He would probably have to testify to this, but it's super short, nothing for him to worry about. Not a lot to it. He will need to tell Sky at the meeting next week, so she getting what Sky needs in order to create this falsification of a story. Is basically what she's doing. So her brother was supposed to be meeting with Sky the next week. Upon information and belief, just like they say, a year prior to Eric's death, Ronnie was over watching football on one Sunday, and Eric and Ronnie were chatting. I want to say chatting about Eric's Mexico trips. Eric told Ronnie he gets pain pills and Fetty Wap from Mexico, from the workers at the ranch. Not to tell me, because Kouri, would get mad, because I always said he just gets high every night and won't help with take care of the kids. There are pictures in my phone of Eric passed out on the floor or in a chair. Ronnie should have those texts from Eric talking about getting high as well. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck. Remember, she got to put the work truck, because they didn't never search the work truck. They actually came in, the owner, Cody, he actually came and got the work truck before any of that could happen. Okay? So that's why she used the work truck, because that was already gone. So they wouldn't find them. Ronnie never told me about the conversation. Eric finally told me and asked if Carmen can get him some. So this is putting Carmen in it. I don't think they read this part to the jury, y'all. So they had all this stuff redacted, because this is putting Carmen in it. Even though the jury didn't get to see this, when I saw this, I was like, oh, she guilty. She guilty. Like nobody's telling. Now she making sure Carmen, because she know Carmen gonna testify. By this time she knows. Guilty. So the jury didn't see that. Okay. So he asked if Carmen can get him some. Eric never wanted anyone to know he had an issue, especially get caught. He always wanted Kouri to go down for him. When they traveled, Eric would put his rugs in Kouri's bag at the airlines, I guess, right before they boarded. That way, if they were to get caught, Kouri got in trouble, not him. Once they got to wherever they were going, Eric would pull out the rugs out of her bag and it would cause a huge fight. Now, that's the one thing that the friend testified to, saying that was something that he did on one of their trips. I believe they were going to Hawaii, and that he did hide rugs in her bag. She was pissed. She was pissed that he would risk her going to jail for his rug use. He just wouldn't laugh about it. Eric couldn't ruin his image that he had rug issues. So he would do whatever he had to. Kouri has never done any type of pills, didn't like them. Rarely would she consume THC, only if Eric begged her, because it was a special occasion. Reword this however you need to do it to make the point. Just include it all. The connection has to be made with the Mexico and the rugs. Ronnie will have the messages to prove Eric confided in him about getting high. He can be short and to the point, but it has to be done upon information and belief. Laugh out loud. They never found the pain pills or Fetty Wap in my house because he had hid it in an allergy bottle in his work truck. And Cody emptied out the work truck within a week. So they were never found. She get on my nerves. That's all I do now. I'm so mad at her. Let me check the courtroom because I can't wait to see what they're going to come up with when they come back up here on this stand. That should be something different. Okay. So she goes on to say, when you talk to Ronnie about this, meet up with him in person. I worry sometimes that your house and your phone are bugged. Maybe drive down to SL and meet him after work without I don't know what that say. Sky has to make the connection between Eric and Mexico because that makes the most sense in her mind. If it's Ronnie's information and belief about the conversation over football, she can use that as the connection. Tell Ronnie, don't overanalyze it. It was a quick 2-minute conversation. Laugh out loud. Tell him I need him to do this. Bring me home. Then we will get them damn bitches. Oh, she said she gonna get them damn bitches. Also, please text Lotto or call. Tell him not to text me anything about us doing things together. Even like church. Shit, she said don't even say we went to church together. Skiing trips, nothing that puts us together. It doesn't look good. We're so close to the end. Let's push through these guys. Come on, team. Go, team, go. Have the conversation with Ronnie before he meets up with Sky. Then tell him to tell Sky at the meeting about the conversation. Hang in there, guys. We're almost there. Love you to the moon and back. Remember, take vague notes of all of this so you remember before you walk this damn dog. So I guess this page 4 is more about something about some commercial mortgage relief. We don't really need to do that, but oh yeah. Only said free Kouri. Free Kouri and all her smirks. You're right. Oh, look at this part. It says Sky is having the My Girls do the first interview with Good Morning America. Please tell Chelsea to bring up that he hasn't been to church in the 13 years since she has known him. And Eric would brag to her about how much he drank and did pills in high school. Okay, so she was trying to get Kelsey to, I guess, say some stuff in regards to Eric. Tell Kelsey to say, Kelsey was out on this once this house got foreclosed on. Like, she was done. She was going to be her best friend into not her best friend anymore. She says, tell Kelsey to say, Eric's always wanted Kouri to go down for him. For example, he would put rugs in her suitcase when we would travel together. So if anyone caught it, it was Kouri. He would put them in the bag right before they left the house, so Kouri didn't know. Then he would, when we would land wherever, Eric would take them out of her bag and Kouri would be pissed. So she trying to get somebody else to say this, but we definitely know that Kelsey didn't get up here and testify anything about this stuff. So she was trying to get Kelsey to testify to that stuff too. Wow. But they didn't, the jury didn't see this. Wow. Oh, this is when she was like, will you buy me a box of Crest white strips, open them up and put them in an envelope and have Sky give them to me? You can tell her what's in the envelope. I'm sure she won't care. I'll make sure they can't be found in my cell. My teeth are getting yellow from so much coffee and tea all day. I love you. I love you. I love you. Hang in there. We're getting there slowly. You're the best mom in the whole world. I'm so lucky to have you. Oh my gosh, she wanted her lawyer to sneak the white strips. Well, done. She ain't got no chill. No chill at all. Like she don't care. And she say she won't care. I will hide them. I gotta get my teeth together. All this coffee and stuff is doing me in. I'm trying to see if there's anything else in this letter. Oh, they back in court.
Ms. Lewis, would you tap that microphone for me?
Tap, tap.
I don't know. I'm sorry. There you go. Great. That should be fine. Brittany will let you know if it's not. We're ready for the jury code. Katie, is there a slide deck that we're playing? Okay. I have a picture of a house at the moment, right? Okay. You'll let me know when you want to publish, Ms. Lewis?
I think Katie just has it ready to go. Yeah.
Oh, okay. But it's not up yet. Okay. Please have a seat as you come in. All right, please have a seat. Thank you for your patience. We'll continue with closing argument. Ms. Lewis.
In the early, excuse me, in the early morning hours of March 4th, 2022, the house was quiet. Kouri Richins fell asleep in her young son's room, like many parents do. At some point in the night, she gets up and walks back down the hallway to her bedroom. She slips back into bed beside her husband. She settles in next to him. She reaches over, and he feels cold. Eric Richins, the father of her children, the man that she has built a life with. Something feels wrong. She pulls the blanket up around him, but something still isn't right. He feels heavy. She turns on the light. And when she looks at her husband, really looks at him, she realizes something is terribly wrong. And in that instant, in that bedroom, in the quiet early of the morning, Kouri Richins' world collapsed. Reasonable doubt. It's not just a slogan. It's not just a suggestion. It's a constitutional shield that protects the innocent and prevents the state from punishing without truth. And it is the state that has that high burden, the highest burden under the law, to prove each and every single element of each and every charged offense beyond a reasonable doubt. The state stood up on day one and they told you they were going to prove that Kouri Richins had the means, the motive, and the opportunity to kill Eric Richins. And we're going to talk about each of these, but first, I want to talk a little more about reasonable doubt. I've told juries for a long time that one way to understand reasonable doubt is, are there other reasonable explanations as to what happened? As you look at the evidence, if there are other reasonable explanations, this is reasonable doubt. And you have to find Kouri not guilty. I put to you that every fact that the state has put forth to say that Ms. Richins is guilty has another reasonable explanation. Let's go back to March 3rd, 2022. From everything we've heard during this trial, Kouri and Eric were happy that night. They were celebrating. Kouri was just about to close on the Midway mansion. Rightly or wrongly, she believed that this was going to be the deal that put her over the top. The deal that had made everything she'd done with her business, the good, the bad, and the ugly, all worth it. The night of March 3rd, they have a celebratory drink, they go to bed, and then Kouri hears one of her sons cry out. And like parents all over the world do, she goes in to lie down on the floor of her son's room. An alibi or the truth? She wasn't inconsistent when she told this story. She told everyone, I was lying in Ash's room. I was lying down with him. What does reason tell you? What does experience tell you? When she wakes up, she goes back to her room. Eric appears to be asleep. We don't know for sure what happens over the next 15 minutes or so. The state asks you to leap to conclusions about what she was doing during that time. Yet they have not shown you any evidence of this. They just tell you to believe it. But what does reason tell you? She gets up. She goes to the bathroom. She picks up her phone. We all pick up our phone all the time. Been away from it for an hour or two. She goes to the bathroom. Maybe she walks to the kitchen. Maybe she gets a drink of water. Maybe she lets out the dog. And then She goes back to her bedroom, phone probably in hand, gets into the bed next to her husband, again, realizes he's cold, pulls up the blanket, realizes something's wrong, and turns on the light. It probably takes a moment or two for her brain to register what she's seen. And then she makes that call that nobody ever wants to make. She calls 911. A big part of this state's case is that Ms. Richins is not grieving properly. You heard this from a couple of different witnesses, 2 or 3. What does that mean? I was unexpectedly widowed when I was not much older than Kouri, and I had 2 little boys. How do you judge someone in that moment? If I've learned one thing during this trial, I've learned I didn't grieve right. I didn't know that, but it's clear now that I didn't. They want you to look at a woman in the worst moment of her life and to judge her grief. There is no wrong way to grieve. They're asking you to judge how she is acting at that moment and then use that moment of evidence of guilt. In the opening, we pointed out, go ahead and put it on that the state looks at facts one way and sees a witch. But if you look at those facts another way, you see a widow. Here's an example. Hands over her face, curled up. A witch, hiding because she's done something wrong, or a widow, hiding and blocking out what has just happened to her, what has just happened to her children, what has just happened to her family and to her life. Look familiar? Portrayals of women grieving in art. Portrayals of women in grief. The state tells you during evidence that, oh, she didn't immediately talk to Kouri Richins when he came to the house because she felt so guilty she couldn't talk to him. Or was it because she didn't want to tell a father his son had died? Oh, she didn't tell the boys when she should have. It was weird. She didn't go talk to them. They were in the playroom. Again, because she felt guilty or because she was dreading the most difficult conversation, the conversation nobody, no mother ever wants to have with her young sons. Their father is dead. The father that everyone agrees was a wonderful father is gone, and she has to tell those little boys, you're never going to see him again. Believe me, that conversation may be the worst moment in a mother's life. How can a woman be judged on how she handles that moment? You heard her friend Allie staking. When Allie arrived at the home that day, she said Kouri was clearly upset. She said she was distraught. This is someone who's known her since junior high, not an officer who met her 5 minutes ago. She said Kouri was acting as you would expect. That night, friends came over to talk about Eric, to drink to Eric. A wake is what the Irish call it. The state wants you to leap to the conclusion that that night, Kouri was celebrating Eric's death. You heard Allie stalking. They were celebrating Eric's life. They kept it light for the boys. They were dancing, they were smiling. All of them were, even Eric's sister. Can we not smile in our grief? They want to tell you no. But reason and experience tells you differently. Let's talk about the investigation. The investigation in this matter was nothing but sloppy. It was driven by bias. Did you notice during the state's closing, they didn't really even talk about the investigation? Instead, they speculated. What was in people's heads? What were they thinking? Speculation, conjecture, not proof. Instead of looking at the evidence to determine what happened, the state they determined what happened, and then they found the evidence to support it. This is confirmation bias. Confirmation bias is when you favor evidence that supports a belief and ignore evidence that contradicts it. That is how this entire case was investigated, working backwards from a conclusion. It started on March 4th. Detective Woody, before she's even entered the home, Amy Richins tells her they think Kouri is somehow involved. Then both Katie and Amy Richins tell Detective Woody they think this is because she recently found out about a trust Eric created. Immediately, this influenced this investigation. But what happened that first day? They found nothing to support foul play. Kouri tells them he was a user of THC gummies, that maybe he used one that night. They never ask where the gummies are. They do a cursory search of the bedroom and bathroom. They admit that they don't look in places where the gummies were found a month later, high up in the bathroom, high above the refrigerator, high up in the laundry room, somewhere in a pocket of either Kouri or Eric's jacket in a closet. All places where they would have been put out of reach of children. But they didn't find any of them that day. You know what else they didn't do? They didn't secure the scene. They moved things around. They told you they didn't have probable cause to search the whole house. We couldn't search the whole house. All we could do was look in the bedroom and the bathroom. But they could have asked for consent. Kouri gave them consent when they asked to search one place outside of the bedroom. The entire house could have been searched that day, but they didn't do it. They didn't even ask. What else happens that morning? Officer Nguyen, he does his death checklist. He says, did he have any history of prescription abuse? Did he have any history of illicit drug use? And what does Kouri tell him? No. How easy would it have been to just say yes? If she had just killed him with illicit drugs, why in the name of God did she just not say yes? Had she said yes, we probably wouldn't all be sitting here today. She didn't say yes because she did not know how he had died. Over the last 4 years, they've gone back to that house 10 more times. And they still can't tell you what happened early morning of March 4th, 2022. 10 warrants, that's a lot. That's not typical. They were still searching for evidence on February 9th of this year, 2 weeks before trial. 4 years of investigation, and they are still trying to find evidence to make their case because they know they don't have enough. They're still trying to prove Kouri Richins guilty. So let's talk about Todd Gabler. In comes Todd Gabler, the private investigator. Jeff O'Driscoll told you, well, he was an investigator for the estate, just the civil case. Seriously? He's putting trackers on the car of Kouri, her mother, her brother. He's trying to track Carmen Lauber's car. He's providing evidence to the police. Detective Woody testified that this information from the private investigator is what helped advance their investigation. He testified he was in the house alone numerous times, finding things the police didn't, not using gloves, calling law enforcement when he found things. He said he didn't need a babysitter while he did all these things, which is different than what Clint Benson told you. He said nobody was ever in that house without me being there. That wasn't true. What he told you wasn't true. Todd Gabler was in and out of that house numerous times by himself. He also told you that he was completely fair and unbiased, testing 2 hypotheses. His hypotheses, suicide and homicide. He ignored any others, including accident. And how did he handle this unbiased testing of hypotheses? You heard Josh Grossman. He said the first time he talked to Todd Gabler said right out of the gate, Kouri killed Eric. Josh told you that tainted what he thought of next. How does it not taint an interview when your opening line is, oh, Kouri killed Eric, so now let's tell me what you have, what you know. Josh told you he started looking back at things differently than he had before because of that. Like I said, he tracked Kouri's car, he tracked her family's car, he tracked Carmen's Lauber car. He didn't track Cody Wright's car. He had more to gain from Eric's death than anyone. He didn't track anyone involved in the civil case regarding the trust. He only tracked people that he thought might lead to information for law enforcement. Did he follow up on Eric's trip to Mexico shortly before the death? No. Did he go to Mexico? Did he try and figure out where Eric had been in Sonora, Mexico? No. Nothing about that investigation was unbiased. Nothing. He passed it all on to law enforcement. And then what he did is he said to law enforcement, you should talk to Carmen Lauber. She's on the ropes in drug court. This would be a really good time to interview her because she would be very likely to be compliant at this time. Everything about this investigation was led by the Richins family. They started on day one and they continued until trial. They are the ones who initially hired and paid for experts. Their private investigator gave information to the police. You know, and by the way, Gabler testified that he followed all the rules of being a private investigator. And that may very well be true, but he doesn't have to operate under the Constitution. There's a reason that we have rights under the Constitution. There is a reason that law enforcement has to get warrants to enter your home, to take electronics, to search your house. It is to protect the citizens of our country. It is to protect the innocent. Sidestepping these important constitutional rights by hiring a private investigator who then let law enforcement know what to do taints this entire investigation. And you know what? That is terrifying. It's terrifying. If someone has enough money to hire a PI that can circumvent our constitutional rights, dig into every aspect of our rights, of our lives, and turn it over to police. We have a constitution for a reason. It's to protect us all. I want to talk about the lead investigator, Jeff O'Driscoll. Here's what he testified that his investigation consisted of. He got assigned to the case sometime in March of 2023. He got a search warrant for some medical records. He thinks he got a search warrant for a couple of cell phones. He interviewed Chelsea Barney, where they discovered that they were wrong about some text messages. Law enforcement was wrong with what they thought they were looking for. He interviewed someone named Jake Sorensen, who must not have had anything important to say because we never heard from him. Then he interviews Carmen Lauber because he was told to by the private investigator. That's it. That was the investigation. He didn't investigate any other leads. He didn't attempt to corroborate information, particularly in the letter that we saw that Kouri wrote to her mother, the walk the dog letter. Now, he told you he didn't need to corroborate that because he didn't get that letter till after Kouri was arrested. So, you know, I guess the state was done. You wouldn't want to start looking for things that might show her innocent. You've arrested her. Interestingly, they were still executing search warrants. They were still trying to find evidence for guilt, but they weren't looking at any evidence that might show innocence. It is absolutely possible that everything she said in that letter was true. In fact, at least 3 things in that letter were corroborated by the state's own witnesses. But they didn't investigate it. Again, ignore what might contradict your theory. Confirmation bias, reasonable doubt. Also remember that letter never went to anyone. So it was nothing more than thoughts on paper. That's all that letter was. What else didn't he do? He didn't interview the person Eric was talking to in Mexico the night of his death, and we'll come back to that. But he didn't follow up on that. He said that. I didn't follow up on where Eric went in Mexico or who he was communicating with in Mexico when he was there. He didn't investigate what Eric did or where he went on February 14th, 2022. He didn't follow up to see if did Eric go to the hospital that day. In fact, he did nothing regarding that day. Nothing. What else? He didn't find fentanyl anywhere. Allegedly, there were 90 to 120 pills of something. At least oxycodone. Where were they? I guess somebody took them, but they didn't have them. So whatever pills Carmen may or may not have provided to Kouri were gone. They no longer existed. They couldn't find or test those pills. And we do know that she bought oxycodone, but you know what? There was no oxycodone in Eric's stomach that night. So instead, Detective O'Driscoll says, well, we wanted to corroborate Carmen's story. I mean, we were going to corroborate it. We weren't just going to go by it. The story that they fed her, they want to corroborate the truth. They wanted to corroborate a story. Again, let's find what confirms our theory. Let's ignore what doesn't. Confirmation bias. Reasonable doubt. Sitting here in this courtroom after 4 years of investigation, there was an awful lot that O'Driscoll just could not tell you. Things he couldn't remember. He couldn't remember what people had told him in interviews. For example, he was asked, did you interview Eric's allergy doctor? Well, yes, but I can't remember what he said. Well, that might have been important because he testified the EpiPens in the house belonged to the children. Well, maybe because Eric had recently used his a couple of weeks earlier when he had an allergic reaction. He said, well, if I could have a few minutes, I could find out what was said. I could give you more information. We were in trial. He was on the stand 4 years after Eric had died. 3 years after he'd been appointed as lead investigator. And either he wasn't prepared to testify or he just didn't know. He is the lead investigator. Now the state elicited testimony from him that how could he possibly know the entire case is just too much. I couldn't know all of that information. But he's the one they put on. He's the one they relied on to testify about this investigation. You didn't hear from anyone else about the last 3 years of that investigation. They chose him. You know what else he couldn't testify to? He couldn't testify how the fentanyl got into Eric's system. He said, well, he ingested it. There was no evidence, none, that fentanyl was put in a drink. That was argument. Argument is not evidence. And they waited until closing to tell you, oh, she put it in a drink without any evidence to back that up. Okay, she made him a drink that night, but that's it. She made him a drink. There's no evidence that fentanyl was in that drink. And the lead detective who couldn't tell you anything, he sat through this entire trial. He heard every witness testify. He had an opportunity to form his answers or reform his answers based on what he knew other people had said. And yet he still didn't know the evidence. I want to talk a minute about deleted texts and the phone searches just quickly. Deleted texts. They said there were deleted texts off Kouri's phone, and that it looks like that probably was true. Why would you delete texts off your phone? Maybe because you were having an affair over the last 2 years. You might want to delete that off your phone before your whole husband's family finds out about it. Maybe because she was buying oxycodone. I mean, she asked Carmen for pain pills. Doesn't mean she killed her husband, but you probably want that off of your phone. The phone searches. So the evidence showed that Kouri found out on April 13th that Eric died of a fentanyl overdose. And that's the day they took her phone and she gets a new phone. These searches are all done on that new phone. Searches of how much fentanyl does it take to kill someone, or how much fentanyl is a lethal overdose? I don't remember exactly. Yeah, because she just found out her husband died of a lethal overdose of fentanyl. You might want to know what that means. And she texted other things. They said, oh, she texted about women's prisons. Of course she's worried. An innocent person would be worried. Anyone would be worried if they just found out that they are a suspect in a homicide investigation. She would have been scared to death. She was looking for information based on what she found out after Eric died. All right, what do we know about those last few hours before Eric's death? It's not a lot, but we do know some things from the autopsy and the toxicology reports. We know that he had fentanyl in both his blood and his stomach. We know he had quetiapine and alcohol only in his stomach and not his blood. So this means the quetiapine had to be taken after the fentanyl. Had they been taken together, they would have both been in his blood. We know there was no histamine response, no anaphylaxis. So he had not had an allergic reaction to anything in his body that night, including fentanyl. The state wants you to believe that the allergic reaction he had on February 14th was to fentanyl. If he had an allergic reaction on February 14th, he would have had one again 3 weeks later. Now, I know the toxicologist testified, well, you don't have an allergic reaction every time, and you can look at her testimony, but it was a little bit hard to understand, but I believe she was talking about, you might eat peanuts for a lot of times and then have an allergic reaction, and then it starts. Once you have an allergic reaction to something, it doesn't typically go away. We know he had norfentanyl in his body, and this is because his body had started to metabolize the fentanyl. The state's toxicologist told you that the fentanyl could have been left over from a previous use. That was a possibility. Another reasonable possibility. The fentanyl was there from a previous use. That was the evidence. That is reasonable doubt. What else do we know from the ME and the toxicologist? Well, we know that the fentanyl was not put in a drink. And how do we know this? There was only fentanyl in the blood and not alcohol. The state's toxicologist leaned toward the fact that maybe Eric didn't even drink alcohol, that the alcohol in his stomach was post-mortem decomposition. But the other scenario that she said that was possible was that Eric took the fentanyl, then took the quetiapine, had a small amount of alcohol. She testified that it would take 15 to 60 minutes for fentanyl to make its way into the blood. That alcohol takes 15 to 30 minutes to make its way into the blood. So if the alcohol and fentanyl were taken together, they both would have been there at the same time in the blood. But just the fact that one reasonable possibility is that the fentanyl was taken before the quetiapine and the alcohol gives you reasonable doubt that it was placed in a drink an hour earlier. Now the state's saying, well, maybe she put it in a non-alcoholic drink. So their celebratory drink maybe didn't have alcohol in it. There's no evidence of that, but they're throwing around a lot of theories. Why is that? Because they don't have one. They don't know what happened. Dr. Christensen and Dr. Ulmer testified that the manner of death could not be determined. This is really important. Dr. Christensen testified the ME's office didn't know enough about Eric's history to determine if it was an accident. They also didn't have enough information to determine it was a homicide. The ME had at least a reasonable doubt as to the cause of death. And the ME isn't held to the high standard that the state is. And there was no evidence that the autopsy couldn't have been amended at a later date if additional information was received. The ME testified The ME testified, excuse me, the ME didn't tell you that they couldn't amend the autopsy. He just told you they didn't. What else didn't they do? Why didn't they do a hair follicle test? Dr. Christensen said, well, we don't do that unless we're asked to. Would you be asked to do that by law enforcement? Again, Summit County was only looking for evidence to confirm their theory, evidence to support that Kouri was behind Eric's death. They did not want to look for evidence that contradicted that theory. Had they done that test, we might have our answer. Confirmation bias. All right, let's start with the means. The state did not and cannot prove that Kouri ever purchased fentanyl. Carmen Lauber, interestingly, they barely mentioned Carmen Lauber in their closing. The only witness who can put fentanyl into Kouri's hand. Let's talk about her testimony. Admittedly, a lot of it was painful to watch. And in some ways, she's sympathetic. But she is looking at multiple long prison sentences. And her only way out, her only way was to testify at this trial. But what she could not do was put fentanyl in Kouri Richins' hands. She told you that she had no memory of what actually took place in 2022. During those interviews, she told detectives over and over again, my brain is fried. I've been using drugs since 6th grade. My memory is gone. So what she testified to you wasn't what she remembered. She admitted on the stand that what she testified to was what she had been shown, what she had been told. Detective O'Driscoll told you that Carmen Lauber could not remember the purchase of drugs after Eric had died. When asked by Ms. Nestor if at least one of the times that Carmen allegedly purchased drugs from Mr. Crozier and brought them to Kouri was after Eric's death, his response was, her testimony was not that. She didn't remember it that way. We found digital evidence that supported that. You know what? She did testify to that. She testified at length and in detail about something that even Detective O'Driscoll said she didn't remember. Carmen Lauber was not able to tell you that she bought fentanyl. She agreed on the stand that it was the detectives that first put the word fentanyl in her mouth, in her head. She was told by detectives in this case that she bought fentanyl. Eric died of fentanyl. You bought drugs. You bought fentanyl. She took that story and she ran with it because she had everything to lose. And O'Driscoll, Detectives O'Driscoll and Detective Maynard told her, you are getting a big, giant get-out-of-jail-free card. And what do you have to do to get that big, giant get-out-of-jail-free card? Give them the details that will ensure Kouri gets convicted of murder. You heard that from O'Driscoll's own mouth. He tried to explain it away. But he went in and he told this woman, get out of jail free card, give us the details to ensure Kouri gets convicted of murder. She had to tell them that. She had to tell you that. She had to say she purchased fentanyl. The detectives walked into those interviews not to find out what happened, but to get Ms. Lauber to confirm what they already had decided happened. Again, confirmation bias. She told them at that first interview, I literally never dealt with fentanyl. And she had reason not to deal with fentanyl. She told you that. She had a daughter who had overdosed from fentanyl. She was afraid of fentanyl. She told them that Kouri asked for something for an investor's bad bag. Maybe it was for Eric. But she told them that Kouri asked for an investor's bad bag. And that later she asked for something stronger. She asked for the Michael Jackson drug. She told them Kouri never asked for fentanyl. She admitted that she got the word fentanyl from Detectives O'Driscoll and Maynard. She told them she couldn't remember. She asked them to lay it out for her, to put the pieces of the puzzle together, to write it down and I'll sign it. They argued that was because, well, she didn't want to write it in her cell. That's why they wanted us to write it. Well, she could have written it right there at the table, I suppose. But you know what else? Remember? She also told the Assistant United States Attorney basically the same thing. Put it together for me. And the U.S. Attorney or the Assistant U.S. Attorney said, oh, we don't do it that way. You have to tell us what you remember. They literally offered a big, giant get out of jail free card. In the state's last question to Detective O'Driscoll, they brought up the TV show, The House of Cards, but who held all of the cards in this case? Jeff O'Driscoll told you. Carmen Lauber held all of the cards. Their entire house of cards is being held up by her. And now at trial 3 years later, she comes in here and says she bought oxycodone once and fentanyl 3 times. Oh, she had her story down. She told it very nicely on direct. But when pressed, she couldn't remember anything. Not from 2022, not from 2023. She couldn't remember on Friday what she testified to on Thursday. And you know, I didn't ask her about her mental health or her learning disability to be mean. I asked her because it explains why she was so easily convinced by law enforcement as to what she needed to do and what she needed to say. She described her learning disability as low education. Well, you can decide what that means for yourself, but one possibility is she has an intellectual disability. And if that is the case, she is more vulnerable to suggestibility than most people. Easy to manipulate. And they took advantage of this. We all saw it. They did too, but they had to find someone who would confirm their theory. But you know what? Through all of this, there were a handful of things that Carmen Lauber was consistent about. There were a few. Kouri asked for some pain medication. Kouri said that in the Walk the Dog letter. Then she told you, I brought oxycodone from Susan Kohler on February 11th. Prescription oxycodone. Now that's important because if Kouri had any pain pills before February 14th, these were likely what she had. She said Kouri never asked for fentanyl. She said that in all of her interviews. Carmen never asked Robert Crozier for fentanyl. She said that. She was consistent with that. That she bought pills from Robert Crozier. That the pills she got from him were light green, 15 to 20 milligram oxycodone pills. When she bought from him again, she asked for more of the same. Those are the things she said throughout. Everything she said, every other thing she said has changed multiple times. It changed again while she was on the stand. Now she says the number of purchases were more. That changed. The date changed. For the first time, she says that Crozier was the first one to say the word fentanyl. It's the first time we've heard that. Wasn't in the interviews. She's not a truthful person. There were a couple of little things she lied on the stand about. Not super important, but I'm going to point them out because they were just untruths. When I asked her if she was on any medication for her anxiety or any other illnesses, she said no. But then later, when Mr. Bloodworth asked her, she said yes, she was on medications. They were in her car in her purse. She told you Nancy Peterson drove to buy the drugs because she didn't have a driver's license. When we showed her that photo was reversed and that she was driving, did you notice how smoothly that story changed? Oh, well, yeah, I drove one way, she drove the other. By the way, where's Nancy Peterson? There was someone who might have been able to confirm Carmen's story, but we didn't hear from her. What else did Carmen lie about? She said on that stand, and she told you, I never violated drug court after I got out, my get out of jail free card in May of 2023. But then when confronted, she had to admit, oh yeah, I did. That's right. She told you, well, I was holding a can of alcohol, but I didn't drink it. When confronted though, she had to admit that wasn't true. She said on the stand, and she told you that. Oh, I just held it. Oh, but you told your probation officer you drank it. Oh yeah, I guess I drank it. But what's the most important thing she admitted to lying to? She lied to a judge. She lied to a judge by writing a letter saying that she had been 100% compliant with drug court. And why did she lie to that judge? She wanted to go to Vegas. And she told you on the stand, she admitted it. Yeah, I was untruthful with the judge to get something that I wanted. She was untruthful because she wanted to go to Vegas. There is a lot more at stake here than going to Vegas. She is, again, being untruthful to get what she wants. And what she wants this time is to stay out of prison. And she will say whatever she needs to make that happen. You know what else she got by telling that story, in addition to her get out of jail free card? She also got an advance straight to go and pass drug court on the way card. No more showing up at drug court. And she told you drug court's tough, but she didn't have to go anymore. No regular check-ins. She just had to text hi or lobber to Detective Maynard. And most importantly, no more drug tests. She's still on probation, still waiting to go to court to see if her charges will be dismissed. And she's not being drug tested. Is she telling you the truth about being clean? We have absolutely no way to know. She got everything she wanted by testifying to things that she admitted she had no memory of. Can you feel for Carmen Lauber? You can. Can you believe her beyond a reasonable doubt? You cannot. And if you can't believe her beyond a reasonable doubt, you have to find Kouri Richins not guilty. I don't want to talk about Robert Crozier, because he's also an addict, and he also changed his story. But what makes him different? First, his original story was given in a 13-minute interview while he was coming down from drugs. Not in 10 hours of interviews over multiple days. Detectives came in, and they told him he sold fentanyl. So we already know. We know you sold fentanyl. You just need to confirm it. We won't jam you up. Just tell us you sold fentanyl. And he agreed with them. And they asked, did Carmen Lauber know she got fentanyl? And he said, absolutely. But what did he explain to you on the stand? Now that he's been through rehab, now that we know he's sober, he gave people what they asked for when he was selling drugs. He always gave them what they asked for. So when detectives came in and said, well, you sold Carmen fentanyl, Carmen asked for fentanyl, he said yes. He said, what I meant is, if that's what she asked for, that's what I gave her. What else makes him different, though, from Carmen Lauber? He changed his story from what the prosecution wanted him to say to what they didn't want him to say. Not the other way around. Why do this? Why would he risk his immunity? It would have been so much easier for him just to stick with his original story. Let's go back. So he gives that original story in April of 23. He sobers up. He meets with the state. He meets with Mr. Bloodworth in April of 25, before he ever spoke to me or to Mr. Berman. And he tells them at that time that he got it wrong. He says, no, I sold Carmen oxycodone, not fentanyl. And how does he know this? He told you. Because he didn't start selling fentanyl until late 2022. And he sold to Carmen Lauber in early 2022. Also, his source gave him fentanyl that was so dark it was almost purple. It wasn't light green. It wasn't light blue. Okay, so then he meets with our team in October of 25. He says the same thing. He signed an affidavit swearing it to be true. He testified to the same thing at trial. I was only selling oxy in 2022. And not only that, he told you it was prescription oxy from a pharmacy. So not fake oxy that was actually fentanyl, but real oxy. And he was a bit of an expert on the topic. I think he knew more than the drug expert did. He told you, light green pills, those were 15 to 20 milligram pills. Light blue pills, those were 30 milligram pills. His prescription was 10 milligram pills. He knew his stuff. He was a pretty successful drug dealer. And he told you when I sold fentanyl, those pills were almost purple. What did he have to gain by testifying to this? He's never met Kouri Richins. He'd never met Eric Richins. He didn't know Carmen. He isn't getting anything from anyone. It's for these reasons that his testimony is more credible than Carmen's. Her freedom is at stake, so she had to say fentanyl. She has to give them Kouri. He has nothing to gain. He just told you the truth. The state told you in closing that they traced the fentanyl. It's absolutely not true. Carmen never even looked at those pills. She didn't test those pills. She didn't take any of them, according to her. And we don't know where any of them are. Where are these some odd 90 to 120 pills? They didn't trace that fentanyl. We have no idea where that is. They didn't trace any fentanyl. So how did Eric end up ingesting fentanyl? What other reasonable explanation might there be? You know, I'm not going to stand here and say to you that Eric Richins was a drug addict. He wasn't a Carmen Lauber. He wasn't a Robert Crozier. I don't think the evidence shows that. But that doesn't mean he didn't use. That doesn't mean he didn't ask Kouri to get him pain pills. He probably did. So what do we know? We know Eric was in pain. He had Lyme disease, which can be very painful. He had back pain. He had knee pain. We know he'd been in Mexico not long before his death. Look at what he was doing right before his death. So right before his death, he's texting Pedro Sonora, back and forth, back and forth. Did they interview him? Like we said, no. He texts his friend Scott Wagner. More, Pedro Sonora, from 8:30, between 8:30 and 8:36, he texts him 1, 2, 3, well, these are back and forth. But between them, there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 texts. He gets a call from Scott Wagner. What's his last Google search? How far is it from Scottsdale to Nogales? And then he gets a text from Raul. We also don't know anything about Raul. Maybe he made other calls. The state said maybe Kouri was calling on the Wi-Fi. Maybe so was he. We don't know who else he talked to, but this is what we do know. Oh, which this is a good place to bring up, I think, that the state did stand up here and they told you that we said things in opening that didn't come in during trial, and that's true. Strategies change during trial. But remember, we are not the ones under an obligation to put on any evidence. It's not us. We're not under an obligation to prove anything. It's them. Okay, so what else do we find on that first day that Eric died? What else do they find? The hydrocodone bottle. Whatever happened to that bottle? Why wasn't it tested? What was kept in that bottle? The bottle sitting right by the bed on Eric's nightstand, right next to his phone and watch that were placed neatly in his charger. An expired prescription bottle with nothing in it but residue. And you can see the residue there. Why would that be sitting out? A 6-year-old prescription bottle. What might be the best way to bring illegal pills back from Mexico? Put them in a prescription bottle? Put them in your suitcase? What might be the best way to store your illicit oxycodone? Stick them in a prescription bottle? Put them by your bed? And now that bottle's gone and nobody knows where it is and nobody tested it. And you saw that white powder, and you can look back when you go back, but you saw that white powdery residue on the nightstand next to Eric. Nobody tested that either. So what's another explanation? What could have happened? Eric was about to take his last pain pill out of that bottle that he kept by the side of his bed. He's on the phone with people in Mexico. He's checking how long it takes to drive from Scottsdale to Nogales. Maybe he knew he was getting fentanyl in Mexico. Maybe he thought it was something else, and he accidentally got fentanyl. Maybe had they tested that bottle, we would know, but they didn't. You know what else we know, though? We know he had a prescription for naltrexone, and it appears he wasn't taking it. A drug used to help people control craving for drugs and alcohol. It's not a drug used to treat Lyme disease. There's a reasonable alternative. Reasonable doubt. All right, I'm going to move to motive. The state absolutely did not prove that Kouri's relationship with Josh Grossman was a motive to kill her husband. Josh and Kouri had been seeing each other on and off for about 2 years. You heard from Josh. He testified that their future together was a fantasy. That at no time did Kouri ever lead him to believe that she was going to leave Eric for him. It was clear that Josh loved Kouri more than she loved him. You could see it in his face. You could see it in his demeanor. You can look at the text shortly before Eric died where Kouri was trying to break up with him. The state wants you to find that the conversation Kouri had with Josh about his time in Iraq is somehow evidence or proof of murder. But Josh told you she was grieving, that conversation was about life and death, and Eric and bow hunting and the supernatural, that it really didn't even seem that unusual at the time. He only thought it seemed unusual when the private investigator told him Kouri killed Eric. It's not evidence of a homicide. It isn't proof of anything. Yes, they were having an affair. Eric was also having an affair, possibly more than one. You heard there was a text about an open relationship, and they can laugh about that, but that's what the text said. And you know what? We do not bring this up to make Eric out to be a bad person. It doesn't matter what he was doing in his personal life. That's not the point. The point is that there were parts of Eric's life that he didn't share with people. Just like he didn't share with Cody that he used marijuana, or even that he took prescriptions. The point is we all have secrets, and Eric had secrets. But back to Josh, the best evidence that Josh was not a motive for Kouri to kill her husband is that after Eric died, she never did get together with Josh. She didn't show up at the brunch that they'd planned to celebrate the closing on the Midway Mansion. She didn't go on a vacation with him in April. She never even finished paying for that vacation. Josh told you that Kouri changed after Eric's death, that she was grieving, that he saw less and less of her, and ultimately she broke things off. And by the way, if Kouri was as motivated by money as they would have you think, would she really have killed her wealthy husband to run off with the handyman who lived for free in one of her houses? That doesn't fit with the state's theory. The state says, look at texts, replace the words in them with different words. They stood here and made up what was inside people's heads, what they were thinking. The state has to rely on evidence. They have to prove their case, and they can't do that. The state did not prove that Kouri killed Eric in order to be with Josh. All right, money. Money's a motive for a lot of things, for a lot of people. Was Kouri a brilliant businesswoman? No. Was her business struggling? Yes, it was. Was there fake it till you make it? There seemed to be a lot of that going on. Brooke Carrington testified that money was not a priority to Kouri Richins. She could have used an accountant, she said. She didn't even use QuickBooks. And this is all true. A young mother trying to run a business, like most young mothers, young working mothers, did her accounting take a back seat to her family? Probably. The state also wants you to believe that Kouri was cheating her best friend, but that's not what the evidence showed. The evidence showed that the $45,000 that Chelsea gave to Kouri was not earmarked for closing. Kouri could do whatever she wanted with that money. All that mattered was that when she went to that closing on that house, that she showed up with $45,000. It didn't have to be that $45,000. It could have been $45,000 she expected to come in from another flip. But then Kouri was arrested and never got the opportunity to do that. That's why that house foreclosed. But you know what the evidence has shown? That Kouri, rightly or wrongly, truly believed that that Midway Mansion was going to turn everything around. They were celebrating that night. If Kouri was going to kill Eric for money, she certainly would not have done it on the night that she believed she had just secured a multi-million-dollar property. And if you look at the state's exhibit 624D, you will see that Kouri actually made a profit on every single home that she flipped. She had reason to believe that she was going to make a profit on this one too. All the foreclosures, those were all after her arrest. And something else, they say it would have cost way more money than she had to rehab the mansion to live in it with Josh, which again, Josh said was fantasy. That wasn't going to happen. But if you don't believe him, look at text. Look at State's Exhibit 2-17D on page 33. This is where she and Eric are going back and forth on how much it would cost to rehab the mansion. And he says, we can't afford that. We don't even have time for that. What does she tell him? And you can look at it. I don't have it word for word. She tells them, no, we're not doing that. I just need money. I just need to give the numbers, to the investors. She didn't intend to rehab that. She intended to flip it after a little cleanup. All right, I want to talk about the gifts that the state talked about in their opening and throughout trial. They made such a fuss about these. They were accessed on Kouri's phone on March 4th, the morning of March 4th. They were tied to the celebration. That's what those were about. If you look at that exhibit, I think it's 3-40, you can see that the orphan gifts were accessed at the same time, down to the second, as a picture of the Midway Mansion. So what do we know about these gifts? We know that some photos were stored in a cache on the phone, not connected to any particular text. We know that they were accessed the morning of the 4th. We know that at least one of the pictures, the one of the mansion, was sent by Eric the evening before, which likely means all of these photos were sent prior to the morning of the 4th. These were not about Eric's death. She wasn't celebrating death. These gifts were sent earlier, and she was celebrating closing on that mansion. It just doesn't follow she would kill him for money. She received less from life insurance than she thought she was going to make on that mansion. Josh Grossman told you that she was surprised when she found out about the $1 million life insurance policy from auto insurance. It appears she didn't even know that. And if you take Brooke Carrington's testimony as true, and by the way, she was a good witness. She is a professional, expert witness. First hired by the family, and then paid $200,000 by the state. A prosecution witness sitting right here today behind the prosecution. Very different than the MEs, who are just here to tell you their findings. But anyway, if you accept her testimony, the life insurance wasn't going to fix the problem anyway. Kouri spent that life insurance within a matter of weeks and was still in debt. And you know what you heard on that phone call between Bryce and Chelsea and Kouri? All I want's the home. It's all I want. They can have everything else. They can have the money. I don't care. I just want my house where I've raised my boys. And you know what? Eric was making good money. In 2020, he told Christina Miller, the attorney he went to about talking about a divorce, that he was making, his income that year was over $33,000 a month. Cody Wright testified that they made $500,000 each the last year that Eric was alive. I believe there was testimony that there were other years she made even more. Not sure about that, but I think that was in there. So if this case was about money, Eric was worth so much more to Kouri alive than dead. Opportunity. Well, I guess her opportunity was she was the only one in the house. Who else was in the house, though? Who else had an opportunity to take those pills? Eric. 4 years later, 10,000 searches, over $300,000 worth of expert witnesses, 3 weeks of trial, the FBI, the DEA, Homeland Security, the Summit County Sheriff's Office. They cannot tell you how Eric ingested that fentanyl. They haven't done their job, and now they want you to make inferences based on paper-thin evidence. They speculated on a number of things during closing, and they want to tell you, they want you to do their job for them. Tell them no. Tell them if they're going to charge a person in your community with the most serious crime there is, they better have the facts. they better have the proof. They better have more than speculation and conjecture because that's their job. It's not your job. All right, I want to talk about the elements. The first one, aggravated murder. Okay, so they have to prove that that Kouri Richins intentionally or knowingly caused the death of Eric Richins. The state has not proven this. They haven't even proven that she obtained fentanyl. They have not proven where the pills ended up or how Eric took them. The state stood up here and argued, well, it really doesn't matter what drug she purchased. As long as it was an illicit street drug, it absolutely matters. Because what did he die of? He died of fentanyl. There was no oxycodone in his system. There was no other drug in his system. They must prove that she purchased and gave him fentanyl. Oh, and let me talk about Becky Lloyd for 1 minute. She said that she had a conversation after a drink or two where Kouri allegedly said, oh, things would be easier. I'd be better off if Eric was dead. But what else did you hear? You heard Becky in a recording tell the officers and investigators, I don't think I can testify to that on the stand. I'm not sure that that's true. But then she testified to it. Well, maybe they threatened to bring a catch pole for her dog too. One thing I want to point out here, though, is if after looking at all the evidence, you believe that Ms. Richins accidentally obtained fentanyl when she thought she was getting oxycodone, and then Eric took those pills voluntarily and died, that is not intentionally and knowingly. That is not aggravated murder. And if you conclude that, you must find Kouri Richins not guilty. All right, attempted murder. What is the evidence of this? And again, it has to be intentionally or knowingly, and it has the rest of the elements there. She had to take a substantial step. So here's the evidence. Kouri bought an omelet and an egg sandwich at 9 o'clock the morning of February 14th. There was no evidence that she left that sandwich in the truck. To the contrary, there was a conversation with her mother saying, they think I left some sandwich in a truck. That didn't happen. Eric said he wasn't feeling well. He took a nap between 11:30 and 2. He called a couple of friends and sounded upset. He joked a few days later with Kouri and friends that his wife had tried to poison him, that he'd had an allergic reaction and used an EpiPen. Alex Staking told you that, Ollie Staking. She never said that Kouri got defensive. She didn't say that. She said they were all laughing. She said that Eric didn't seem upset or scared. It was a joke. Wouldn't be the first time a spouse ate something and said, oh my God, my wife tried to poison me. But that's it. That's their entire case. He didn't go to the hospital. He didn't do anything that day but take a nap. Eating an egg sandwich, having an allergic reaction to something, and taking a nap. There is no world in which that is attempted murder beyond a reasonable doubt. Oh, they point out that months later in text to Chelsea, her friend, that she gets some details wrong about that day. Maybe because she didn't try to kill him, and in her memory that day really wasn't all that important. She said, I bought him lunch. Well, it was breakfast. Again, they stood here and said, Eric was thinking this, Kouri was thinking this. She was, off with Josh thinking all these things. None of this was evidence, not any of it. None of it is proof. They talked about some IRS calls that she made on those days. No evidence as to what was in those calls. No witnesses from the IRS. Speculation, conjecture, not proof, reasonable doubt. Okay, I'm going to jump quickly. The other 3 counts I'm going to go through quickly, but I'm going to go to count 5, which is the forgery count. Now, remember what we're talking about here. This is one of those life insurance policies that any of us who belong to a credit union get, where you don't have to do anything. You sign here for $100,000 free life insurance. And this was filled out for both Kouri and Eric. Matthew Throckmorton, the handwriting expert, all he could tell you is that Eric probably did not sign the True Stage insurance policy. Probably is reasonable doubt. And he could not tell you that Kouri did sign it. They have not proven that Kouri forged Eric's signature. And there was no evidence either way if Kouri had permission to sign Eric's name on that True State's life insurance. I mean, let's be serious. It's the rare married couple who doesn't occasionally say, hey, honey, I'm going to sign this for you. Is that okay? But there was no evidence either way. She's not guilty of forgery. All right, jumping to the insurance fraud counts, count 3. Count 3 is directly connected to count 5, because this count alleges that Kouri fraudulently obtained that insurance policy, and the fraud was forging Eric's signature. They said there was a reversed social security number on there, but the fraud's the signature. So if the state hasn't proven to you count 5, it automatically follows they haven't proven count 3, and you must find her guilty, not guilty on count 3. Count 4 says that alleges that Kouri fraudulently collected the True State insurance policy. All that means is if she did kill her husband and then represented something different to collect that insurance, that would be fraud. But if you find Kouri Richins not guilty on count 1, you have to find her not guilty on count 4. The state has not proven their case. They don't have the evidence that Kouri Richins killed her husband. So instead, they have tried to show you as much evidence as they possibly can to convince you that she's the sort of person who would. Getting close to the end. I'm sure you would like me to stop talking, but I have to tell you, I'm afraid to stop talking. Because as I stand here right now, Kouri Richins is still cloaked in a presumption of innocence. I don't ever want to walk back to that table. As a defense attorney, that is one of the longest walks a lawyer can make. This entire case is going to flash before my eyes. And all I will be able to think about once I sit down is, what did I miss? What did we miss? What didn't we tell you that you wanted to hear? Did I focus on what you wanted to know? Did we do enough? You're about to go through those doors and into the jury room and start deliberations. Everyone in this courtroom, everyone watching around the world, we all wish we could follow you and listen in. But that room, that jury room is yours. It's sacrosanct. In that room, you get to decide. And when you get in that room and you look at the evidence, if you think that Kouri Richins might have killed her husband, that she likely killed her husband, that she probably killed her husband, you must find her not guilty. Because maybe, probably, likely, very likely, none of these reach that extraordinary burden of proof beyond a reasonable doubt. I'm going to ask you to do a couple of things when you go into that room. First, you might be tempted to go around the room and take a vote for guilty or not guilty to see where you all stand. We ask you to refrain from this. Instead, we ask, talk to each other about where you see reasonable doubt. Also, if Kathy or Alex or myself did something to offend you during this trial, please hold that against us and not against Kouri. Now, the state's going to get up and talk to you again because they get the last word. And the reason they have that last word is because of that heavy burden. But when you filled out that jury questionnaire, we asked you if you would be comfortable making your voice heard in that jury room. Would you stand by your convictions, by what you believe? And each and every one of you said yes. So here's my final ask of you. When you're deliberating and something comes up that we didn't respond to, will you be courageous? Courageous enough to raise your hand and talk about what our response would be. Raise your hand for Kouri, because you are the last line between an innocent woman and the state. Be courageous. Courage is what this moment demands. The courage to stand between a member of your community and the state and demand that they comply with the Constitution, that they comply with their burden. Do not let them fool you. Do not fall for red herrings. Kouri Richins did not kill Eric Richins. The state did not prove this case beyond a reasonable doubt, and you have the courage to tell them this and find Kouri Richins not guilty.
Mr. Bloodworth.
Your Honor, 15 minutes now will save me 30 minutes later.
Understood. Folks, let's you stretch your legs.
All All right, jury.
I genuinely couldn't tell if you wanted to do something on the record or just needed a break.
No, so just a break to, well,
Collect your thoughts.
collect my thoughts.
We'll be in recess until 2:15. Thank you.
Shame, shame, shame. She had to take that shame walk, that walk of shame. Boy, oh boy, oh boy. Who raising their hand for Kouri? Pretty Brown said she like that color. She don't know what y'all talking about. Kouri innocent. Don't be trying. Hey, they can only work with what they got. Could y'all hear my thing? Look. Could y'all hear it? I can't tell if y'all can hear it. Could y'all hear my soundboard? For some reason, I feel like it's not connected again. Oh, you can hear it? Okay, good. I was like, I don't know if you can hear it or not. It's faint. Let me see. It's probably coming out of the wrong thing or something. Yeah, I have to see if I can maybe I don't know if it's I don't know why it's so slow. I mean why it's so low. It shouldn't be low. I bet you that damn ding for this damn thing is not slow. Not low. You're on my nerves. Yeah, so yeah, I don't know. And I can't understand. I know she pointed out a lot of things saying that the state didn't say this, the state didn't say that. And I was thinking to myself during her closing, like, oh my gosh, please don't say that. Because like you saying that, like if they did forget it, you just reminded them to say something about it. Girl, bye. Don't be doing that. I wouldn't be saying none of that stuff. No, siree, Bob. I wouldn't be saying any of that stuff, but she went up there and she was saying it because I wouldn't have reminded them of nothing. They would have had to go back and figure it out. Or she should have did it some kind of different way. In my opinion. Let me see. Yeah, so I think that she shouldn't have pointed out anything that she thought that they missed, because what'll happen is right there in rebuttal. They gonna remember, they gonna be like, oh, we didn't point this out, let's do that. Even though I don't think the state is gonna forget about anything they're doing. Mic check, 1 2 1 2. Yeah. Oh, so I can hear myself in that portion of my headphones. I wonder, does that make the sound better with these headphones on? I see a lot of creators with the headphones on. I just don't know. How do I sound okay with my headphones in? Do it sound better or no? I see a lot of people with headphones in their ears when they're talking. Let me see. I don't like it when the defense be like, we don't have the burden of proof. So that's just saying we ain't got to do nothing but go to jail. Well, good. I wonder, so do it sound better? Like, okay, wait. Does this one sound better? Or does it sound like I'm echoing? It sounds like I echo when I got this part on. Like I can hear myself talking back to me. But Afro Man, the Afro Man, it sound the same? No difference, huh? That's wild. The Afro Man. Yes, SD. Your wish is my command. With the Afro Man. Yeah, we can always watch it on a faster speed. I can get it together for us. The Afro Man. Yeah, I can set up a room for that. I have to start working on it while we in court. Yeah, I think Kat Williams is covering it too. So if y'all want to watch double coverage of it, or if you want to watch, yeah, she is covering it too. That's gonna be a good place to watch it. We will have to probably watch it after anything. Yeah, I think it's a civil suit. I think. Don't quote me on that. I have to go in there and check. I think it's a civil suit. She said a hair guy trial. Sue's so cute. Yeah, so that's he got on this red, white, and blue with these flags on his suit. Oh boy. Yeah, we can go and watch and see what it's about. I don't know much about it. I can tell y'all that much. I don't even know where it's happening at. I have to find out some information. I'll create a room for us to watch it in. Which is like, you wonder if he, maybe not. Who knows? Yeah, I'm on Cat's thing, looking. And yeah, he being sued by some deputies. Okay, yes, it's a civil trial. I just wanted to make sure. Afro man. Probably so. She want to know who all medicated before they go into court. They still on break at court. Let me see. I have to see what news station is playing it. Oh yeah, here we go. Oh no. Oh, it look like it's on this. They got people on here crying and stuff. Like, really? Let me see. Is this the entire feed? I'm just trying to see what we got going on here. I'm trying to see if I can see date. Okay, here we go. Okay, so it's okay, so I found the news station that is being streamed on. Oh, it's a nice clean stream too. That's awesome. That's always awesome work. Yeah, and that don't look like it's gonna be like a long trial anyways, because it's like a civil trial. So we'll probably be good with this one. I'll get everything set up, like I said, and we will watch that for you, SD. It's gonna be, it look like it's gonna be very interesting. 6 minutes, Dougie Fresh, you're on. Yeah, I have seen some stuff. Why hasn't anyone brought up there was no client wanting rugs? Ain't no telling. Ain't no telling. But I wonder what he is going, like she was scared to say her final word. I didn't think she was going to say her final word because she didn't look like she wanted to. Like she looked like she was struggling. She was like, I want to sit down, but I don't want to sit down. Like the hardest thing for me to do is to sit down. I don't want to do it. Like I don't want to do it. Can you blame her? They don't have no more chances to speak to the jury. No more chances. No more chances. Okay, let's do this. Because now SD got me working on stuff. Party going.
From the surf in San Diego to the courtroom stream, SD walks in like she owns the scene. Pelo multicolor shining in the sun. She cracks one joke, chat laughing as one. She throws preguntas bien chidas, sharp like a blade. Cross-exam queen, nunca tiene a braid, and that dance so spicy. spicy. Cali Mix close, she brings the fuego, everybody knows. Cuando Jason llega, ay caray, she flirts poquito. He just says hi, sweet pea laughs. Aquí vamos otra vez, SD drops the fuego and the chat says yes. She's fuego, fuego, lighting up the show. Tex-Mex in the chat, everybody knows. Con su risa, su vibra y su pelo tan cool, she turns the live stream to a cumbia at the pool. Fuego, fuego, SD's the queen. Spanglish magic en la chat screen. When she pops on camera, we all say que show. Latina sparkle with that California glow. Los mos la quieren, they hype her name. She adds flair y sabor to the game. ¿Qué onda, gente? And here comes the fun. El chat se enciende like under the sun. When she teases Jason, boy, behave. But without a chaos, this chat ain't the same. Bailalo, mija, with your Tex-Mex vibe. Bring the cumbia flow, keep it alive. SD with the groove, don't ever stop. Shake up the stream till we're all on top. She's fuego, fuego. Let her up the show. Tex-Mex in the chat, everybody knows. Con su risa, su vibra y su pelo tan cool, she turns a live stream to a Latin dance floor. Boom. Fuego, fuego. SD's the queen. Spanglish magic en la chat screen. Beach girl sparkle, courtroom delight. SD keeps the chat shining bright. Sweet pea, the mods, we all agree. Take it to trial, ain't the same without SD. Yeah, lights on, chat awake. What's the move tonight? Sweet pea in the room, yeah, you know the vibe, right? Quick, sharp mind cutting through the noise. Got the whole room laughing when she drops her voice. Eyes on the screen and she reads the whole room. From jokes to facts, she's ahead of the boom. Not just talk, yeah, she bringing receipts. When Sweet Pea speaks, everybody hits repeat. She don't just show up, she sets the tone. One laugh from her in the chat's blown. Smart, funny feelings, yeah, that's the code. Main character energy fully in mode. Whoa. Sweet pea, say it louder when she enters the scene. Sweet pea, got the jokes, got the facts, got the mean. When she talks, everybody leans in. Sweet pea, yeah, you know she always wins. One line of queen, yeah, she never miss. Turn a quiet room into a viral clip. Brains and humor in a perfect blend. When Sweet Pea starts talking, that's the trend. Say it again, who runs the chat? Sweet Pea, yeah, that's that. Sweet pea, yeah, you know she always wins. Late night glow from 1,000 screens. Everybody watching, nobody seeing the same thing. One line drops, tension in the air. Half truth, half theory. Somebody already there. We don't just scroll, we decode. Read between what they said and what they showed. Quiet minds with loud ideas. You feel it shift when the chat appears. Not here for drama, not here for the show. We're here for the patterns that nobody else knows. We're the signal in the noise. Low voices, sharp choices. Every thought hits like a flare in the dark. We're the signal in the noise. No scripts, just voices. When the chat moves, yeah, it leaves a mark. Someone jokes, someone pulls the facts, someone notices what they tried to hide in the gaps. No spotlight, but the room feels tight. Truth doesn't shout, it arrives quiet. Different minds, same frequency, not followers, we're a community. They think it's random, they think it's luck, but patterns don't lie when you look long enough. Say it soft, say it slow. Who really runs the flow? Not the screen, not the host, it's the chat. Yeah, you know.
Horror tricks are not again.
Mr. Bloodworth, please proceed.
Thank you, Your Honor. Next, guys. Harder tricks are not legal standards. Legal standards are what matter. Let's review a couple of the important ones. You'll have them in your instructions when you go back to deliberate. Reasonable doubt. I come back to this one again and again. Evidence usually consists of testimony and exhibits presented at trial. What the lawyers say is not evidence. I've come back to this slide in rebuttal precisely because of defense's closing. There is a reason the state provided you in its slides with the cite to every single piece of evidence it argued. We told you what transcript page and line number. We told you what exhibit number. Because what the attorneys say doesn't matter. The evidence is what matters. And there's a reason defense counsel didn't cite you to the evidence. Next slide, Scott. A lot of the evidence is circumstantial. It is. People do not video themselves poisoning their spouse. But circumstantial evidence is just as good as direct evidence. You can use circumstantial evidence to conclude facts just as you can use direct evidence. The instruction gives the example of it is wet outside and people are closing up their umbrellas. That makes sense. Let me put it to you a different way. Does everybody know what happened here? Kouri Richins chose Carmen Lauber. The state didn't. Hold on, let me check. Kouri Richins chose Carmen Lauber, not the state. Go ahead, Scott. Thanks. Kouri Richins chose Carmen Lauber because she was the drug dealer she knew. The state granted Carmen Lauber immunity because it cares more about a murder case than a drug deal. That should surprise nobody. Kouri Richins chose Carmen Lauber in part because she had control over her. She could help her out. She employed her to some measure. She could help her out. A little quid pro quo. You give me some drugs, I can help you out with your drug court. Kouri Richins chose Carmen Lauber, not me. Her testimony is corroborated. If you only believe Carmen Lauber's testimony that is corroborated, that is plenty of proof to convict. She was only at that Maverick in Draper 3 times. That's what the digital evidence shows. Each of the 3 times she was there, so was Robert Crozier. Those were the only 3 times he was there. Their testimony corroborates each other in the relevant manner. It corroborates that they met, that he sold her drugs, illicit street drugs, that it had fentanyl. Blues had fentanyl. Corroborates that they weren't prescription drugs. He got them from a plug, not a pharmacy. They were packaged in a little clear baggie, not a prescription bottle. All the testimony of Carmen Lauber and Robert Crozier that matters Corroborates each other.
So with these transactions, when Carmen.
Go ahead, we've seen this one again. Crozier was at the gas station 3 times. Carmen Lauber was there every time. The March drug deal. Timing of this is very interesting. Shortly after Eric's death, Carmen Lauber spoke with Kouri Richins and asked, please tell me these pills were not for him. Of course she denied it. No. But then, a few days later, she asked for more pills. It's curious as to why. Perhaps to cover up that the pills were indeed for Eric. If I ask for more, she'll know they weren't for Eric. It's also interesting that she said she needed something to get her mind. What? I don't know. Maybe she wanted the pills for herself. This suggests she wanted the pills for herself to calm her mind, which tells you she knows that a pill that she buys from Carmen Lauber is not bad. It's a whole bunch of pills that kill. Consciousness of guilt is evidence of guilt. Kouri had a guilty conscience. She couldn't talk to her father that night, not because she was overcome by grief, because she could not face the man whose son she had just murdered. We're going to play these clips right here now. This is when Kouri Richins is asked whether she's going to tell her children, whether she's going to talk to her children. Notice Kouri Richins' reaction in the moment. To this will be Katie Richins' reaction in the moment. Go ahead, Sky.
Where are your children now?
Asleep in that room. 2 are awake with their ear to the door. I don't want them to come out. Please don't make them come out.
We don't know. We went to bed.
Hey, Clint's here. He's gonna help. Where are my boys?
The kids are in
Where's my brother?
He's in this room.
No. Baby.
Kouri, is there a way we can relocate your boys upstairs?
Yeah.
Because there's going to be a lot of traffic.
Yeah, I'll tell her now.
Kouri Richins walks away. Katie then takes the boys upstairs. In moments of tragedy and profound sorrow, you not only comfort your children, they comfort you. Kouri Richins hides her face because she doesn't know how to react because she is not grieving. She doesn't want to see other people see her non-reaction. She's not grieving because she feels no grief. She just murdered Eric. You heard Deputy Wynn testify. She wasn't crying. Deputy Wynn's body camera did catch a moment of surprise. That's the moment he informed her that Deputy Wynn, was sending Eric's body for an autopsy. That's her surprise. She didn't tell anybody that night that Eric used fentanyl because she thought she would get away with it. She didn't think anybody would find out that Eric used fentanyl. And the minute Deputy Wynn said, "We're sending his body for an autopsy," that's her reaction. The 2016 empty hydrocodone bottle is immaterial. Eric had no hydrocodone in his toxicology results. The only other hydrocodone reference in the entire body of evidence before you is that investigators recovered on the first search warrant bag, like a Ziploc type bag, full of hydrocodone pills in the laundry room and the mudroom of the house. Perhaps Kouri Richins removed them from that bottle and staged the crime scene. This is also inconsistent with the notion, having those hydrocodone bottles in the house, pills in the house is inconsistent with the notion that Eric had a secret drug habit and was going to the street for illicit pain pills. And there's a baggie of hydrocodone in the house. Okay, there is no good reason these images were accessed the same exact minute that deputies departed the house the morning that Eric died. None. And there is, by the way, despite what defense counsel just told you, there is no evidence that Eric Richins sent these images. He sent an image of the Midway Mansion the night before that was accessed at the same time as these images. Sorry, he sent an image of the Midway Mansion the night before, but it was not the image that was accessed at the same time. The image that was accessed at the same time is the distance full view of the Midway Mansion, which makes sense in this context, not the image that Eric sent of the pile of rocks in front of the Midway Mansion. Details matter. We don't know who sent these images, but we do know that they were accessed on Kouri's phone at 8:29, the exact minute that deputies signed the log out of the house, and that whoever accessed them turned the phone this way to view them better. They also viewed the distant image of the Midway Mansion. Maybe she was celebrating the Midway Mansion. Maybe she was celebrating Eric's death. Either way, there is no good reason these images were accessed at 8:29. Kouri Richins minimized how Eric died because she needed to cover up her involvement in Eric's death. The worst minimization was the one to his father. After speaking on March 17th with the medical examiner's office, Kouri Richins told Eric's father, knowing this was not true, that Eric Richins died in part of COVID and in part of the same lung fungus that Jean's wife, Linda, died of. That is not only covering up her involvement, that is cruel. She covered up with the medical examiner. She pretended she didn't know what quetiapine was, even though she was prescribed it. She pretended she didn't know what acetaminophen was, even though it's Tylenol. And there is probably not a mother in the United States that does not know what Tylenol is. She pretended she didn't understand the word illicit. She has a master's degree. In feigning ignorance with Dr. Christensen, she was fishing for information to craft her defense. She was asking, was it injected? Did he eat it? She wanted to know what the medical examiners knew so that she could craft around it. She was really worried about the amount of alcohol. On April the 13th, Detective Woody told Kouri Richins that Eric died of fentanyl intoxication. Right after that, she tells Josh, oh, it was just a trace. Chelsea, it was just a trace. It was his lungs that were shot to shit. She is minimizing, deflecting, covering up. She is distancing herself from her murder. Manner of death on the death certificate is immaterial. It's a box we check. It's used for statistical purposes. They turn the information over to the Bureau of Vital Statistics. It's immaterial for this case. You determine the manner of death. It's murder, aggravated murder. Perhaps in a perfect world, the medical examiner would amend the death certificate, but you heard Dr. Ulmer. She signed it on June the 6th, 2022, when the investigation was really in its infancy. And she had one foot out the door. It was her best solution to finish her report before she retired. It is what it is. Bureaucrats. Eric did not ingest the THC gummy laced with fentanyl. When asked if she ate one that night by Deputy Wynn, it didn't seem like he did. Toxicology, there was no measurable THC in the toxicology analysis of Eric's blood or gastric. The THC that they collected on the April 13th, 2022 search warrant, right? The first search warrant. It was found in the cabinet above the toilet in the master bathroom. Wasn't there the night before. You heard Deputy David Pimentel talk about how he searched it. You could see his search on the body cam. It wasn't there. It was put there after Eric died. That's where most of the gummies were. There was also a package in the kitchen, which was never searched the night he died. But all the gummies were sent to the lab for testing. In fact, the gummies, lots of stuff was sent to the lab for testing. None of it confirmed any fentanyl. Brian Holden, he was a state crime lab tech that testified. Detective Haskell works the streets of Salt Lake City, drugs his whole career. Never seen fentanyl-laced marijuana. That's cover-up. That's misdirection. Kouri Richins' plan, if it wasn't a plan, to make money on the Midway mansion is not tethered to reality. Across her portfolio, she lost money, and she lost money on nearly every individual project. She even admitted, it's out of my league, but the margins are so insane that I had to pick it up and then figure it out. Ha, 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 help. That's ha, ha, ha with $3.2 million of other people's money. She is intensely ambitious. Her plan was not tethered to reality because she could not, with more money than she could even imagine, overcome the Corps of Engineers holds on this property. Not going to happen. She asked Eric Richins for input on how much it would cost to rehab the house. That's the text string right there. Read the whole thing. You'll see that she sold the Midway Mansion to him, not as a project they were doing, but as just a sale that she was brokering.
Okay, you clean that one, right?
Okay, ready?
Run.
See, I'm getting all three.
Cheers, boys.
Yep, come back in the corner with us. There we go.
Richard.
Richard.
Richard, yep.
Richard.
Look, Chachi's still going.
Oh! You were an Afghanistan warrior.
You are an Afghanistan warrior.
People grieve differently. There's no ancient artwork of that photograph. This book provides kind of three pieces of insight into Kouri Richins. The first is she wrote it, had it written, and published it in early 2023 when she knew that investigators were investigating her for the murder of Eric Richins. She promoted it. Her mother sent a book to investigators, all to deflect attention away from Kouri Richins. She also wrote it to make money. You see the emails, they're in evidence. She thought she would sell 100,000 copies in 10 months at $5 profit a copy. That is not tethered to reality. But it does provide insight in how desperate she was for money. That she would trade. She would trade on her sons and the death of her father to make money. The final things it tells you about Kouri Richins is that she wanted, as part of her facade, as part of her appearance of success, privilege, and affluence, she wanted to be an author. But she didn't write it. And you can see from her writings and text messages, Orange Notebook, the notes, the Walk the Dog letter, not only did she not write it, she's not a good writer. But she wanted to appear as one. The appearance was what was important to her. In defense's closing, when you strip out rhetoric that could be argued at any closing, anytime, anywhere, on any case, when you strip that out of defense's closing and you hone in on substance, the entire substance of the defense's argument is based around trying to explain the Walk the Dog letter. Kouri Richins is saddled with this letter and needed to craft the defense around this letter. It's obvious that the letter was written to get her brother to testify to a narrative that would explain everything. Let's unpack the letter in about 15 or so sentences, not with what Kouri Richins wrote, but with what the evidence shows. It's a translation from what Kouri Richins wrote to what the evidence shows. First part, here's what I'm thinking but you have to talk to Ronnie. He would potentially have to testify to this, but it's super short. What the evidence shows is this says, I'm thinking that if you tell Ronnie to testify to what I'm about to write, it will explain everything and I will not get convicted. Ronnie will need to tell this to my lawyer because I just made it up and it will have to come from him. Never mind that I was arrested 4 months ago. I need an excuse for Ronnie and Eric to be hanging out. Never mind that football season ended a month earlier. I need to explain the fentanyl, and fentanyl must be everywhere in Mexico. Never mind that Eric would have to fly with the fentanyl, and I later say that Eric would not fly with drugs for fear of getting caught. Never mind that I know this story despite Ronnie never telling me. I need to explain why everyone will testify that Eric never used drugs. This kind of happened once with THC gummies on a trip to Hawaii. Hopefully this is enough to corroborate my entire walk the dog story. I need to distance myself from fentanyl. These are my made up words, but Ronnie can make up his own words. If Ronnie does not say these things, I'm convicted. I need to explain why investigators never found a trace of fentanyl in my home. Never mind that it doesn't make sense that Eric hid the fentanyl after asking me to buy it. Don't get caught passing this made-up story along to Ronnie. That would be horrible. Tell Ronnie to keep the story short so that he does not mess it up. Since his conversation with Eric never happened, tell him that it was only 2 minutes long. Ronnie needs to do this so that I do not get convicted. I can then extract revenge on Eric's sisters. Remember, I just made this story up, so my lawyer does not know it yet. All the evidence in this case proves that Kouri Richins murdered her husband and the father of her 3 children, Eric Richins. There is no other rational explanation for the evidence. And despite all the evidence, Kouri Richins clings to the facade that has enabled her to get away with so much for so long. And despite all the evidence, Kouri Richins doubles down and blames Eric. She is intensely ambitious. See through her facade, check her ambition. Do not let her get away with murder.
All right. Next step. Brittany, if you would please swear in the bailiffs that will watch over the jury during deliberations.
Y'all raise your right hand. Do you affirm that you will take charge of this jury and take them to some private and convenient place where they may deliberate upon their verdict, allowing no one to speak to them nor to do so yourself unless so ordered by the court, and to return them to the court when they have reached a verdict or when so ordered, subject to the pains and penalties of perjury? Thank you.
Thank you. Ladies and gentlemen, a few additional instructions. If you want to read along, you can fast forward to instruction number 46. Four-person selection and duties. Among the first thing you should do when you go to the jury room to deliberate is to appoint someone to serve as the jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all members of the jury get the chance to speak. The foreperson's opinions should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict form on behalf of the entire jury. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into several sections, one section for each count charged. Each count has separate instructions. When rendering your verdicts, you need to make sure only one verdict for each count is marked. You may be asked additional questions about the basis of your verdicts. Remember, any response you give on the verdict form must be unanimous. Regarding jury questions during deliberations, these instructions should contain all the information you need to decide this case based upon the evidence. However, if you have a question or need clarification during deliberations, please write a note and give it to the bailiff. I will review it with the lawyers. We will answer your question as appropriate. This brings us to one of the more difficult parts of the trial for me personally. A jury in the state of Utah is 8 jurors, and there are 12 of you. We intentionally impanel alternate jurors to ensure against the unforeseen because things happen. Jurors fall ill, they suffer a personal or family tragedy during the length of the trial. Sometimes they simply don't follow my instructions and they get exposed to information that it's not appropriate for them to have. Because we can't see around every corner, we impanel alternate jurors to ensure that an emergency or other unexpected circumstance does not cause a mistrial. We simply can't try a multi-week trial without the help of alternate jurors, and for these reasons, the service and sacrifice of alternate jurors is just as valuable and just as deserving of respect as the remaining jurors. Moreover, the service of alternate jurors does not end when they leave the courthouse today. Rather, the alternate jurors are still subject to all of the court's instructions and restrictions, because if an emergency arises during deliberations, one or more of the alternate jurors may be called back to join deliberations at that point. We could not have expected that all of you would be so hardy and so diligent in following the court's instructions, and so we impaneled 4 alternate jurors. The alternate jurors in this case are jurors 9, 10, 11, and 12. If jurors 9 through 12 would please stand. An important instruction. This case isn't over. You're still impaneled. Please do not talk about the case. Please do not let anyone else talk about it to you. Please do not read, watch, or listen to anything about this case. And do not do any research of any kind about it until I call you personally to let you know that all of these admonitions are lifted. Thank you for your ongoing service in this case. Please rise for the alternate jurors. Greg, I can't see who's over there. Yeah, Greg, if you would let them out, I have a couple of extra instructions for each remaining. Thank you. Okay, please have a seat, folks. Members of the jury, as you deliberate, you may have questions. If you do, please remember, you can write a note, give it to the bailiff. I'll review it with the lawyers and we'll answer your questions as appropriate. Please remember, though, that the bailiff cannot answer any trial questions for you. Just as you have not been allowed to research or investigate matters on your own during the trial, you may not use any outside source to research or investigate any matter as you deliberate. No online dictionaries, no online maps, nothing outside the evidence presented in this case. We will provide for you in the deliberation room the exhibits. You may take your notes with you. You may take your copy of the jury instructions with you. We'll provide a copy of the verdict form. This case is now submitted to you for deliberation and determination of your verdict. Please rise for the jury.
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. I need one member of your respective teams at least to begin confirming with Brittany after we go off the record that we have consensus regarding the exhibits that have been admitted and will be going back into the jury room. If any disagreement comes up, let me know. We can handle it on the record. Ms. Nestor, anything further at this time?
Your Honor.
Mr. Bloodworth?
No, Your Honor.
All right. The court will be in recess. Thank you for your patience.
Okay, there we go. We got it. That's that. Well, we got a verdict clock up. I'll keep this room open for the verdict watch. We'll replay some testimony in this room while we wait for a verdict. Give me a second, I'll get that up. For those that wanted to watch the Afro Man civil trial, I am going to drop the link for that room in just 1 second. Let me see. Just thinking of some testimony that we've seen that was pretty good. My PI guy was something else, boy. Let me see. Wait a minute. I really liked his testimony. I don't know why, but I did. So especially when he pulled out that full neck brace. So a lot of people, I'm gonna put a poll up in regards to how long y'all think it's gonna be for them to deliberate. I'll do 2 to, because I'm thinking they have to like 4:30. They already had lunch. So I'll do 2 to 3 hours, which means that we'll get a verdict today. And then I'll do one option for tomorrow morning or tomorrow afternoon as far as the verdict. And that should cover all our bases for us. I also thought the detective's testimony was really, really good. In this case, on cross and exam, what's the name? Let me see. She has so many dang on days of trial. Oh yeah, here we go. Here go my boy. Man, when he pulled that neck thing out when the defense got up there, I was like, oh goodness, no. They stressing my man out. So live video, here we go. Let me get this poll up here. Okay, so there's our poll for that. Yeah, I really enjoy his testimony. He was like, hold on, Your Honor. I cannot keep my head. I was like, oh my goodness. Oh Lord, they didn't stress my guy out. He like, I got to get my stuff out. Crazy. It's definitely crazy. I'm sorry. I was saying that I put the link for the Afro Man civil trial in the chat for those that want to watch that trial. For those that want to continue to watch, rewatch Kouri's testimony, I do have the verdict clock is up. I will be checking in. I will be providing updates in regards to the verdict. But those that want to watch some testimony, I'm going to have that planned until we have a verdict in this case, guys. And let's do that.
Sir, what is your name?
My name is Todd Gabler, Gabler.
You appear to be recovering from something.
Yes.
Would you mind just at a high level explaining?
On January 13th, I underwent a 5-level PCLF. That's a posterior cervical laminectomy and fusion. My neck has been fused together with titanium rods.
Sir, are you taking any medication today that would affect your testimony?
I purposely did not take any pain medication today for the purpose of the clarity of my mind and my testimony to you today. I took Tylenol this morning.
What, sir, is your occupation?
I'm a licensed private investigator in the state of Utah.
Whoa, here we go.
How long have you been a private investigator?
34 years.
What, sir, is your investigative experience that is relevant to this case?
Well, over the course of 34 years, I have worked on approximately 100 homicide cases. I have been active in the trials of perhaps a dozen or maybe more homicide cases over the course of my career. I have extensive experience in a specialty in digital forensics, which allows me to examine digital devices, phones, computers, other things of a digital nature to uncover information that may have been deleted, destroyed, or altered.
Okay, we got something going on right now. So they back in the courtroom already. So let's see.
Part of the courtroom, Ms. Lewis, Ms. Nestor, and Mr. Ramos are in the courtroom with defendant Kouri Richins. As the 8 jurors were walking out and making their way, to the jury room, juror number 2 pulled Deputy Zag aside and handed him this note, and as she was handing it to him said, "I thought we were supposed to receive a factual stipulation before we got the case," or words to that effect. And the note says, "Factual stipulation, question mark." How would you like to respond, if at all?
When you were gonna read-
865 is the
Yeah,
exhibit.
it's regarding, I believe, the Burmester stipulation of fact that we had introduced, Your Honor.
But not read?
But not read.
Yeah.
May I direct them to it by number?
Yes.
I think that might be
Can we have a consensus about what the number is? Can we confirm? We'll look at it together. Katie, are you able to pull it up?
It would be 8-65.
If you would mind plugging in, we'll look at it together.
Sure. I don't know how a digital copy of that. I think it was.
Scott, if you wouldn't mind plugging in, we'll look at it together.
Yes, Your Honor.
We didn't provide Your Honor with a hard copy.
And we marked it with a sticker.
Yeah, it marked it there, so that might.
For whatever that's worth.
It should be on the screen now, Your Honor.
Yeah. Let's see. It's among the things we're sending back. Yes, Brittany?
Yes.
Okay, so I will just do my usual question, factual stipulation, question mark, answer. Please see State's Exhibit 8-65. Any objection, counsel?
No, Your Honor.
No objection. I had another question, just in the event they want to view a physical piece of evidence.
Like the gummies?
Yeah, any of it, a phone, I don't know.
Yeah.
Miss Gibson has custody and control of them. She knows that we may need to alert her.
Okay.
If they need it. So
Got it.
if that's a question that comes up, we would just have to get to Chelsea and she can bring it over.
We'll keep you posted. Ms. Lewis, Ms. Nestor, Mr. Ramos, any objection?
No.
Okay, that's what we'll do. Now, I'm about to go off the record, but I need a lawyer from each side to stay with the Scott and Katie of your respective sides and reach consensus with Brittany about what's going into the jury room before you leave the courtroom.
Yes, sir.
Even if the lawyer doesn't do any talking, I just need you to stick around. Thank you. Very good. We're off the record. Thank you.
Okay, so they off the record. Like I said, I'll continue to keep watching, seeing what's on there, and we'll kind of go from there. Let's go back to our testimony.
I can't really think of anything else that is sort of a 30,000-foot view of what would be important to the jurors in this case regarding my experience.
Well, sir, of those 100 or so homicide cases, how many have you worked for the defense?
All of them. I have always sat on that side of the room, standing in between the state and a defendant.
And you mentioned, sir, that you testified about 12 times. Have you ever testified for the state?
Never.
Did there come a time shortly after Eric Richins' death when the estate of Eric Richins hired you as an investigator?
Yes.
Do you recall about when?
I was first contacted by Crystal Bowman Carter, an attorney. I believe that would have been early to mid-March of 2022. She asked that I contact her client, Kouri Richins Benson, regarding the death of her brother, Eric. She gave me a broad sketch of what she knew about what had occurred regarding Eric's death. And it was a very short conversation, very professional, very to the point. And then it was a few more weeks before I first spoke with Katie and Clint. That's Kouri Richins Benson and Clint Benson at their home in Summit County. That was April the 1st, 2022.
And was that engagement to investigate the death of Eric Richins?
Well, that was part of the investigation. I was under the impression that I had been hired at the instance of the filing of a lawsuit by the defendant in this case against Katie for the trust money and the control over the trust that Eric Richins had created.
And to be clear, the lawsuit involved Kouri Richins as trustee.
Correct.
And when you're interacting with Kouri Richins, it is in her capacity as trustee.
Correct.
Or personal representative of Eric Richins' estate.
Correct.
What, if anything, sir, did you inform at that meeting with Clint and Katie? What, if anything, did you inform them of how you conduct investigations?
Right. So I talked with them about some of the various facets of an investigation, how it would proceed. I've already talked to you about the qualifications that I have in digital forensics. And so I talked a little bit about that, about the need to get a hold of phones and computers and other things that would have evidence of either a wrongful death or some mismanagement of finances that was being alleged in the case. So for all my clients, it's basically the same speech. You're hiring me to find the truth. The truth is sometimes very difficult for us to accept. I've often said that the truth is half what you most fear that it is, and half what you most desire it to be. And you cannot separate those two from the truth. I told them that they would have to accept the truth about what happened to their brother, no matter what that truth was. If he took his own life, they would have to accept that. If someone was responsible for his death, they would also have to respect my investigation and accept that truth. They agreed.
Sir, from that point forward, did you conduct an independent investigation?
I did.
Sir, who paid for that investigation?
I was paid by Clint Benson, but my understanding is that the legal sort of line of authority for which I was engaged was for the estate and Kouri Richins Benson as the personal representative.
Did you bill them at your customary rate?
I did. I continued to bill them at the rate that was established at the time of my engagement, even though my hourly rate increased during the course of my investigation. They enjoyed a lower rate essentially because of the time that they engaged me.
Did anyone else pay you for your investigation?
No.
Did anyone from the Summit County Sheriff's Office direct your investigation in any fashion?
No.
Did you conduct your investigation entirely independent of the Sheriff's Office?
Yes.
Did you provide information from your investigation to the Sheriff's Office?
Yes, on many occasions.
And before providing it, did you receive approval from your client?
Yes, that is part of the standard operating procedure. It would be a crime for me to, under the Utah Private Investigators Regulation Act, to have any file materials go to anyone else but my client without my client's permission. So the standard course would be that I would discuss my findings with my client, and we would discuss handing that over to the sheriff's office. In every case, information that we thought important to the investigation was handed over, and there was no event, no occasion upon which we decided not to turn over something to the sheriff's office. Full disclosure. That was the rule.
Sir, was that flow of information one way from you to the sheriff's office?
Oh, yes, very much so. I initially tried to get the 911 audio call that the defendant in this case had made, and the sheriff's office denied my request under the Grandma law. I appealed to the county administrator for Summit County. She also denied my request. So, yeah, it's common for police agencies to be one-way streets.
So it was not uncommon for your request for information to be denied?
Correct. My investigation proceeded regardless of whether they were providing me any information or not.
Did you have contact with the Summit County Attorney's Office before Kouri Richins' arrest?
No.
Did anyone from the Summit County Attorney's Office direct your investigation in any fashion?
Never.
Did you conduct your investigation independent of the County Attorney's Office?
Yes.
On June the 15th, 2023, after Kouri Richins' arrest, did you receive a subpoena from the County Attorney's Office for your investigative file and any forensic data that you had collected?
I did.
Did you provide that material to the county attorney's office in response to that subpoena?
I did. I produced 2 hard drives. One contained what I call the logical and physical investigation file. That would be interviews, audio recordings, photographs, videos. That was a fairly large file. And then the second hard drive that I provided a few weeks later was all the computer forensics, the digital forensics, the examinations of the C&E computer, a clone of Eric's iPhone, and some other digital data.
Did you begin your investigation with a hypothesis?
Yes. A number of hypotheses appeared clear to me in this case. My investigations are hypothesis testing exercises. That's just a fancy way of talking about something that we all do every day. We look at a situation and we evaluate what that is. Is there evidence that supports our hypothesis that that is what it is? Well, if we're looking at a red light, our hypothesis may be that traffic should be stopped. And we look around for data to verify that hypothesis, that indeed there are cars that are stopped at that red light. In this case, it was clear to me that two hypotheses needed to be looked at. Number one, Eric took his own life as a matter of accidental overdose. Number two, Kouri Richins surreptitiously had Eric ingest a massive amount of fentanyl and killed him. So, as the case proceeds, and I see new data, I see phone data, I see computer data, I interview people, I look at documents or things or other devices. All of that data gets fed into one of those two hypotheses, both of those hypotheses. Does this confirm it? Does it deny it? Does this evidence make it more likely that this hypothesis is true or less likely that this hypothesis is true? Does this evidence preclude the possibility of one of the hypotheses being true? So that hypothesis testing continues throughout the investigation. And sometimes a permutation of the hypothesis comes along. We have to change the hypothesis just a little bit to allow some of the data to fit that hypothesis. Not large permutations in this case, pretty straightforward, two competing hypotheses.
Sir, you just mentioned that in testing your hypotheses, you conducted some interviews.
Yes.
What, sir, is your process for conducting interviews?
So my process is to always have a recording device active for any of my interviews whenever possible. This eliminates any possibility for me to be biased or unclear in my reporting of what was said during that interview. It also protects me in a liability scenario if someone were to allege that I had done something improper or had offered them material for their cooperation, anything like that. That would all be protection for me by recording that contact. So that is the primary objective of documenting an interview. Later on, when I report it, when I summarize that interview and in writing, because it's hard to get a lawyer to listen to an entire interview. There's some difficulty that they have with that. So they need a summary sheet about what the interview was about. And I type those up based upon the recording that I made. And I typed up those later, or I may have an agent type those for me from the recording. And then I'll review the report and sign off on it. And then it'll go into the file. So that would be my process with respect to an interview, all interviews.
Approximately how many interviews did you conduct in this investigation?
It depends upon your definition of an interview, I guess, but 45, probably, somewhere in that department. 40, I guess what I could say, 40 to 50 to be safe.
And in those interviews, did you identify yourself?
Oh, yes, always. There was no occasion in this case where I did not identify, give people my true identity and who I represented.
And did you record those interviews?
Yes. I think there were a couple of occasions where I could not get a recorder fast enough. But other than those couple of occasions, they were all recorded.
Who, for example, are some of the people that you interviewed?
I interviewed friends and associates of Eric's, I interviewed friends and associates of Kouri's. I interviewed a number of people involved in Eric's business and personal life. I interviewed family members, both the Richins family, and I attempted to interview family members of Kouri's family, but was not successful in gaining their cooperation for an interview. So that was generally who I interviewed.
And was the purpose to test your hypotheses?
Well, yes, I'm interested in getting those interviews done from as many people as I possibly can from both sides of the camp, so that I can get the largest possible data set to feed into that hypothesis testing scenario.
Did you pass your interview recordings and written reports along to the sheriff's office?
I did.
Sir, as part of your hypothesis testing, did you analyze Kouri and Eric Richins' cell phone billing records?
I did.
How did you obtain the records?
Eric and Kouri's cell phones were being paid by C&E Stonemasonry. They were Verizon accounts. And I obtained the the billing records from C&E, from Ali Wright, with the authorization of Kouri Wright. There were 2 productions of telephone records from C&E. The first one was for the period of January 2022 through May of 2022. The second production was May of 2022 through February of 2023.
In that January of 2022 onward time period, what types of information were you looking for in the billing records?
So because the billing records don't really offer content, that is to say, it's not you don't get to see text messages or what the text message was, you do get to see the numbers that were connected to Kouri and Eric's phones. So we first of all decode that number to a name. We try and figure out who that is. And we fill in every instance where that number occurs with that name. And then we begin to count the total number of contacts with that phone number. So for example, we would see the highest number of contacts for Kouri's phone to her mother. Not an unusual circumstance that someone would be close to their mother, and that would be the highest number of contacts on your phone. So that was the procedure that I was initially interested in, was the weight. We call that the weight. So what is the weight of that person on the other end of the line? Kouri's mom was a high weight because there was a high number of contacts. And so I'm interested in how many times you contact that person. Occasionally, I'm interested in what time of day you typically contact that person, and the type of contact, whether that contact is by text message only or by voice and text. That changes the character of the person on the other end of the line.
Sir, did you pass your analysis of contact weight along to the sheriff's office?
I did.
Was there any particular contact weight that caught your attention?
Yes.
What contact did that involve?
It involved the contact with Carmen Lauber. I noted immediately that there were many hundreds of text messages between the two from the initial data set. That was January of 22 through May of 22. There was a very heavy weight. I don't recall if she was the second or third weight, but it was very close. The only two people that I recall that were ahead of Carmen on that weight was Kouri's mom and Eric. So that was the one that stood out to me. There were others that I investigated, but that one was of particular interest to me.
And to be clear, that involved the weight of contacts between Kouri Richins and Carmen Lauber.
That is correct.
Did that contact weight cause you to investigate Carmen Lauber?
It did.
What did you determine?
Well, it was immediately apparent to me that Carmen had a very extensive criminal record involving drug use and potentially drug sales. I noted that Carmen had a dirty urinalysis, meaning that she tested positive for prohibited drugs in her drug court around the time of Eric's death. I was very concerned about the high number of contacts and the criminal history for Carmen, and I alerted the sheriff's office about that.
As part of your investigation, did you search the Richins' home?
Yes.
When did you first search it?
I believe it was May the 8th of 2023. That was the day that it was released by the sheriff's office. It was an estate asset. Kouri's lawyer, two of her lawyers from Ray Quinney Nebaker, had showed up as soon as the sheriff's office had departed. And I had arranged for security to stand watch at the house after the sheriff's office released that. So I engaged in a conversation with counsel who wanted access to the home, and it was eventually agreed that one of the lawyers would accompany me on an inventory of the property, all of the assets in the house, all of the items in the house and the detached garage. And so that lawyer stayed for a couple of hours and then left. I never saw them during my search of the property again. I continued to search the property for 4 or 5 days. And then that was the end of my contact with the house initially.
And what was your process for searching and documenting your search of the Richins' home?
Right. So GoPro video, chest mounted, typically, sometimes mounted on the head, and a backup audio recorder just in case something happens to the camera. At least I've got an audio recording of what I'm talking about, where I'm at, what I'm looking at. So that is the procedure for documenting those. There's also photographs that are taken. There are also, with respect to documents, I scanned with a scanner many thousands of pages of documents in this case from the detached garage office. So that was the general procedure for being at the house. There was at least one occasion that I can think of where I was called over to the house and I didn't have my camera with me. So my video camera. So I used the audio recorder and my camera on my cell phone to document things. I think that was in 2024. So with that being the only exception, that would be my process.
And was Clint Benson present at the home whenever you searched the home? And I guess by present, I mean in the home, not necessarily leaning over your shoulder.
That is not an easy question to answer because my focus was not on Clint Benson. My focus is on the things in front of me. I was never in that house without Clinton Benson's authorization. I was never in that house without Clint Benson being on his way. So if he wasn't there when I got there, he was on his way there. And so he would join up later. It's possible during the May searches that Clint had left the house while I was documenting things in the house. I think that was particularly true of the detached garage office, where I was spending maybe 8 hours in a day just scanning documents, just feeding documents into a scanning device. So I think Clint was likely not there during that.
He was generally there?
He was generally there, I would say so, yes.
And you were recording with your GoPro the whole time?
Yes, with the exception I noted, yes.
Did you ever remove, well, other than your recording equipment, cameras, audio, GoPro, all of that?
Just an update, verdict clock is at 40 minutes of the jury deliberating. I'm assuming that at this time they just have a foreman at this point in time, but I'm gonna continue to watch and monitor it. It looks like the judge is going to be checking in with the jury at 4:30 to decide they want to continue deliberating or not past 4:30. I'll let you guys know.
Did you ever bring anything into the house?
No, I did not.
Did you ever remove anything from the home?
Yes, I did.
What did you remove from the home?
So during my May searches of the house, and in particular in the detached garage office, I encountered a number of documents that had Ray Quinian Nebeker letterhead on the top. And they were either communications between Kouri and her lawyers, or they were billing records from her lawyers. That would be improper for me to read or possess. It would be unethical. I placed these documents into a manila envelope. And as I encountered more of them, I would simply grab a hold of them and put them into the manila envelope. And at the end of my May search, I took that envelope to the office of Ray Quinian Nebeker and handed it over. There were other things that I removed from the house. Sort of the general category of the kids, the boys' things. The boys had requested a few things. I believe Child Protective Services or someone at DCFS had requested that we get documents that pertain to the boys. And I believe there were some other documents that I removed that were personal documents that were now the property of Katie Richins Benson. These documents involved vital records, birth records for Eric, other vital documents that, we would generally safekeep for ourselves. And I turned those over to my client. I'm trying to think if anything else was removed. Any item that I considered to be evidence was removed by the sheriff's office, not me.
So if you came upon something that you considered to be evidence, how did you handle it with the sheriff's office?
I don't think there was a standard approach. I only recall a few occasions. I think the first couple of occasions I may have contacted the sheriff's office directly, either Lieutenant Hemingway or I can't recall the others. And then on one occasion, I contacted Travis, the investigator with your office, and then subsequently spoke to the sheriff's office about removing an item.
And is it your understanding that the sheriff's office would then get a warrant and come to the house to seize whatever item you thought might have evidentiary value?
Yes, I was there for one of those occasions.
Thank you, sir. I don't have any further questions.
Thank you.
Are we gonna take a break before we go forward?
You tell me. Would you like a break?
Could we have
It's up
just
to
a
the
few
jury,
minutes?
No
whatever
problem.
they want.
You know what? Let's let you stretch your legs. We'll take a restroom break. The witness asked for a break. We provide a break.
All right, jury.
Mr. Gabler, watch your step there. There you go. Mr. Gabler, may I ask you a question?
Yes, sir.
Would you like the opportunity to use the restroom?
Yes, sir.
Okay. I'm sure you know this, but
Yes.
you cannot speak to anyone during
Yes.
the break. All right. If is 10 minutes enough time, sir?
5 is plenty.
All right, we'll say 10. We'll be off the record until 3:40. Thank you.
Well, I don't know, guys. I think that some of this stuff, like I said, every time that they had something in the house that they needed, that they found, that this detective found, he done did all the work. This PI. Hey, Phil, welcome in. Yeah, this PI done did all the work for everybody. So I don't know what you do with that because he done did it all. He done definitely did it all on this case. Yeah, the kids is out here on spring break. Yeah, we don't have no TiVo time. All our TiVo time is gone. No TiVo time. We are live up in the courtroom. That's okay. That is okay. So he probably gonna be on here for majority of the time because they don't have really a lead detective. He did do it all. He got the phone records. Kouri should have never filed a lawsuit or tried to go against this trust, because as soon as she thought that she was about to go against this trust or do something with this trust, what they did is they was like, oh, you want to sue us for this trust? We about to figure out every way possible to not get you, for you not to get any of this money and fight this off. That to me is what happened. Now, I'm not saying that they wouldn't have investigated Kouri later, because it was already the sisters. She was sending letters 2 weeks later talk about she did it. So I'm not saying that that they weren't going to investigate her, but she sure gave them the ammunition they needed in order to, hey, okay, let's get busy. Let us get us a private investigator. The police officers are not moving fast enough. Let's get on it. And I mean, let's get on it right now. Yeah, and I'm not, and we gonna go, and she about to cross-examine him. I'm really surprised that it was that short. As far as his direct. So maybe they got another detective that's gonna come up, because I know that, from my understanding, he is the one that when they found that not the walk the dog letter, when they found that other letter that they found in the kitchen cabinet, because the evidence technician kept testifying to, they had to keep coming back. They kept coming back, getting more evidence, and each time he was the guy kept calling them like, okay, we got this, we got that, we got this, and so they could protect the chain of custody. They would contact the crime scene technicians, and the crime scene technicians would come out there, and they would, after they get a subpoena and a warrant saying, hey, letter in the top right hand cabinet, they would write the subpoena and a warrant for that, and then the crime scene technician would come in there and get it. And the way that they were able to obtain where certain things that may be potential evidence was at is through this detective. His PI. Let me say PI. Through this PI. So I find that, and mind you, the only people that had access to the house is Eric's family. Because she didn't have access to the house at this point in time. So, I mean, was this really stuff that was there? Do they have the handwriting analysis, man, did not show that was Kouri's handwriting on anything. They haven't, unless they're going to bring that person in later once the letter comes in. But even the same way that they got that letter in that she did at Sedona. Yeah. But they the ones kept calling. He the one that kept calling back, and I think that the family had a lot of involvement. I mean, I'm glad that they were involved, but I just really don't know if it kind of tainted the investigation. Susie said, everyone sees the complaint that the sister and the family are out to get Kay, but if you were really not loving, if you were a tight-knit, look, I'm changing what you're trying to say. If you were a really tight-knit, loving, moral family, wouldn't you do everything you could to bring the truth out? Yeah, I think so. I think that I guess my thing is that, I mean, I guess two things can be true. In my opinion, I agree with you. I do think they were heavily involved. I'm not mad at them for being heavily involved. I'm kind of like disappointed with the police department there in some ways. I guess that's where I'm getting it at. Like, I don't think this PI investigator should be billing the police department, wherever they stay at in Utah. He needs to be billing them. That money needs to go back to the trust fund for whatever work he did, because if the officers were just doing their job and actually investigating everything thoroughly, I mean, he wouldn't have had to do all of that. So I do think that the sister and them, they were overly involved in their brother's life. I still do think that. I do think that, but you know, however they move is however they move. Yeah, because if it was my family member, I would definitely be, if I knew, if I had knowledge. Donna says, Susie, I agree. And Morel said, it's me. Oh, most definitely. Let me see. And Donna, I don't find it all that off-putting like some. It also does not sound like they would be out all that much money if Kay was still in the pit. Remember, they are trying to protect kids. Yeah. Yeah, I think that they knew a lot. Kind of like what Bryce, the best friend, was kind of saying to Kouri. Like, Eric was probably never going to say Kouri did good things. He probably only went to his sisters and them to complain about what Kouri did bad, right? So, you know, when your loved one is being mistreated, even if they keep going back for the mistreatment, you start forming your own bias with the person that you have been told has done some harm or damage to your loved one. So I know, I can see why they're in the position that they're in and why they did what they did. I just wish the police would have did more. I just can't see them spending this much money and effort to just pin it on the girl. I don't think that they spent that much money to pin it on her, Susie. I hope I know they spent a lot of money. I think they did just what they went into it, just with what the PI said. Look, you may not like the results of this road that we about to go down. Do you want to go down this road? And they said, yeah. And even when they went down the road, remember the PI said that he could only turn over or disclose information once they gave him permission to disclose or turn over that information. So there's that. So that's also something that to think about when we looking at this. So I guess they didn't really have to turn over the information, but in the same token, like if somebody has done harm to somebody that you love and now you have that information, of course you're going to turn it over, right? So that was just a given. But it don't seem like they like Kouri a lot at all.
Oh, all right, very good. We're ready for the jury.
Did they bring the jury back in? Oh, she just standing up here. Let's see what she gonna do. How she gonna cross-examine him? It's like the cross-examination be taking longer than the direct. That's how you know when they losing the case, because they got too much to prove.
Please have a seat. Thank you. All right, folks, have a seat. Thank you. All right, Mr. Gabler, you're still under oath, sir.
Yes, sir.
Ms.
Please,
Nestor,
the court.
please proceed.
Good afternoon, sir.
Good afternoon, Ms. Nestor.
I don't believe you and I've ever met, but I am Kathy, and I'm Kathy Nestor, and I'm one of Ms. Richins' attorneys. So it's nice to meet you. So I want to just kind of start with a basic observation, but get crystal clear. You are not law enforcement, correct?
That's not me. Her microphone or something is not on her. They don't have their microphones on in the courtroom.
Correct.
Okay. And the rules and ethics and expected practices of private investigators are significantly different.
They may get that information out on
license law.
cross-examination. how much he get paid an hour and all that stuff. I mean, they paid the
Don't know that I
forensic
would agree
accountant
with that in every
$200,000.
circumstance. A private
It's not me
investigator,
talking over it.
when he is hired by
The
a
microphone
lawyer,
not on.
is bound to all the ethics that lawyer is bound to.
Okay.
So,
But for
But-
example, you don't have to go get a warrant to go look at a house.
well, right, that's the state action distinction.
Right.
Yeah.
Right.
I'm not a state actor.
Right.
I've never been a state actor.
Right.
I will never be a state actor.
Oh, y'all can hear him?
So if you
I
want to
can't
go
hear.
search a house for 6 straight days and look at thousands of documents,
Mhm.
you don't need to get a judge to give you permission to do that, right?
No, I got the permission of Kouri's lawyers.
Oh, I had my thing muted. My bad. I rewinded it back to the beginning of it just in case I was talking and she was talking. My bad.
Please have a seat. Thank you. All right, folks, have a seat. Thank you. All right, Mr. Gabler, you're still under oath, sir.
Yes, sir.
Ms.
Please the
Nestor,
court.
please proceed.
Good afternoon, sir.
Good afternoon, Ms. Nestor.
I don't believe you and I've ever met, but I am Kathy Kathy Nestor, and I'm one of Ms. Richins' attorneys. So it's nice to meet you. So I want to just kind of start with a basic observation, but just to make it crystal clear, you are not law enforcement, correct?
Correct.
And you've never been law enforcement in your whole life, right?
Correct.
Okay. And the rules and ethics and expected practices of private investigators are significantly different, would you agree with me, than those that apply to licensed law enforcement?
I don't know that I would agree with that in every circumstance. A private investigator, when he is hired by a lawyer, is bound to all the ethics that lawyer is bound to.
Okay.
So,
But for
But-
example, you don't have to go get a warrant to go look at a house.
well, right, that's the state action distinction.
Right.
Yeah.
Right.
I'm not a state actor.
Right.
I've never been a state actor.
Right.
I will never be a state actor.
Right.
Yeah.
So if you want to go search a house for 6 straight days and look at thousands of documents,
Mhm.
you don't need to get a judge to give you permission to do that, right?
No, I got the permission of Kouri's lawyers who represented her to do that.
And you also got the permission of Clint Benson, right?
Yes,
And in fact, Clint gave you a key,
yes,
and you had that key to use at your discretion.
yes.
And there were times when you would go to the house and Clint was not there and you would let yourself in, right?
I believe that my testimony covered that, and that was that Clint was aware that I was there and he was either on his way or there with me.
But you agree with me, and you have videos, I believe, that back this up. But there were occasions where you would go to the house, Clint was not there, you'd use your key and you'd go in.
Yes,
And there were occasions where you would be spending hours and hours and hours in the office. Because I've
Yes.
watched all the videos,
yes.
and you would be there alone without Clint anywhere around you.
Yeah, I don't need supervision, counselor. I was
Perfect.
conducting an investigation, independent investigation, and he had given me the key, trusted me with that, and I was authorized to enter the premises at will.
Right. So if he got on the stand and said you were never doing anything outside his eye, that would be false.
Well, from his perspective, he had knowledge of my presence there, as I have testified every time I was there.
Fair.
So from his perspective, it may look different.
Do you agree with me, sir, that there's hours and hours and hours of video of you alone in that office going through things?
I think that I've already testified to that.
Okay. Now, you were not permitted access to the house until after Kouri had been arrested, right?
No, that's not correct.
You got in the house before she was arrested?
No, that is not correct.
Okay, help me out.
The house was released by the Summit County Sheriff's on the 8th.
Okay.
That's what gave us, that was the trigger, not Kouri's arrest. It was the end of their search that triggered our access to the house.
Okay.
The police were executing a warrant.
Do you know when Kouri was arrested, sir?
I don't recall the exact date or time.
Would it surprise you to be the day before May 7th?
Okay.
All right. So
Objection, not a foundation on that.
Was
Would
it
you
May 8th?
re-ask the question, Ms. Nestor?
sorry, was it May? Would it surprise you if it was the same day, May 8th, that you got access to the house?
It would not surprise me since I do not recall.
Okay. And during the time after Eric's death, but before Kouri's arrest on May 8th, did you ever go inside the house for that entire year?
I'm sorry, could you ask that again?
Sure. During the time between when Eric Richins died on March the 4th, in the early morning hours of 2022, and May 8th of 2023, were you ever inside the house at any point in between those times?
No, never.
Perfect. So the first time you ever got in that house, over a year had expired since Eric had passed.
Yes.
Okay. And you mentioned the police had executed a search that day before they released it to you, right?
Yes.
And do you know how many times prior to that the police had searched that house?
No.
Okay. And then you've also testified here, I think very honestly, that on repeated occasions, you notified the police, hey, there's something you missed. You might want to go back to the house and find it again.
I mean, I'm not going to adopt your characterization, but it is true that I called them back to that house when I discovered something that I thought was evidentiary.
How many times?
Oh, I don't know, 4, 5.
So on at least 4 to 5 occasions,
Yeah.
you found things the police had missed.
Yeah. Oh, that's been my experience throughout my career.
And you
The
told
police
them,
never
sorry.
get everything, ever.
Right. Well, I'm
It's
not going to
true
argue.
in every case I've ever handled.
Sure, not going to argue with you on that one.
Yeah, it's true.
So they come back because you call them and say, hey, I found something, come back. Here's where it is.
Yep.
And they know you're doing that. They know that you have full access to this house, right?
I don't know what they know. I can't answer that.
Well, you're calling them every time you find something.
Well, what opinion they formed in their mind is not within my knowledge.
Okay, fair. True, you called them every time you found something.
That I thought was of evidentiary value in their investigation.
And did
True.
any of them ever say, you know what, we're good, stop calling us?
No, I don't recall that at all.
So then the converse of that is they encourage you to keep doing that.
Well, no, that is not the converse of your hypothetical, and I do not agree with your assessment.
Okay. Did you feel like you were helping them?
I was following the instructions of my client to turn over anything I thought was relevant to the criminal investigation. This is not my case. My case is in the civil court. Anything that we thought was of value to the criminal case, we turned it over.
And the police were happy with that.
I don't know if they were happy or sad or distraught. I have no idea as to their emotional condition.
They sure never told you to stop.
The police never directed me to do anything, and if they had told me to stop, I would have ignored them.
Okay. So you could go in without a warrant, find something, call them, tell them to get a warrant, and they'd come get it.
I think that's an oversimplification and a vilification. I had permission to enter those premises. I had every right to be there. I didn't need a warrant. I'm not a state actor. I have the permission of the property owner. So I don't agree with your characterization.
When the cops would show up, did you point out what you were showing them? Were you usually there?
No, I was there on one occasion when the police showed up. They executed warrants when I was not there.
Okay.
Yeah. So I only remember one occasion where I found an audio recorder in a dresser drawer that they then recovered by warrant.
And you waited around and pointed it out to them.
I did.
Okay.
Yeah, I never touched the device. Okay. So yeah, I would have, I don't know if I pointed it out. I think what I did was on that date, when I saw the recorder and recognized it for what it was, which is not easy, I just immediately withdrew. I left my audio recorder going until the police arrived. I don't recall pointing it out. I recall describing to them where it was.
Okay. Thank you for that clarification. So then there was one occasion where you found something that was a letter purportedly written by Eric called the My Princess letter. Do you remember that?
I remember a baby cakes letter. I don't know if I remember My Princess. Is that the same one?
That's the one.
Yes.
You remember finding that letter?
August the 9th of 2024 is when I took a photograph of that, but I found it on May the 10th of 2023 during my search of the residence.
So when you found this letter, at some point, did you move the location that you found it from?
I don't recall ever moving the location. On the video, you will see me find the letter on May the 10th of 2023 when I'm in the bedroom, and it is located in the bottom drawer of Eric's side of the bed, the bottom drawer of the vanity. And I looked at it. I didn't think it was relevant. I put it back down on the drawer. On August the 9th of 2024, when I photographed it on the bed, I do not recall if that letter was on the bed or whether I went and retrieved it from the vanity. But there is video. The August 9th, 2024 was the episode that I described that I was called over and I didn't have a video recorder. So I was recording by audio and this is the same date that I recovered the audio recorder. So the letter was also photographed. And then later, I think it was taken by the police. I don't know, but.
Let me stop you for just a minute.
Okay.
You left the letter on the master bed, correct? For the police to find.
I left the letter on the master bed. I didn't know that the police were going to come for it.
Okay. And they ultimately did, correct?
Well, ultimately, I don't know because I wasn't present, so that's beyond my knowledge.
Isn't it true that you moved other things around in that house often?
No, that is not true.
Did you move a computer that you located in the office?
I don't recall moving a computer in the office, but I did not move it out of the office.
Did you put it in your Tesla?
If you are talking about the C&E computer, I did not find it in the office. That is not how that worked.
Okay. So you found it where, sir?
I found it in possession of my client who had taken it, who had been given it or taken it from Becky Lloyd. So my understanding of the pathway of the C&E computer that I examined was that it was picked up by Becky, who lives nearby and works for C&E. The C&E computer, she then went to get business files off of it. I talked with her about this. I filed an extensive report regarding my interview about the computer. And then before I could get up to Francis to get that computer, I lived at the time 250 miles south of Francis in Washington County. So it takes me a while to get up to Francis. Before I could get up to get that computer, I believed that my client had already secured it, and so I went and got it from her.
So Becky got the computer from the house after Eric died,
Yep.
right?
Correct.
Then Becky gave it to Katie.
Correct.
And Katie gave it to you.
Correct.
And then all of that, no law enforcement ever put hands on it.
Correct.
And at some point you took it back up to the office to go through it?
No.
Well, there's video of you going through that computer in the office.
I suppose that I may not have remembered that I went through a computer in that office, but the C&E computer was processed at a location in Midway, and I recall that there was what I want to say is an obvious missing hard drive location. I could see the outlines of a hard drive that had been in place in that computer. I became suspicious that the hard drive had been removed prior to me getting to that computer. I later sourced that missing hard drive to an upgrade that was performed by a computer company at the request of C&E. The hard drive contents were transferred to a solid state drive, and I did locate that inside the computer.
Okay. So can we play for the witness only clip TG10?
We're going to play without sound, right?
Yes, sir. No sounds necessary.
Okay.
I'm going to kind of wait till we get to the computer part. I'm sorry, that's the wrong one. Can we bring that one down? That's the next one. We want to go to the one right before that, which is 173. It's GXO 10073. Do you have that one? Okay.
Excuse me, I'm having difficulty keeping my head up.
Oh, no worries. Whatever you need, sir, to be comfortable. Take a minute. Yep, I'll go back to that. It's going to take her a minute to upload that, Your Honor. So we'll get to that. You don't recall putting electronics, documents in your Tesla and driving away from the house?
Oh, I remember that, yes. But that was not the C&E computer.
Okay, what computer was that?
I don't recall. I'd have to see the video.
So
That's why I make them.
You removed a laptop from the office and put it in your Tesla and drove away with it?
I don't recall that. No, I do not. That would have been my, if there was a laptop in that office, it was mine.
Okay, well, we're going to pull it up in just a minute. I'll help
Fantastic.
refresh your memory.
Yeah.
Also, you mentioned earlier that you didn't take, other than the vital records and the attorney-client privileged records, that you didn't take anything else out of the home. That's not entirely true. You also took a safe out of the house?
Yeah, I described that by report, but that house, that safe was returned.
Okay, so you went into the house with your own key, correct?
Yes.
You went into the family, I believe is in the master closet, is that right? Where was it?
Yes.
You picked it up, took it out of the house, and put it in your Tesla.
Yes, I believe I did that at the request of Clint Benson.
Okay.
Yeah.
And then you drove it to a locksmith
I did.
and you busted into the safe.
I did not bust into the safe.
Well, he did.
He bumped. He used a technique called bumping. It's the movement of the door and the frame of the safe that allows it to come open.
Okay, but you didn't have a combination.
I don't know if that was a combination. I thought there was a key to that one.
It was forced open with a hammer, right?
I think it was a rubber mallet and it was dropped onto the ground.
Okay.
I think that's what eventually got it opened, was that it was dropped onto a flat surface.
And when you were doing that, there's no law enforcement there, correct?
I don't need law enforcement to babysit me.
Okay. And you open it up and there's clips from guns in there, right?
I would have to go back to my report to recall exactly what was in there.
But you handled it with your bare hands, no gloves.
I did.
All right. And I'm sorry. You also found an unusual residue in the safe. Do you recall that? That you touched with your fingers?
I don't recall that.
All right. We'll play that in a second.
Fantastic.
I do think we found the video of the laptop. So can we queue up for the witness only GXO10073?
Yeah, that's my laptop. I am scanning into my laptop the documents that I am going through at the office. That is my laptop.
The black one?
Yes.
Okay. So you're scanning all the documents you're finding in the office and then loading them into your laptop.
Yes.
Okay. All right. And again, Clint Benson was not present when you were doing any of this.
Yes, that is my testimony on direct.
Okay. Now let's go to the one of the safe. Can you pull up the clip 100055? Hold on just a moment. 1055. See if you can find that one. Sorry. I think it might be under the impeachment documents. Nope. Okay. All right, we'll get the safe one up to refresh your memory about that residue. You don't remember touching some residue and filming it and asking the safe breaker if that was unusual to find residue on a safe?
I don't recall that. I would have to refer back to the video that I made of that for just this purpose.
Okay, no worries. So my understanding is you were at the house. There were some times before you got access to the house while Ms. Richins was still living there that you would sit outside her house and observe the house while she was in it. Is that fair?
It is not fair. That is false.
You never did that?
I never sat outside her house and watched her. False.
Not on March 9th of 2023?
Correct.
Not on April 12th of 2023?
Correct.
But you did put trackers on their cars, is that right?
I did.
And that's a secret device that you put on someone's car so you can follow where they're going without their knowledge?
So GPS tracking devices are generally covert, and there's good reason for that. I put GPS devices on Kouri's vehicle and two of Lisa's vehicles, one of which was being used by Kouri's brother, Ronnie.
So her mother's cars and her car.
That is correct.
And how long did you track these individuals?
I think there were different times for different vehicles. I don't recall the exact amount of time, but that'll be in the file that you have.
And did you turn over your reports on every single place they went for months to law enforcement?
Yes.
And you know that law enforcement is required to have a warrant to do that.
Well, they have to get a warrant, and I have to go through a different procedure that's prescribed by Utah law to appropriately place those devices.
Did you track anybody else's car in this case?
I want to say yes. Yes, I did.
Who else's?
There were some vehicles that I suspected that Carmen Lauber may be utilizing. But I discovered that, in fact, the vehicle that was parked at her house overnight on many occasions was being driven by someone else.
So you never gave that report to law enforcement?
I believe I did.
You gave the Carmen Lauber tracking report to law enforcement?
Yes, it wouldn't be named Carmen Lauber, though.
What would it be named?
Oh. I want to say there were a number of people that were associated with her residence.
That's all right. If it's
There was
someone
Nick Bon Savage. There was, and there was another young man who were frequenting that residence. And I believe that vehicle that I tracked from that residence was seen there overnight on multiple occasions. I really don't remember because the point of that was to track Carmen Lauber. And when I discovered that it wasn't Carmen driving the car, I removed the device.
Okay. Law enforcement was also providing you, I believe you said that Mr. Bloodworth asked you if you got information from law enforcement and you said no. Is that right?
No, that is not right.
Okay, please correct me.
Well, I would have discussions with law enforcement. I could garner an understanding. She's on the ropes in drug court is what it says.
Right.
She was on the ropes.
And in fact, what you argued was she would be very likely to be compliant at this point with law enforcement. Is that your words?
Yes.
All right. Also in here, you accused Kouri of lying about the name of her house cleaner.
Yes.
And the lie that you said Kouri told was that her house cleaner was her cute cleaner, Norma.
Yes.
In fact, didn't you, sir, finally confirm that Norma Garcia was her house cleaner?
I did later confirm that. Yes.
So when you sent this to police and said Kouri was lying, you were wrong.
I was wrong.
Okay.
But prior to Norma.
Kouri's shaking her head. Give him some more.
Very good.
Did law enforcement give you access to I'm going to try to use the right word, to folders where you could access their information on like a subfolder where you had a link to their folder?
No.
Did you provide them with links to your folder?
Yes.
And one of the links you provided them involved a download of Eric's phone. Is that right?
No.
Okay. Did it involve the decoded call logs that you talked about earlier where you figured out everybody's number and name?
I'm confused. You're talking about two separate things. You were just talking about Eric's phone.
You said no, right?
I had an identical copy of Eric's phone that I created from the backup on his Apple iCloud. I may have turned that over to them, but they already had Eric's phone. I didn't need to give them what I had done, which was to trick the Apple server into repopulating a blank iPhone so that I could then forensically examine that iPhone and come up with context from Eric's phone. So I may have given them that information that I created from a clone of Eric's phone.
So you had in your possession a clone or an exact copy of Eric Richins' phone.
It would not be an exact copy. Only the items that were unencrypted or decryptable from the Apple backup would be on the cloned phone. For example, encrypted data would not be present for biometrics, for his Apple Watch. If he was wearing a biometric watch, that is all encrypted. That would not come back to a new cloned phone. But all of the text messaging, the web histories, the call histories, all of that stuff will be present on that clone.
So you had access to all his texts?
I don't believe I did.
Why not? And this is maybe a stupid old lady question, but explain to me why you didn't have access to his texts if you downloaded everything off the
You
cloud.
said all of his texts.
Okay.
I don't believe I ever got all of his texts.
How far back did they go?
I don't recall the date at this time. I would have to refer to the file material to know the exact date of the first event on the phone.
So how much time did you spend reading through his texts?
Well, I don't recall exactly. I could refer back to some records to come up with an answer for you. It would have been a number of hours.
Hundreds of hours?
No,
Okay,
I mean, in this case,
right.
936.3 hours.
Is how many hours you billed total for the case?
Yep.
And what were you paid for that?
I don't know,
How much do you charge an hour?
$125 an hour. However, that is not the only billing rate in this case. When I used computer forensic software and my expertise in that regard, the rate would be higher. $200 an hour, I think, was the discounted rate that I gave them.
So I'm really bad at math. Please
Me
forgive
too.
me if I get this wrong.
Yeah, well, we're both in the same place.
We're talking about over $100,000 you made on this case.
I would say so, yes.
Okay. Now I want to go back to that phone and you reading his text.
Yes.
As you were culling through your hypotheses,
Yeah.
obviously one of the things you want to look at is the state of their marriage. Is that fair?
I mean, it's significant, but it's not dispositive.
I agree.
It's important context, but it's not evidence of anything, really. I see a lot of bad marriages out there. In my career, I've handled many hundreds of divorce cases. So, people have problems.
Did you review text messages between Eric and some of his friends?
Yes.
Did you review text messages between Eric and Bryce?
Bryce Knudsen?
Yes.
I don't recall specifically, but if they were there, I probably looked at them.
Okay. Your Honor, can I have just a moment?
This was sitting here.
He's something else. He's like, he a private investigator. He don't have to listen to no police. What is y'all talking about? You listen to his client telling him, yeah, he made over 100 grand. He up here like a boss. He handling this cross-examination. You don't know who she thinks she is, but she better get it together. Not Mr. Magoo. You talk about the smirking?
With Kouri?
I don't recall that.
Of course you don't. Well, I don't know about her doing this victim shaming, but all right. I guess they got to get in this information.
At some point, were you investigating cases that were being prosecuted in the Summit County area around the time that Eric died, where people were caught distributing fentanyl?
Yes.
Did you gather affidavits from cases where fentanyl was being sold in the Summit County area?
Yes.
And did you ever follow up on any of those investigations, or did you just stop by gathering the affidavits?
Well, they were plugged into the hypothesis testing matrix. I considered them for their proximity being in Summit County and for them involving fentanyl. In each of those cases, I found no relationship to this case.
Okay. I want to pull up TG2, Katie, just for this witness only. Sorry,
He
I'm
just
right about
takes
the
his
time.
long
I'm a little bit
time
longer,
with
Your Honor. I'm
hearing out
close
the
to them.
No
witnesses.
problem.
Sir, do you recognize that?
The jury, I mean. Sorry.
Is that what you were talking about with Mr. Bloodworth, which is the decoding where you looked at his call records and tried to figure out who he was calling?
It is the record that I referred to when I was talking about it on direct. I agree with that.
And Katie, could we go to the page for the date 2/14/2022 at 12:23 p.m.? It's a ways down. Just a moment, Your Honor.
Of course.
All right, sir, we've blown up a section. Does that refresh your memory about what you determined a call that was made on December 14th at,
Give me the date one more time.
I'm sorry, February 14th, thank you, Your Honor, at 12:25 p.m.?
Well, this is not a record that I created, but I recognize the format, and it appears to be that Eric Richins' phone had an incoming call at 12:25.
Can you look at the call right above that one?
This is an outgoing call from Eric Richins' phone on March the 9th of 2022. I'm sorry, February the 14th of 2022 at 12:23, 2 minutes before the first record that we talked about. And that is to a different number, 801-473-5058.
So as part of your investigation that you were doing on the mirror phone, you could at least identify a call that was made by Eric at 12:23 p.m. on February 14th, right?
I'm confused. We're looking at an invoice record from a carrier, and you're asking me about his phone. Those are two different things.
Did this invoice come from his phone?
No.
Billing records?
From his carrier, from Verizon.
Right.
That's not a record from his phone. That's a record from his carrier.
Understand.
Two different things.
So according to the bill from his carrier,
Yeah,
he made a call at 12:23 p.m. on February 14th.
correct.
Okay.
Objection, there's a 901 problem.
I'm done with it, Your Honor.
Hold on. You got to approach for a moment, if you would.
You mentioned you interviewed 45 to 50 people, somewhere around there, 40 to 50.
Yeah, it's an approximate number. I have no method of calculating that number. It's approximate based upon my memory.
Did you ever interview Kouri?
I did. I spoke to Kouri. She called me on January the 19th of 2023.
All right. And she voluntarily spoke to you
She called me.
and talked to you voluntarily?
She did. And I stopped her. I told her it would be inappropriate and unethical for me to continue the conversation outside the presence of her lawyer. I then texted her lawyer and had a phone call with her lawyer about the propriety of her client speaking without her presence.
Okay.
I then
So you-
requested that Kouri submit to an interview multiple times.
All right, stop.
Okay.
Don't reveal what anyone else said to you.
Okay.
The point is, Kouri called you to talk to you and tell you her side, right?
I don't know what her intentions were. She seemed very angry that I had contacted one of her business associates. I believe that was the reason she called me on that date.
And so you never to this day have sat down with Kouri and heard her version of what happened.
No, despite my repeated requests.
She called you.
And I was bound by the ethics not to talk to her outside the presence of her lawyer. She was a litigant. She sued my client.
Okay. And ultimately, as you were working with the trust, did you become aware that the trust filed a wrongful death suit against Kouri?
I am.
And are you aware they're seeking over $10 million in damages against Kouri Richins?
I didn't know that. It's irrelevant to me.
Okay, court's indulgence for just a moment, Your Honor.
Of course.
Just one moment. You found it? What's the date? Okay. I asked you whether you recalled seeing any texts with Eric about him and Kouri having an open relationship, and you said you could not recall. Is that right?
Correct.
Can you put that up on the screen, please? Do you recall looking at that text?
I do.
You've seen this one?
I believe I have. It's a joke.
It's a joke.
It is. It appears to me to be a joke.
Did you see the text around this text?
I did.
So you have reviewed the text between Eric and Bryce.
I don't know. I don't know that this is a text from Bryce. I have no idea. This does not identify Bryce.
So
Doesn't
now that
identify
now
anybody.
now that you have your memory refreshed, do you remember seeing this text between Eric and another individual saying that Kouri and I are starting an open relationship tonight? Right?
It says, Kouri and I are starting an open relationship tonight, so I told her I'm taking you home.
Right.
Yeah.
Okay. You left that out of your report.
No, this would be part of my report.
Did you see sexting between Bryce and Eric when you looked at their texts?
I don't recall that, no.
Katie?
And is this sexting? I don't know what you mean.
No, I'm not talking about this one. I'm talking
Okay.
about other ones.
All right. I don't recall. I'm talking about many hundreds of thousands of messages in this case. I can't recall them all.
Just a moment. Court's indulgence for just a moment. Can I show you this other text right here and see if this refreshes your memory? Do you remember seeing a whole bunch of emails like this or texts like this between Eric and Bryce?
Honestly, no, I don't remember. Like I say, there were hundreds of thousands of messages in this case. I don't remember even 1% of them. As I look at this, I mean, it just makes me laugh. It doesn't appear to be serious.
So how many of these joke sextings did you review that Eric did?
I don't understand this to be sexting. I think you're wrong about that. I resist your characterization. These are two friends joking with each other. That's what I'm reading here.
And they did that all the time?
I don't know.
Hundreds of times?
If I had the records, and then I could answer your question, but I don't remember all of these messages. And yeah, this is a joke.
Did you review all of the texts between Bryce and Eric?
I think at one time I would have gone through every single text message that was available to me on Eric's cloned phone. So do I recall it? Well, I mean, I recall that it was a bit mind-numbing. There was a lot there. Nothing particularly stuck out in my mind or memory about those messages.
Did they repeatedly talk about having sex acts together?
I don't recall.
Did they repeatedly talk about oral sex together?
I don't recall.
Did they talk about anal sex together?
Also don't recall.
But you read them all.
I'm sure that I did.
And it's all joking.
Knowing what I know about Bryce and Eric, yeah, that's how I interpret it.
So you do remember reading things of this nature and you interpreted it all as joking?
No, as I sit here today, I interpret it that way. I would have interpreted it that way back at my original reading of it. That doesn't mean I recall it. It means I have an opinion about what I thought then. That's different.
And what did you think then? They were joking?
No. What I think now is that this was a joke. I do not have a recollection of this at the time that I first read it, but if I had a recollection of that time, I'm sure it would be the same as it is today.
And if there were these tens of 20s of 50s of these types of emails, all of them would be jokes?
Sustained.
Yeah.
That's it. That's all I have, Your Honor.
Mr. Bloodworth, anything further?
He was up here blushing.
Yes, Your Honor, thank you. The text, they're a bunch of to-dos locker room talk from August of 2018.
That was my read of it, yes.
There wasn't any serious read that Eric Richins and Bryce Knudsen were engaged in some homosexual affair.
Zero.
In all of the text messages you reviewed, did you see any evidence of Eric using illicit street drugs?
No, I looked and I could not find.
You mentioned legal requirements for a licensed private investigator to place a GPS tracker on a car. What are those legal requirements?
So the statute governing that was adopted a few years ago. It requires that before placing the device, a licensed private investigator must identify the person or persons that are driving that vehicle and potentially the owner of that vehicle, and that they submit a request to query the protected persons database in the state of Utah for any record of those persons that are subject to the GPS tracking. That is designed to keep us from tracking people who have protective orders or temporary restraining orders or other lawful processes that define them as a protected person. We cannot track you in that circumstance. We do not have independent access to that database. So we must ask an agency of the state for a yay or nay. Is this person in the protected persons database? We have to do that before we place a device. We have to be certain that we are not tracking a protected person. So I submitted those requests to the appropriate counties of the jurisdictions where I placed these devices. The Summit County Sheriff's Office initially declined my request under the statute. I insisted. I finally got them to comply. I did the same with the Wasatch County Sheriff's Office, and they complied with my request.
Did you conduct your investigation entirely within the bounds of the law?
I believe I did.
Did you conduct your investigation entirely within the ethical bounds of private investigators and the attorneys you were working for in this case?
I believe that I did.
Thank you, sir.
Ms. Nestor, anything further for Mr. Gabler?
No, Your Honor.
May we release this witness?
Yes, sir.
Yes, sir.
Thank you for your time. Please step safely. You are free to go, sir.
Thank you.
That was hilarious. Like, I don't think that stuff no joke. You know, Bryce is the one that they was talking about. He always taking off his pants. Okay, so just for you guys,
It's an appropriate time to recess.
I am going to.
It is, Your Honor.
Ms. Nestor.
Watch my deliberation here. Yeah, I thought that his testimony was real good. I also thought the detective's testimony was pretty good too. I think it was this day.
A lot.
Well, Bailey was there.
Testimony
Like,
was pretty
and
good.
that's what I
So the judge is supposed to check in with the jury. I think about 4:30 Mountain Standard Time, which I believe is going to be like 5:30 their time.
Avoid the
And
boys
let us
being
know
home, so we waited
if
till
they
after they
are
went to
going
school.
how long they're going to deliberate. So we'll find out some more information very shortly. If they're going to continue to deliberate or they're coming back tomorrow.
When detectives executed that warrant, did they recover an orange notebook from a nightstand in the master bedroom on Kouri Richins' side of the bed?
Yes.
Scott Exhibit 2-66, please. You just scroll through that real quick.
Honor, can I speak to Mr. Bloodworth for a moment?
notebook.
Yes, it is.
Your Honor, the state moves to admit and publish 2-66R.
We renew all our previous objections that have been ruled on by the court already, Your Honor.
Understood. 2-66R is admitted and published.
Detective O'Driscoll detectives also execute a search warrant at the Willow Court home on November the 7th, 2024.
Yes.
Scott, Exhibit 2-65, please. Is this an accurate depiction of a document recovered from the kitchen cabinet of the home pursuant to that search warrant?
Yes, it is.
Your Honor, the state moves to admit and publish 2-65. No objection.
2-65 is admitted.
Did Kouri and Eric Richins exchange text messages regarding the Midway mansion?
Yes. I believe those were located on Eric's phone.
Scott, Exhibit 2-17D, please. Is this an accurate depiction of a January 5th, 2022 text exchange between Kouri and Eric Richins?
Yes, and the green bubbles are Eric and the blue bubbles are Miss Richins.
Your Honor, can we have just one moment, please? Just a moment, Your Honor. I'm so sorry. Thank you. That's okay, Your Honor. No objection at this time.
State moves to admit and publish 2-17D.
2-17D is admitted.
Scott 2-37D, please. Detective, is this an accurate depiction of a March 2nd, 2022 text message between Kouri and Eric Richins?
Yes, that's correct.
Your Honor, the state moves to admit and publish 2-37D.
No objection, Your Honor. Thank you.
2-37D is admitted.
I want to turn now to some other text messages. Scott 2-71R, please. Is this an accurate depiction of a May 24th, 2023 text message between Kouri Richins and her brother, DJ Kouri?
Yes, it is.
Your Honor, the state moves to admit and publish 2-71R.
No objection.
2-71R is admitted and published.
Thanks, Scott. Can I get 2-72R? Detective, is this an accurate depiction of a May 23rd, 2023 text exchange between Kouri Richins and her mother, Lisa Darden?
The date I'm seeing is May 31st.
Sorry, May 31st.
But yes, between Miss Richins and Lisa Darden.
Your Honor, the state moves to admit and publish 5-72R.
No objection.
5-72R is admitted.
Five or two? I'm sorry.
Sorry, two.
Two.
2-72R. Yes.
That's sorry about that.
Hey, Joseph, welcome in. Yeah, the jury is out currently deliberating. We just like looking at old testimony while they're back there deliberating. They are currently 2 hours and 13 minutes and 33 seconds. I believe we'll get an update in regards to the jury and what they're going to be doing in the next 20 minutes.
Detective, I'd like to turn now to some phone calls. Scott, can I get 2-76 and 2-76T?
One second, detective. The detective can see 2-76T.
Your Honor, 2-76 on the left side is an audio recording, so there's nothing to see.
Okay.
Is this an accurate transcription and audio recording of an August 22, 2023 phone call between Kouri Richins and Lisa Darden?
The transcript does represent that, yes. I don't have the audio recording, but the transcript is accurate.
Your Honor, the state moves to admit and publish 2-76 and 2-76T.
If we could just have the instruction on the other speaker.
Ladies and gentlemen, during this telephone conversation, you will hear the voice of Kouri Richins. You also hear the voice of people that are not Kouri Richins. You can consider and accept the statements made by Kouri Richins for their truth or for any purpose. The people that are not Kouri Richins, you cannot consider their statements for the truth of what they say. You can only consider their statements for the effect they had upon the listener, Kouri Richins. 2-76 and 2-76T are admitted.
Picked up the sandwiches from the diner. Are you asking me that? Yes. Oh, I did. I thought so. Okay, that's enough of that. Ronnie said, no. I said, Ronnie, yes. And there was something about a love letter put on the seat of his truck with the sandwiches. I said, I don't think so, Ronnie. I never heard that. I said, I believe they were eating in the office. Yeah, supposedly you put a love letter on the seat of his truck with the sandwiches. No. Yeah, exactly. In the office? Yeah. So it's just bullshit. Yeah. He became deathly ill. Oh, Bailey was there. Like, and that's what I put. Yep. That's what I put. God, they can come up with some wild shit. I told DJ, I was like, what do these people do? Just sit around a damn table and see who can come up with the craziest fucking stories. Well, you know, it makes sense to them. See what they're saying? I put a love note on a poisoned sandwich and put it in his car? What the hell? Yes. God, look like this psycho. Here's a poisoned sandwich I get for you. Here's a love note. On Valentine's Day. Like, what the fuck? Huh? On the seat of his truck is what it said. What in the hell? Oh my God, they are nuts. And they're gonna feel so stupid. And that's the thing, I feel like all of America, really. When people get up to actually testify and say, no, that is a lie, that did not happen. I was there. You can't compete with somebody who was actually there on your belief. Right. You know, so I'm just like, you know, and the stupid part is the freaking detectives, so just all those idiots, they know this. When they were at my house, I told them this. But they're going to you have through anyway. And I almost wonder if they didn't tell the prosecutor. So they're saying it was on, they're saying just a few days later, Valentine's Day, Kouri made Eric a sandwich and placed it on the seat of his truck along with the supposed love note. Oh my gosh, what the hell?
And then the next question is, when Eric ate the sandwich, he immediately broke out in hives, had trouble breathing. He later told his friend he thought Kouri tried to poison him. It is so fucking sad that you would go to this lie. And Austin was right. I did go back and look where they do start with, I believe. Well, I'm going to have a whole bunch of I believe today when Rick calls me.
Well, exactly. And that's what I was like, well, you believe that I believe this.
Yes. Exactly.
Oh my gosh, they're ridiculous.
So Ronnie said, when are you calling him? And I said, I'm not. He's supposed to call me today. I said, and then I want my question answered. I believe. I'll show you, I believe. And he just sent me a text and asked me when I'm free today. But just sure as I say, go ahead and call. Ronnie's going to call back and we're not done.
Scott, can I please get 2-77 and 2-77T? Detective, is this an accurate depiction of a transcript of a second August 22nd, 2023 phone call between Kouri Richins and this time her brother, Ronnie, regarding Valentine's Day 2022?
Could Scott scroll through a couple of the pages just so I can verify?
Yeah.
Yes, it is.
Your Honor, the state moves to admit and publish 2-77 and 2-77T.
Same instruction, Your Honor, but no objection.
As with the last audio recording and transcript, you may consider Kouri Richins' half of this conversation for the truth of the matter. You may not consider the statements made by people that are not Kouri Richins for the truth of the matter of what they say. You may only consider those people's statements for the effect they had upon Kouri Richins as the listener. The 2-77 and 2-77T are admitted.
Eric a sandwich and put a love note on it. The sandwich was poison.
Oh my God, I know. Like, no, the fuck, that did not happen. I was like, no, that didn't happen. Here's what happened. Nanny can testify. That's who fucking lived there. That's not what happened.
Yeah.
Like, that's not at all what happened. Where the fuck are you getting this bullshit?
Yeah, and like I even like have like my bank statement and stuff showing that I bought lunch at Mirror Lake. Like I didn't make any fucking.
Yeah, I know. I was like, no. These sandwiches are bought from a restaurant from a diner up the road. Receipts to prove it. This shit didn't happen. They're working in the office, and Nanny's there to testify that all of this is true, and everything they just said is complete horseshit.
Detective, are you familiar with what is known as the walk the dog letter?
Yes, I am.
Scott, exhibit 2-86R, please. If you could scroll through that for the detective.
Actual reading, I'm sorry, 86 R.
Detective, is this an accurate depiction of a 6-page letter to Lisa Darden written on either September 12th or 13th, 2023, that investigators recovered on September the 14th, 2023, from a book that was among Kouri Richins' personal possessions.
Pause for 1 moment.
Your Honor, I object. I think there needs to be a foundation laid of if whether or not it's to her mother.
Please approach.
Okay.
All right. Do you remember the question, Mr. Detective O'Driscoll?
I can ask it.
Okay, please.
Is this an accurate depiction of a 6-page letter to Lisa Darden written on either September the 12th or 13th, 2023, that investigators recovered on September the 14th, 2023, from a book that was among Kouri Richins' personal possessions?
This is that letter. It has redactions, but yes, this is that letter.
Your Honor, the state moves to admit and publish 2-86R.
Just renew the previous objections the court's already ruled upon.
Okay. 2-86R is admitted and published.
Detective O'Driscoll, can you please, starting at the top where it says page 1, read this letter aloud?
Page 1, walk the dog, but take vague notes so you remember. Here is what I'm thinking, but you have to talk to Ronnie. He would probably have to testify to this, but it's super short, not a lot to it. He will need to tell Sky at the meeting next week. Upon information and belief, just like they say, a year prior to Eric's death, Ronnie was over watching football one Sunday, and Eric and Ronnie were chatting about Eric's Mexico trips. Eric told Ronnie he gets pain pills and fentanyl from Mexico from the workers at the ranch. Not to tell me because I would get mad, because I always said he just gets high every night and won't help take care of the kids. There are pictures in my phone of Eric passed out on the floor or in the chair. Ronnie should have texts from Eric talking about getting high as well. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck, so I wouldn't find them. Ronnie never told me about the conversation. Eric finally told me and asked if Carmen could get him some. Eric never wanted anyone to know he had an issue, especially get caught. He always wanted Kouri to go down for him. When they traveled, Eric would put his drugs in Kouri's bag at the airlines right before they boarded. That way, if they were caught, Kouri got in trouble, not him. Once they got to wherever they were going, Eric would pull the drugs out of her bag and it would cause a huge fight. She was pissed he would risk her going to jail for his drug use. He just would laugh about it. Eric couldn't ruin his image that he had drug issues, so he would do whatever he had to. Kouri has never done any type of pills, didn't like them. Rarely would she consume THC, only if Eric begged her because it was a special occasion. Reword this however he needs to make the point, just include it all. The connection has to be made with Mexico and drugs. Ronnie will have the messages to prove Eric confided in him about getting high. It can be short and to the point, but has to be done. Upon information and belief, LOL. They never found pain pills or fentanyl in my house because he hid it in allergy bottle in work truck. And Cody emptied out work truck within a week, so they were never found. When you talk to Ronnie about this, meet up with him in person. I worry sometimes your house and phone are bugged. Maybe drive down to SL and meet him after work without Bree. Tell Ronnie don't overanalyze it. It was a quick 2-minute conversation, LOL. Tell him I need him to do this. Bring me home and then we will get those damn bitches. Also, please text Lotto or call. Tell him do not text me anything about us doing things together ever, like church, skiing, trips, nothing that puts us together. It doesn't look good. We're so close to the end. Let's push through. Have the conversation with Ronnie before he meets with Sky. Then tell him to tell Sky at the meeting about the conversation. Hang in there. We're almost there. Love you to the moon. Take vague notes of all this so you remember before you walk the dog.
Detective, does Sky in that letter refer to Sky Lazaro, Kouri Richins, former defense counsel?
Yes.
No further questions, Your Honor.
Ms. Nestor, please.
Thank you, Eric. Let's jump right back into that letter since we're on it, while it's fresh on our memory. It's Exhibit 286 for the record.
You want me to put it back up?
Yes, please, Your Honor.
There you go.
Thank you so much. All right, so this letter that you just read aloud, do you know the date that it was written?
I believe it was September either 12th or 13th.
Okay. And in this letter, the very beginning letter tells, I guess if it's her mother that she's addressing it to, if that's what you say, that to remind Ronnie to tell Sky this story, correct?
What part are you referencing?
The story about what Eric told him about getting fentanyl from Mexico.
There is a part that says tell Sky at the meeting next week.
Okay. So it looks like there's about to be a meeting with her lawyer, Sky, right?
I have no idea if that happened or if that was about to happen.
Okay.
It says at the meeting next week.
All right. So there's a meeting coming up with the lawyer, and Kouri is relaying something that Ronnie had known from the past, just in something that occurred between him and Eric in the past, right? When they were watching a football game.
Pause for a moment. Go ahead, Mr.
Objection, Your Honor. Foundation.
Sustained.
Okay, let's blow it up. We're going to get very particular. All right. A year prior to Eric's death, Ronnie was over watching football one Sunday, and then she tells a story about something that Eric allegedly told Ronnie, right? And just by the way, if you could go up just a little bit above that.
Wait for the answer.
Wait, before let me rephrase. Katie, if you could go back up to he will need to tell Sky at the meeting next week, just start right there and then highlight. And then thank you. I'll rephrase.
You're withdrawing that question.
Yes, sir, I am. So he's going to need to tell Sky next week about a year prior to his death, something Eric told Ronnie, allegedly, right? About his trips to Mexico.
Your Honor, there's no question there.
It ends in a question.
Thank you, Your Honor. Right?
It includes the word allegedly.
Yes. Right?
Hold on. Any other objection?
Your Honor, perhaps you could just re-ask it again.
Sure. One more time, Ms. Nestor.
In the letter, because you said you weren't sure, so we're looking right at the letter. In the letter, she says at a meeting with Sky next week, and she talks about Ronnie telling a story about a year prior to Eric's death, Ronnie being over watching football one Sunday and talking to him about his trips to Mexico, right?
That's what the document says.
Okay. As the chief investigator of this case, did you ever go to Ronnie and say, hey, did this happen?
I believe investigators reached out to Ronnie. I don't think it was me, but I believe one of the other investigators reached out to Ronnie for interview and were not able to talk to him.
So the answer is you were never able to confirm or deny with Ronnie whether this actually happened.
I was not.
Okay, let's go to the next page. Then she tells a story about Eric putting drugs in her bag at the airlines right before they board. You see that? Can you highlight it, please, Katie? Now that story has been verified by Allie Staking, her friend that testified before this jury, correct?
Objection, Your Honor, foundation.
Have you been sitting in this?
The objection's overruled.
Thank you, Your Honor. Is that right?
Could you rephrase the question?
That story about Eric putting drugs in Kouri's bag when they would travel and causing a fight was verified in this courtroom by Allie Staking under oath. Is that correct?
I listened to Ms. Staking's testimony. She told of one incident when that happened.
Okay.
This says Eric would, as if it happened multiple times, so I don't know. I just know what I heard Ms. Staking testify to.
Did you ever ask any of Kouri's friends or family if they knew of situations where it had happened before?
Where what had happened before?
Where Eric had put drugs in Kouri's luggage when they traveled?
I don't recall asking that specific question, but I think I heard about it coming up. I don't remember who the conversation was with, but I think I had heard something to this effect before.
Was it involving a trip to Mexico?
Not specifically, no.
Okay. Do you remember where the trip was involved?
I don't. Sorry.
So at least someone in your investigation did at least suggest that they knew of another situation besides Hawaii where Eric did this.
No, I don't know if it was a separate one or if they were referencing the same one. I don't know for sure.
All right. All right. If we could go to the bottom of highlight the bottom half for me. All right. There's references in here that Ronnie will have messages on his phone to prove Eric confided in him about getting high, right?
That's what this text says.
As the chief investigator of this case, did you ever go check Ronnie's phone to see if those existed to verify this?
I was made aware of this letter after May 8th.
Of 2023.
Of 2023.
Okay.
Like I said, I believe investigators reached out to Ronnie to talk to him in general about the case, and he denied letting us talk to him. So no, I was never able to confirm this with his cell phone.
So we sure have sat in this courtroom and listened to a lot of testimony about search warrants to seize phones. You know how to do that, right?
I do know how to do that.
Didn't issue a search warrant to get Ronnie's phone to see if that happens to be true.
No, but like I said, this information came to me well after May 8th, 2023.
Okay, sir, that's 3 years ago, right?
Yep.
And isn't it true you issued a search warrant as recently as 2 months ago to search the house for, I think, the 10th or 11th time, didn't you?
Yes.
Okay. All right, and then can we go to the very last little bit about they never found pain pills or fentanyl in my house? At the bottom? Yes, please. Thank you.
I can see that.
You can see it? Great. Okay. So again, this refers to the previous page where Eric allegedly told Ronnie that he kept his drugs in an allergy bottle in his work truck so that Kouri wouldn't find it, right?
Objection, Foundation. That's not what the previous page says.
We just go back to the previous page.
Sure.
We'll use the-
Absolutely. Katie, can you go back to the first page and find this section in there about where he kept his drugs? Let's see. Yep. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck so I wouldn't find them. Isn't that what that says?
The whole sentence says Eric told Ronnie he keeps them in an allergy pill bottle in his work truck so I wouldn't find them.
And by the way, this was seized September 14th of 2023, correct?
I believe so, yes.
And at that point, had you revealed to Kouri that you had found an empty hydrocodone bottle in Eric's nightstand the day of his death? Had you ever revealed that to her or her lawyer at this point?
I personally didn't find the bottle.
Okay.
It was located on the night of Eric's death and was transported with his body to the ME's office.
There's no way for Kouri to know that when she wrote this, right?
Objection, Your Honor. Speculation.
Sustain.
Okay, that's fair. All right, go back to what we were just talking about, to the bottom of the second page. All right. They never found pain pills or fentanyl in my house because Eric hid it in an allergy bottle in the work truck.